it to Pennsylvania, Your Honor. He is aware of this subpoena as well. And on June 6th, 2026, Mr. Roman retained counsel in Pennsylvania, Ms. Ariana McClellan, Your Honor. I have a letter from her I'll show you, which was sent to Mr. Stringham. I believe this is already filed for us, Your Honor, just so you have a copy. And Ms. McClellan, who's Mr. Roman's Pennsylvania counsel, she essentially reiterates most of the arguments that Mr. Smith has made in his response to our motion, arguing that it's not. What she actually says, Your Honor, is that one of the main issues, if you look at the second paragraph, she says, among other issues, the location was not Mr. Roman's regular place of business, and the person purportedly served, Al Manning, is not Mr. Roman's agent or otherwise authorized to accept service on his behalf. The issue is, Your Honor, that's not the standard under Pennsylvania law. We are allowed to serve someone at a usual place of business, a place that they exercise responsibility and control over, particularly when that person is some type of corporate lead or in charge in some way of the actual business itself. Moving on, Your Honor, they also state that the place served, again, was incorrect. The issue is, Your Honor, that's the publicly listed headquarters for the Middle East Forum. I believe that's also listed in the California Secretary of State's file, Your Honor. But a simple Google search will tell you that that is their publicly listed headquarters. They also further argue, Your Honor, that Pennsylvania has no jurisdiction over Mr. Roman. We're not really sure how that would be, Your Honor. And firstly, I'd like to show you the non-disclosure agreement Mr. Roman had with my clients. You'll notice, Your Honor, that this is signed in part by Gravitas Energy Solutions, of which Mr. Roman states he does journalistic business and activity through. And the address given for Gravitas Energy Solutions is 144 North Narberth Avenue, Pennsylvania, 19072. Now, that address, Your Honor, if we move on to the interrogatory responses provided in this case, now, Mr. Roman is not one of the Parker defendants, Your Honor, but I still submit this to you as evidence of Pennsylvania's jurisdiction over him. Your Honor, if you will turn with me, please, to page 5 of these interrogatory responses, Your Honor. Paragraph 19, Greg Roman is identified in these responses, and the address listed for Mr. Roman is 144 North Narberth Avenue, apartment 442, Narberth, Pennsylvania, zip code 19072. So he's signing contracts with a Pennsylvania address. In interrogatory responses that I assume he's provided an address for himself. He's identifying Pennsylvania as an address he can be contacted at. It's clear, Your Honor, he has some connection to Pennsylvania and they have some jurisdiction over him. Next, Your Honor, and frankly, Your Honor, those are the only 2 addresses we have for Mr. Roman. He's a difficult man to find, but we do know those 2 addresses, both of which are in Pennsylvania. Another argument made, Your Honor, in both the letter by Ms. Stringham and Mr. Smith is that Mr. Roman is in Israel. And so the courts of the United States, your court, the courts of Pennsylvania, they have no authority over him. The issue is, Your Honor, is he is frequently in the U.S. He actually was in Las Vegas yesterday, Your Honor. He was speaking at the Republican Jewish Club of Las Vegas. He spoke there from 6:30 to 8. I have a copy of that somewhere, Your Honor. I apologize again. These are out of order because I thought he'd be here. Secondly, Your Honor, he'll actually be in Washington, D.C. next week from May 19th to May 21st for a private event. You can actually have lunch with Mr. Roman for only $2,500 sponsorship, Your Honor. So on that note, Your Honor, and I have copies of that as well if you'd like. And then I also have too, Your Honor, a copy of the Nevada News. On Thursday, May 14th, Greg Roman will deliver a special Iran war update at the Republican Jewish Club's Las Vegas office near Rancho Drive and Interstate 95. Again, Your Honor, we view this as just a repeated attempt to dodge a subpoena. He's clearly in the U.S. frequently. I believe he was in Florida earlier this year. He's testified before the U.S. Congress. And as to his security concerns, Your Honor, I have no doubt, based on what I know about Mr. Roman, that the work he does is very secure and it's very sensitive. We do not dispute that at all. He seems to be involved in some very high-level things, both the United States and Israel. He seems to be very involved in the war on terror, particularly with what's going on in Iran right now. I'm aware that there is probably some security concerns that he has that are extremely valid. The issue is, though, Your Honor, is he won't even do a Zoom deposition. We've offered a Zoom deposition. We sent service of that to his attorney. We offered to do a Zoom deposition. We'll depose him virtually. We have no issue with that. We're happy to accommodate him. However, I'm sure there's some kind of Zoom security feature that only certain people can get on the Zoom. I have no interest in discussing with him his involvement with Israel, his involvement with the United States. All we want to ask him about is his involvement in this case with my defendants. That's all we want to know. We know they had an NDA. We know they had an agreement. They at one point had the same counsel, and now he won't sit for a deposition, Your Honor. And we have done everything we possibly can to try and find him, to try and serve him. He continues to dodge. We're not asking for sanctions. We're not asking for the productions of records right now. We just want to depose him. And we believe, unfortunately, that what we're seeing is a pattern of disregard and disrespect for this court and the court of Pennsylvania. He's not above the law. We've done everything to serve him properly. And so we'd ask, Your Honor, that your only remedy for this rule to show cause be to compel his testimony.
Anything?
Yes, Your Honor. Again, Taylor Smith here for Greg Roman. Your Honor, it's interesting that now we have a copy of this non-disclosure agreement on the record of this matter. If you note from it, you will see that in fact, what Mr. Roman has been doing this entire time is working on a documentary concerning me. And so please understand that in my representation of journalists, as the attorney for the South Carolina Press Association, on behalf of individual documentarians, Your Honor, like Mr. Roman, it is my common practice, as is the client's insistence, Your Honor, that they not be jeopardized by virtue of my representation. That means, Your Honor, unless I am authorized to accept service of documents by the client, I cannot. And in this case, Your Honor, at all times, including times when I was representing private investigation services group, on behalf of Mr. Roman or Gravitas Synergies Solutions, Your Honor, I was never authorized to accept service. I still am not as of this day. Your Honor, that stems from the same reasons you can now read in their own filings on this particular rule to show cause. Meaning, you can see now from this exhibit that they've now passed up that the desires even of his clients, my former clients, Your Honor, was that this would be maintained as a confidential relationship. That was for purposes of protecting Mr. Roman. And why does that need a protection, Your Honor? You can see his affidavit attached to our response, where he describes the security concerns he would have if he were forced to sit for a deposition. Your Honor, our statutes of this state protect the press as the first entity mentioned in the Bill of Rights through a statute that protects news media. That is a conditional privilege which may be overcome. Your Honor, you may recall that I did file on Mr. Roman's behalf a motion to quash a previous subpoena in this matter. And so that was because at that time, it was my understanding from my client that his bank, in that case, PNC Bank, had been served with process and that they were intending to comply with that subpoena. It was because that service was proper, Your Honor, that I then had standing as a non-party to come to the jurisdiction on behalf of that non-party and say, Your Honor, I respectfully ask that that particular subpoena be quashed. That is not this situation you're looking at right now, Your Honor. You can look at the documents they've handed up and there are defects on their face. For instance, in the context of what we have most recently received, this proto-notary application, There is no seal here. So even if this is a proper procedure under the Commonwealth of Pennsylvania, Your Honor, I'm not licensed there, I cannot opine on that there is not a seal on this, which means that even if the nature of the scope of this document as a legal instrument to comply with what the rules of this particular jurisdiction were, is to say, you, Greg Roman, at the address he mentioned, Your Honor, has to appear. Where is the court? I'm looking at the face of this document, and it says by the court, and it has a proto-notary. A quick look at the guidelines for proto-notaries in Pennsylvania seems to reveal, Your Honor, that it would still have to have the seal of the court to reflect this was actually a court-issued document. Your Honor, this does not have that. But frankly, Your Honor, it doesn't really matter. Because if you look at who it's directed to Greg Roman. It's not directed to the Middle Eastern Forum. Your Honor, if it were directed to the Middle Eastern Forum, let's assume for a second here you even grant them that assumption, even though the scope of this subpoena plainly does not apply to the Middle Eastern Forum, it applies to Greg Roman. That then would raise the question as to who this individual is that he has named, Your Honor, which purported to say, yes, that entity was served. That was the Al Manning he referenced, Your Honor. Mr. Al Manning then would have to be shown by this entity now, Private Investigating Services Group, to say that we served them at a particular time and found this person that he listed as his address. So then the question would be raised, who is Al Manning to the Middle Eastern Forum? Your Honor, in the context of their motion, they filed a colloquy with Mr. Roman's counsel up there in Pennsylvania. You can read it for yourself. The counsel has indicated that Anning does not have any ties to Middle Eastern Forum or to Greg Roman. And so at this moment, aside from the fact, Your Honor, that as they say, he had not lived in that jurisdiction for months when the service occurred, Your Honor, thus notice itself was probably not proper, nor could jurisdiction be, even if this was effective service. There also is nothing about how Al Manning, even today, in this proceeding, Your Honor, ties Al Manning to the Middle Eastern Forum. There are other defects, Your Honor, that I pointed out in our response from what they have attached. Your Honor, they seem to also be intimating that I am under a legal obligation at this moment to accept service on behalf of my client, but I've received no authority or no understanding under state law or Constitution that when on behalf of a non-party, you challenge a discovery device being sent to your client, that you somehow are going to the merits or to the defenses of a particular claim in that case. Consequently, Your Honor, when I did file, as Your Honor might be aware, a motion to reconsider Your Honor's previous ruling on that motion to quash, they say that by doing that, I now have to accept service of a deposition in Pennsylvania. So, Your Honor, I am not aware, I do not believe that authority exists. That I, for whatever reason now, by challenging those other orders as a non-party to this action, can force my client to then have to sit for a deposition, which I somehow am now on the hook because I am aware of them having provided. So at this moment, Your Honor, I'm sitting back then and I'm wondering to myself, what is it a lawyer would do in this situation? How would they protect their client's interests? And so I have no choice then, Your Honor, but to go for, as you're aware now, to the original jurisdiction of this state's Supreme Court to seek protections from Mr. Room. Your Honor, you can take judicial notice of that proceeding if you wish, but you don't have to because I've attached his affidavit here. The same thing applies. Even if this were effective service, and even if this were a deposition notice, Your Honor, which we would be haggling about right now, I would have come back to Your Honor and applied for relief from you to quash that subpoena for the same reason that we did before. That there was effective service, he had a legal duty to respond, and thus we asking your court relief from that legal duty. That is not what happened here. What happened here is that now we are being held for him to come to the United States of America to potentially sit for a deposition, which under the same substantive basis for the previous motions, Your Honor, that we filed in this action for the limited purpose of quashing subpoenas, is improper under state law as a newsgap. So, Your Honor, there are multiple defects with this rule to show cause. The one I'd like to come back to is the one that's a little bit confusing. I do not represent Max Fertati, Henry Rizal, Private Investigation Services. There arose a conflict, and me and my former law partner, Drew Radiker, had no choice but to be relieved as counsel. We and I filed documents, Your Honor, which you now have before you, and has been part of this action since last year, indicating that we had their consent, because they signed that document, indicating that I could be withdrawn. I made an error in that document, and now it's led to arguments even from them that I in some way represent them. They know that's not true. I have not represented Henry Rosado and Max Furtati since the moment they fired me. That was last year. And that was mere hours or day or two, Your Honor, before you see that thing filed right in front of me, and asking for my relief from this matter. I am not attorney of record. I am not seeking any sanctions against a current client of mine. I'm happy to answer any questions you have.
Sir.
I just want to say, Judge, first of all, we're not implying that Mr. Smith is engaging in any knowing wrongdoing at all. I have the utmost respect for him. We're just arguing he can't bring sanctions against our clients, who he still currently represents according to the public index, Your Honor. That's all we're saying. Secondly, Your Honor, as a journalistic shield, we've been through this. I'm not even sure if the condition precedent for journalistic shield even applies to Mr. Roman, Your Honor. He certainly is a commentator, but publishing a few articles that may be considered journalism, I would question if that's even the case. And again, Your Honor, it's not a carte blanche protection. You don't just say journalistic shield, I don't have to sit down through a deposition. If he wants to bring that up in the deposition for certain questions, that's okay. That's his right. If we feel as though he's dodging the question, we can come in here and argue a motion to compel. But he has to come and sit for the deposition, Your Honor. It's not a total wall that he just puts up and says, sorry, I'm a journalist. You can't depose me. I'm in Israel now. Sorry. All we want is his deposition. We've done everything we're supposed to do according to Pennsylvania law, Your Honor. The reason we served Mr. Smith, and I'm aware he can't accept service without his client accepting it. As a defense lawyer who primarily handles car accident cases, I'm very aware of the issue with getting your clients to accept service, Your Honor. But we did that as a courtesy to say, hey, he's saying the subpoena is improper in Pennsylvania. We don't think it is. Let's avoid going to court. Just get him to accept it. And he won't, Your Honor. So we served him at his place of business. Of course, they're saying Al Manning can't accept service on his behalf. I have no doubt that is their stance. But we served it to an individual who is at that location, who I assume Mr. Roman, as the director of the Middle East Forum, exercises control over. He exercises control and responsibility over the property. That's the standard. We would attempt to serve him at Gravitas Solutions, Your Honor, but their registered agent is in Wyoming. And not just the town, not just the street, Your Honor. The location for Mr. Roman's registered agent in Wyoming has 53,000 businesses registered there, Your Honor. And it's because of Wyoming's protections. And we understand, again, he has sensitive security information, completely understand. We did what we're supposed to do. We domesticated into Pennsylvania. We just want him to sit down for a deposition. That's it. We're not asking for sanctions. We're not asking for penalties. We believe you have the authority to compel him. We will then domesticate that order in Pennsylvania, and that'll be the end of that, Your Honor.
Okay.
Your Honor, if I might very briefly,
Sure.
I was not there in Pennsylvania. I'm not, like I said, licensed in Pennsylvania. I would just humbly urge Your Honor to read what they have filed in this action, which includes the colloquy between the counsel that they hired in Pennsylvania and Mr. Roman's counsel in Pennsylvania about precisely why all this service is in fact as defective as I tried to explain to Your Honor. It more appropriately describes this, Your Honor. And to the point regarding sanctions, Your Honor, it's the Rule 11 certifications that occur with these subpoenas. They were well aware by the time they attended the second service at that address, he was not in the United States of America and did not live there. Then they bring this rule to show cause today, Your Honor, certifying that as well, that there was proper service.
Thank you. Thank you, John.
Thank you, Judge. Appreciate it.
Yes, sir.
And Your Honor, may I ask if we may be relieved? May we be relieved?
Yes, you may leave. Council, let's move to the next matter.
Thank you, Your Honor. Morning, Your Honor. Becky Lindahl here on behalf of non-party Mandy Matney. We're here today on a contempt hearing following the issuance of a rule to show cause. And as a preliminary matter, Your Honor, we have an objection to the contempt hearing being heard today because it was based on a petition that was not accompanied by an affidavit or verification as is required under South Carolina law. Additionally, Your Honor, on late on Wednesday evening after the close of business, approximately 6:30, defendant Parker, the Parker defendants attempted to cure this fatal defect by filing an affidavit. And we moved to strike that affidavit as untimely. I also have some initial arguments to make about the supplement to the rule to show cause that Mr. Parker and the Parker defendants filed earlier this week. Your Honor, as we discussed in chambers, the way that we see the flow of the argument going today is that I will argue the objection, the motion to strike, and the issues related to the supplement. I also have some argument related to matters of law, where Your Honor could decide this purely as a matter of law without any evidence. After the Parker defendants have met their burden, we do have evidence to present on willfulness. And then I would like to argue again some legal matters with respect to the evidence that was put on today, that will be put on today. So on the objection, Your Honor, our objection is that the original petition to show cause and the supplement that was filed earlier this week, neither one was accompanied by an affidavit or verification. And just to give Your Honor, just to back up and do the timeline here, Ms. Matney was served with a subpoena in October. She objected timely and moved to quash based on the reporter's privilege and also on undue burden. We had a hearing on that objection and motion to quash back, I think it was the day before Thanksgiving. Her motion to quash was denied. We timely moved for reconsideration, which the Parker defendants note in their briefing this week is a right of a party to do, and not allowing a party to move to reconsider is inherently unfair. So Ms. Matney availed herself of the remedies available to her under the rules in South Carolina law and filed a motion to reconsider. That motion to reconsider was denied, and this court entered an order on March 16th saying that Ms. Matney shall be deposed within 14 days. That order did not set a specific deposition location, nor did it refer to any specific subpoena. On March 27th, and this will be put in through evidence on March 20th, assuming it's the Parker defendant's burden, but on March 27th, Ms. Matney appeared at a deposition location that she had given timely notice of, where she felt secure, and we'll talk about the security risks both in the evidence and in this argument. Parker defendant showed up at a different location and they refused to take her deposition. As set forth in our brief, the Parker counsel for the Parker defendants also refused to meet and confer any further about a compromised location and date. They then, on March 30th, March 31st, they filed a motion or a petition for a rule to show cause and for contempt. And the court set that for hearing on April 7th, 2026. The April 7th hearing was a show cause hearing. It was not a contempt hearing. And Your Honor was clear on that on the record, and that is attached to our response that we filed on Wednesday. It's on page 5 of our opposition. Footnote 3, Exhibit 2, Your Honor clearly states we're not here on contempt today. Your Honor issued the rule to show cause. Ms. Matney is here today pursuant to the rule to show cause. And this is the contempt hearing, Your Honor. So on the affidavit issue, there's three primary questions that the court needs to answer. One, is there an affidavit requirement under South Carolina law? In other words, are you required, if you bring a petition to show cause seeking contempt, must it be accompanied by an affidavit or a verification? The answer to that question is yes. The second question is, did Parker meet the requirement? The answer to that question is no. The third question is, did Ms. Matney waive her objection? And the answer to that question is also no. So we object to this proceeding moving forward at all today, Your Honor, because the petition is fatally flawed, and to hold Ms. Matney in contempt, which is what we're here on today, pursuant to an unsworn petition, would be reversible error. On the affidavit requirement, Your Honor, so we cited in our initial opposition, and then we also filed yesterday we filed a motion to strike the untimely affidavit that was filed on Wednesday night. We cited a number of cases that very plainly hold that a rule to show cause, a contempt motion based on a rule to show cause must be based on an affidavit or a verified petition. And the failure to include an affidavit or verified petition is a fatal defect. And that quote comes from State v. Kennerly, 331 SC 442, Court of Appeals 1998. It's also contained in that quote also is supported by Toyota Florence Inc. v. Lynch, 314 SC 257 from 1994. We've also cited Hornsby v. Hornsby, 187 SC 463, and that's a 1938 case that holds that for all contempt proceedings, other than for acts committed in the court's immediate presence, an affidavit is essential. All of those cases cite back to the first case to make that, include that holding, which is State v. Blackwell, 10 SC 35 from 1878. In the short response that was filed by the Parker defendants, they make an argument that the affidavit requirement is limited to family court, and that the affidavit requirement comes from Rule 14 of the family court rules, and it does not apply to the circuit court rules. Your Honor, that is simply not the case. And in the motion that we, the motion to strike that we filed yesterday, we included a number of cases that show that that argument is patently false. Parker does not acknowledge in that filing that two of the cases that Ms. Matney cites, the Toyota Florence case and Kennerly, are not family court cases at all. And even Hornsby is a family law case, but it does not refer to the family court rules. These cases that address that requirement are relying on circuit court appeals, not family court. And they're not based solely on Rule 14 of the family court rules. Parker argues that the affidavit requirement no longer exists, also because the South Carolina Rules of Civil Procedure were enacted in 1985, and the South Carolina Rules of Civil Procedure somehow supersede the well-established case law set forth, or the well-established rules set forth in State v. Blackwell. The issue there is that that requirement and Blackwell have been set out in appellate opinions multiple times since 1985. Toyota Florence is a 1994 case. Kennerly is a 1998 case. Miller v. Miller, 375 SC 443, that is a 2007 case. And Ferrara v. Hunt, this is a Westlaw site, Your Honor, but it's an unpublished opinion, 2015 Westlaw 475-7079 is a 2015 case. Not one of those cases relies on family court rules, and they were all decided after the enactment of the South Carolina Rules of Civil Procedure. So there's a statement in Parker's briefing that says the affidavit requirement, to the extent it still exists. There is no question, Your Honor, it still exists. A rule to show cause that is based on constructive contempt, which I don't think there's a dispute that this is, has to be supported by an affidavit or a verification. And just to pause on the constructive contempt, there are two types of contempt, as Your Honor is well aware. There's direct contempt that occurs in the presence of the court, the jury room, within this space, or related to an ongoing court proceeding within the court. But then there's constructive contempt, which is contempt that occurs outside of the presence of the court. And Ms. Matney is being accused of contempt for related to a deposition, which is necessarily constructive contempt. So the constructive contempt requirement of an affidavit is still alive and well. And it was not superseded by the rules of civil procedure being passed being adopted in 1985. So then the next question, Your Honor, is did they meet the requirement, the affidavit requirement? And they did not. Their petition was filed on March 31st. And in their filings, they seem to argue that because Ms. Matney has put affidavits in the record, that those affidavits save their unverified, fatally flawed petition. The problem with that, Your Honor, is that as of March 31st, the only affidavit that Ms. Matney had filed was back in November. So it could not have addressed the court's order, the court's March 16th order, and the subsequent events. Ms. Matney filed a second affidavit in connection with her opposition to the rule to show cause on April 6th. So that was not in the record as of the date they filed the petition. There was a hearing on April 7th. Ms. Matney was made to give testimony. They're relying on Ms. Matney's testimony to get around their fatal mistake. But that also was not in the record as of March 31st, the date that they filed the petition. And notably, I could not find a case, Your Honor, where a verification requirement was satisfied by the opposing party's testimony denying the violation. Ms. Matney's affidavit and Ms. Matney's testimony both denied the violation. So it doesn't save their fatal flaw. The other issue, though, Your Honor, is that the requirement, there's a requirement under Rule 6D of the South Carolina Rules of Civil Procedure that when a motion is to be supported by affidavit, the affidavit shall be served with the motion. Shall means mandatory. And South Carolina law provides no exception. In a case that Your Honor decided and that was affirmed, Lemons versus Macedonia Waterworks, Inc., 431 SC 186, Court of Appeals 2020. It includes the quote, use of words such as shall or must indicate the legislature's intent to enact a mandatory requirement. So 6D's use of shall means that the contemporaneous affidavit requirement cannot be cured after the petition is filed. Now, they make some arguments in their brief about substantial compliance. And the case that they rely on for that is State v. Nathans. And I can get the site for you, Your Honor. So State v. Nathans, also a very old case, which is interesting because they complain about Blackwell being too old to rely upon. But State v. Nathans was decided only less than 20 years after Blackwell. So State v. Nathans is 49 SC 199, 1897. And they use that case for the proposition that they can use Ms. Matney's own affidavits and her subsequent April 7th testimony at the show cause hearing to cure the fatal filing error that they made. But that's not what Nathan says. First of all, the filings in Nathan's were in the record when the contempt motion was filed, or the rule to show cause petition was filed and the contempt was heard. And they argue that that Nathan says you can substantially comply, and that they substantially complied by the fact that Ms. Matney, an opposing party, put an affidavit into the record and was made to testify. But the substantial compliance in Nathan's refers to the fact that instead of an affidavit, you could verify the pleading. It doesn't say in a later obtained sworn statement, you can cure a fatal filing defect. And Your Honor, notably, they have been on notice of this issue since April 6th. We filed an objection in our opposition to the rule to show cause. It's on the public index. It's included in the very first paragraph. It's included in paragraph 23, and it's included in paragraph 28. Nonetheless, despite having been on notice since April 6th, Parker waited, which is 37 days before Parker finally attempted to cure this fatal flaw. They did not file an affidavit until about 35 hours before this hearing that's been scheduled for at least 2 weeks. And to the extent they try to use other provisions of 6D to get around this, there is a provision in 6D that says that reply affidavits can be served at any time before the hearing, but this is not a reply. This is a jurisdictional requirement for the court to hear this contempt hearing. Nor can they rely on the 10-day motion notice period in Rule 6, because they only gave us less than 48 hours notice of this affidavit. So we do move to strike this affidavit as being filed too late, being irrelevant, being unfair and prejudicial to Ms. Matney because of how close it was filed to the hearing. And candidly, Your Honor, the fact that they filed it at all is an admission that they knew they had to once we pointed it out. With respect to the supplement, so they filed a supplement earlier this week, and the supplement includes a number of post-hearing, post-deposition allegations about things that Ms. Matney has said on her podcast or posted on social media. We object to those exhibits being used to examine Ms. Matney as well. The supplement is also unsworn. And that was filed after we had notified them on April 6th in our filing that they had made a mistake. And they still filed it unsworn. And they style it as a motion to supplement their show cause petition. But Your Honor, Ms. Matney has not had an opportunity to address that in a show cause hearing. She can't be made to sit at a contempt hearing and have material added on to the show cause that already occurred that was filed less than a week before this hearing. And let me just go through some of the exhibits that I presume they intend to use today. Exhibit B to their supplement includes Ms. Matney's social media posts. And as you know, Your Honor, Ms. Matney was deposed on April 8th in the Spartanburg County Courthouse. We were meant to stay overnight that night. None of us had clothes or our toiletries. We didn't have our medication. It was considerably expensive for Ms. Matney to stay over on short notice. We had to arrange childcare or pet care. It was, I think that alone is a suitable sanction. But those posts are dated. And incidentally, Your Honor, I think one of the reasons why it was held at the Spartanburg County Courthouse was because Your Honor wanted to be able to rule on objections as they came up. And we never had to summon you, Your Honor. Ms. Matney answered every question fully. The deposition was closed. It was not held open. She was not instructed not to answer other than on very limited privilege grounds. And we've gotten no follow-up since then about our objections. So in Exhibit B to their supplement, they include a number of social media posts. And if you look at them, they're dated April 16th, April 19th, April 20th, April 22nd, April 23rd, May 1st, May 2nd, May 11th. And then tab C is transcripts. It looks like they're screenshots from a podcast app of podcasts that Ms. Mandy published. Ms. Matney, sorry, it's Ms. Matney published. April 16th, April 21st, and May 5th. All of those materials that they attached to their supplement were published or said after the April 7th rule to show cause. Similar with, there's also some materials behind tab E that are dated from May, from this month. Those also cannot be considered on a contempt hearing today, because there's been no rule to show cause with respect to those materials. But even if there were, Your Honor, those materials relate to Ms. Matney's post-hearing, post-deposition speech after she had already complied with the order. She sat for a deposition. She has fully produced every responsive document that she could find. And we've put in her affidavit, and it really didn't come up at the rule to show cause, but she spent 8 hours looking for these materials. And those materials, they were looking for text messages from 2019, 2020, and 2021. And they asked for them in 2025. Of course, text messages don't live for that long. So she didn't have the materials anymore that they wanted, but she gave them everything that she had. So we would object to any of the post-hearing, post-deposition materials being considered in connection with a rule to show cause or with a contempt hearing today. We also cited in our brief the well-established principle that speech is not contempt. And we cite to the Bridges case from the United States Supreme Court that journalists cannot be punished for criticizing the judicial system or the players in the judicial system. Ms. Matney is not a party to this case. She's not a lawyer. She has a right to speak freely about her opinions about the judicial system, nor is she a party to any confidentiality orders in this case. Those are only, the confidentiality order is very explicitly limited to the parties and their counsel. And Ms. Matney is not a party. Your Honor, it's clear after reading their supplement, which is, I would describe it as mean-spirited. It's clear that the purpose of that supplement is to try to stack the deck and prejudice the court against Ms. Matney before this hearing. So we would ask that Your Honor not consider. So the next question is, did we waive? And no, we did not. We timely objected on the public index to the rule to show cause in paragraphs 1, 23, and 28 of Ms. Matney's opposition. We then objected again. We made it as clear as day. We objected in a separate document on May 13th, and we objected in our brief. And I think it's important to note, Your Honor, that the rule to show cause proceeding and the contempt proceeding are two separate proceedings. And the Parker bears the burden in both. And although we're not alleging that that contempt is limited to family court, the family court rules are instructive on this. And they note that the hearing procedure, and this is after the rule to show cause has been established, which it has here, that the moving party still has to satisfy the burden at the contempt hearing. So these are two separate proceedings. And that's highlighted by the fact, Your Honor, that a rule to show cause proceeding can proceed ex parte, like it did today with Mr. Roman. So the fact that Ms. Mandy was compelled to give testimony at that hearing did not waive the written objections that she made on the public index. And again, Your Honor was clear that it was not a contempt hearing. They cite the Nathan's case to say that, that Ms. Matney waived. I can't find another case that holds the same way. That by filing a written objection, but then being compelled to testify, waives an objection. And in fact, Nathan's finds, it includes in its ruling that there are multiple ways to raise issues with respect to a contempt hearing, including in a return or otherwise in a motion. And Ms. Matney's responses to the rule to show cause and the contempt petition were a return. I could also find no case since Nathan's that provides that a written objection on the public index is insufficient. Your Honor, that's my argument on contempt. I don't know if we want to pause there and give Parker an attempt to opportunity to respond, but it's our position, Your Honor, that the failure to include an affidavit is fatal, and it would be reversible error to proceed today. So we would ask this hearing conclude once the objection is sustained.
Okay,
May it please the court,
yes, ma'am.
Your Honor, Debbie Barbier for the Parker defendants. Your Honor, I'm going to be mindful of the court's time. I know that there are a number of witnesses that Ms. Matney wishes to call today, and so I'm going to be very brief. Your Honor, it's Parker defendant's position that Your Honor correctly issued a rule to show cause on the record before this court. The case law in South Carolina requires notice. Ms. Matney and her counsel had ample notice of a show cause. And she also had ample notice that an evidentiary record was being established in order to support the court's rule to show cause. In addition, Your Honor, on March 27th, well before we filed our rule to show cause petition, Ms. Lindell filed a status update. It was actually on the day that Ms. Matney was supposed to be deposed. She filed it before we filed our petition for the rule to show cause. And she acknowledged within that petition, in that status update, that Ms. Matney did not go to the location of the deposition and that the deposition did not go forward. And I think Your Honor is aware that those facts really are not in dispute. Not only did we have the status update that Ms. Lindell filed on the public index, she also filed on April 6th, prior to the evidentiary hearing, an affidavit of Ms. Matney. And Ms. Matney fully acknowledges in that affidavit that she did not attend the site where the deposition was noticed. So again, that's not in dispute. And then we have the April 7th hearing. And at the April 7th hearing, Your Honor, was clear that we were going to establish an evidentiary record in this case. Prior to that proceeding, Ms. Lindell did not object at that hearing. She did not say that that hearing should not go forward because there was a fatal defect in the Parker's defendant's motion for rule to show cause. And in fact, at that hearing, Ms. Matney, if you look at the record of the transcript on pages 51 and 52, Ms. Matney fully acknowledges she did not go to the location where the deposition was noticed. And so, Your Honor, the facts are largely undisputed on that. Ms. Matney failed to comply with the court order, and therefore your rule to show cause order was correctly issued. Your Honor was clear in the rule to show cause order that you relied on the pleadings, the affidavits, the testimony of Ms. Matney, and the arguments of counsel. There is no requirement under South Carolina case law that our original motion had to be filed with a petition or an affidavit or verification. That's covered by Rule 11, as your honor knows. All pleadings, since the South Carolina Rules of Civil Procedure were adopted, have to be filed pursuant to Rule 11 in good faith that the council, verifies that these facts are true and accurate to the best of their knowledge. And that, of course, was done. So, your honor, in response to their objection that came a few days ago on the eve of this hearing, the Parker defendants filed a brief verification verifying the initial motion for rule to show cause and then the supplemental information that was provided. We're only here today, as your honor knows, to decide whether her non-compliance was willful and what the appropriate penalty for that is. So, your honor, it's our position that the affidavit that was filed by the Parker defendants, this week was unnecessary, but was done to appease any concerns that counsel for Ms. Matney has that our information in those in that motion or the supplement was not verified. And as I said, your honor, Ms. Lindell didn't object until a few days ago and didn't object to the hearing going forward on April 7th. So it's our position that if there were a valid objection, she has waived it. She didn't just have Ms. Matney testify during that hearing, and we called her to the stand. She also presented a witness at that hearing. So she fully participated in that hearing, and therefore she has waived any argument that she might have had. But there's absolutely, your honor, no fatal defect in the Parker defendants' motion for rule to show cause. We rely, your honor, on the case law and the briefs that we've submitted to the court. We rely on the civil rules of procedure in South Carolina and the evidentiary record that's before the court. However, your honor, I'll say that if your honor wants to reopen the order that was issued on the rule to show cause and wants counsel to resubmit the original motion, the supplement, and the verification, we're happy to do that. And if Ms. Matney wants to come back in 14 days and have another hearing, we can do that too. I think that is probably a colossal waste of this court's time and resources because, as I said, it is largely undisputed that she did not show up for the notice location of the deposition. And today's hearing really is only to decide whether or not that non-compliance with this court's order was willful or whether she had some mitigation or valid excuse for it. And I'll be happy to answer any questions of your honor, but that would be the argument of the Parker defendants on that issue.
Have none.
Thank you.
Okay, anyone else? Okay. Next matter.
Your honor, as we discussed in chambers, I am going to give an argument on one issue that your honor can decide as a matter of law. And then I will give a preview of what we will be putting on in our case once the Parker defendants have met their burden. But we included in our brief that someone cannot be in contempt of an order that does not clearly state what they're supposed to do. And the order that your honor signed simply says, Ms. Matney shall be deposed no later than 14 days from the entry of this order. It doesn't refer to the subpoena other than in a caption. And it doesn't say Ms. Matney shall appear at a particular date, at a particular time, at a particular place. It just says Parker shall depose her. Ms. Matney, with respect to the subpoena, it was reasonable. The fact that the parties were negotiating with respect to the date and the time highlights that that order did not clearly say these are the specific requirements that Ms. Matney must meet in order to be in compliance with the order with respect to when and where she should appear. And that's also highlighted, and this is in our brief and attached as Exhibit 11, but before Your Honor entered your March 16th order, the Parker defendants sent over a stipulation about Ms. Matney's deposition that indicated that Ms. Matney would appear for her deposition at a location, and this is a quote, "to be determined by the parties." And then there were brackets that said Bluffton or Maynard Nexon's office in Columbia. So it was always contemplated that the parties were going to agree on a location. And Your Honor's order did not set a specific location. So that order was not sufficiently clear to put Ms. Matney on notice that she had to do exactly what Parker wanted her to do, exactly when they wanted her to do it. And she showed up for a deposition, ready, willing, and able, half a mile away from the Parker defendants at 9 a.m. on March 27th. The Parker defendants, who the order says will depose Ms. Matney within 14 days, elected not to. But on the face of the order, Ms. Matney was not ordered to appear at a specific time or to comply with a specific subpoena. And Your Honor can decide that issue as a matter of law, that the order was not sufficiently specific for Ms. Matney to be held in contempt of it. Your Honor, we again, a couple other just issues that are partly evidentiary and partially legal. We will put on evidence today that there's no indication that Ms. Matney's violation was willful and that she attempted to comply. And that she had reasonable concern for her peers. We also will, I've also already discussed that the post-hearing, post-deposition conduct that's included in the supplement cannot form the basis for contempt. And, Ms. Barbier did not address the issue of the fact that the supplement was also not verified. So the supplement at a minimum cannot form the basis of contempt. And we would ask that none of the materials in the supplement or attached to the supplement be considered at all. And I provided some additional reasons for that as well. I also want to address just briefly, Your Honor, that there were some statements in the supplement related to Ms. Matney's supporters being in the courtroom. And I will note, Your Honor, that she does have supporters in the courtroom, but this is an open courtroom. It's a hallmark of the American legal system that our courts are open, barring extraordinary circumstances. The supporters who are here are not disrupting anything. There's no jury. So the fact that there are supporters here for Ms. Matney should absolutely not be held against her.
Let me interrupt you right there and tell everyone here you're welcome in my courtroom anytime, including today.
Thank you, Your Honor. With respect to the preview of the evidence, once the plaintiff's, once Parker's made his prima facie case, we will put on some witnesses to show that Ms. Matney attempted to comply in good faith and that she was in reasonable fear. We'll put on evidence of why the reasonable fear existed and how that affects the willfulness. To the extent that we get to remedies, Your Honor, we also are intending to argue that there's nothing to purge because she has complied. She was deposed on April 8th. She gave a full day of testimony, most of which was completely irrelevant to this case. She was asked questions about her media company. She was asked questions about her journalism with respect to Alec Murdoch. She was asked questions about her impressions of what other third-party witnesses think about things, like her collaborator, Ms. Farrell. She was asked about compensation, not specific compensation, but she was asked about how she derives her compensation and how she came to be the executive producer of a scripted series about Alec Murdoch. She's also produced documents, and there's been absolutely no follow-up. We included in our brief, and I'm not going to reiterate them here, but we included in our brief some sites as to why a non-party, which again, Ms. Matney is, she did not invite herself to this party. She got hauled in. But a non-party does not have the same obligations under Rule 26E as parties do. Nor did Ms. Matney have any obligation to preserve documents because she didn't know she was a part of this case until 2025. But she's done everything that she can. We also will argue, Your Honor, that Parker did not comply with Rule 45 by minimizing the burden on Ms. Matney. He refused to take into account her very real, subjective fears. He spent an entire day asking her about irrelevant evidence, which the courts have found is an undue burden. They also have not even tendered her the Rule 45 witness fee or her mileage. She was made to stay in Spartanburg overnight without notice, without her medicine, and at considerable cost. To the extent Your Honor is inclined to award damages or a fine, they have to be limited to Mr. Parker's actual loss. He was going to take this deposition no matter what. Prepping for the deposition is not related to any breach of a court order. And those costs have to be reasonable. At the depositions of this matter, and I'll argue this in more detail after the evidence has concluded, Parker has frequently sent 4 partner level attorneys for a non-party witness who does not know anything about what they're seeking. And we know that they were using this overnight stay in Spartanburg as a free trip on Ms. Matney, because everyone in the courtroom could hear them talking about the steak dinner they were going to have in Spartanburg and laughing and joking that it was on Mandy. So Ms. Matney has already borne substantial costs. So we would ask when we get to that point in the hearing that any compensation be limited to the cost that she's already incurred, both to hire her own counsel, to argue these motions, and to stay overnight in Spartanburg. Thank you, Your Honor.
Thank you.
Your Honor, just briefly, the only matter that I'll address that she addressed is with respect to the matter of law that she indicates. This matter could be dismissed on. Counsel for Ms. Matney, as you know, there's 2 lawyers that are here for Ms. Matney. They're both experienced and both knowledgeable about the law. They understand the force and effect of a subpoena. They understand the force and effect of a court order. And Your Honor's order was not ambiguous. Every subpoena that's been issued since October of 2025 has had the same address and the same location that the deposition was going to take place at. And so, Your Honor, is our position that that was not complicated. There was nothing defective about your order. Both Ms. Matney and her lawyers knew where she was supposed to be on the date of the deposition, and they failed to show up. It's just not complicated. With respect to a lot of the other matters that Ms. Lindahl has raised, we had anticipated making some closing remarks after the witnesses are presented, and I'll save that for them. Thank you, Your Honor.
Thank you. As to the matter of law, it's about where she was supposed to be. The court finds there is no error there. She knew where she was supposed to be, and in the testimony, sworn testimony, she knew where she was supposed to be, and but she was not there. And a subpoena is a court order. Whether or not I specifically put it in my order does not matter. Knew where she was supposed to be. Counsel. Call somebody, anything?
No, sir, Judge. I think it's our understanding that at this point, our position is a contempt involves, was the conduct willful? Was there any excuse, or was there some other basis for which she chose not to show up, which can include financial interest, strategic interest, or things of that nature? We'll wait and see what witnesses that Ms. Matney's attorneys put up, and we'll cross-examine them as necessary. Thank you.
Okay. Yes, ma'am.
Your Honor, the moving party bears the burden in a contempt motion. And then Ms. Matney is entitled to put on evidence in her defense. And I'm not aware of any case law that says they can rely entirely on the rule to show cause hearing.
Okay, do you put the transcript in from the April 7th hearing?
Judge, by reference, we incorporate the transcript from the April 7th hearing and the filings subsequent to that and prior to that as the basis for holding her in contempt, including your order and the subpoena that had been submitted in this case a long time ago. Let me just state for the record too, that we have admissions by Ms. Matney under her affidavit and in her testimony and from her counsel that she was not there, she was aware, and she physically had the ability to comply with the order. Thank you.
Okay. Any objection to the transcript and the affidavit?
Your Honor, the objection is that Your Honor was very clear that it wasn't a contempt hearing, and so we do object to the transcript being the sole basis of the Parker defendants putting on their prima facie case of the contempt motion on which they bear the burden.
Okay, your objection is overruled. The transcript and the affidavits certainly can come into any particular case whatsoever.
Your Honor, just to be clear for the record, I'll have this marked as our Exhibit 1 and Exhibit 2. This will be the transcript from the hearing before Your Honor on April 7th, 2024, and then the affidavit of Ms. Matney that was filed April 6th of 2026.
Okay.
Your Honor, before we put on any evidence, could we just take a brief comfort break?
Sure. We can take,
5 minutes?
yeah, let's take about 15 minutes. How about that?
Thank you, Your Honor.
To allow our witnesses to appear electronically via WebEx. And I would ask that court address that motion at this point.
You want to be heard on that?
Your Honor, just briefly, we do not believe that the rules of civil procedure have been followed as it relates to subpoenaing the witnesses or for getting permission from the court to have them appear electronically. Furthermore, we don't consent to having witnesses appear electronically. You have the problem with swearing them in by oath. You also have the problem of cross-examining from a distance with documents. And so we object, but that's all we have to add.
Yes, sir. I declined to sign that motion or to grant that motion previously. By not signing that order. And I refer back to the Supreme Court order. Yeah, I think it's been amended and updated as of February of 2025, and I have it back there if anybody needs a copy of it.
Thank you, Your Honor. In light of that, I would ask that we be allowed to proffer what our expert would have testified to.
Okay. You can proffer the witness's testimony. Yes.
Your Honor, our expert witness was Laura Richards, who is a preeminent world-renowned expert on stalking and harassment. She was a former investigator. She actually assisted in developing the DASH protocol that has been adopted by law enforcement worldwide in determining threats regarding domestic partner violence. She has a very successful podcast. She has been a witness, an expert witness on harassment, social media harassment, and coercive control numerous times. She was prepared to testify about the effects of ongoing harassment on a victim, as well as had reviewed a lot of social media postings and communications in regard to Ms. Matney, and had developed an opinion that Ms. Matney's fear regarding attendance at the location selected by the defendant Parkers was valid, sound, and reasonable to not be able to comply.
That's what her testimony would be?
Yes, Your Honor.
Okay, anything from the defense?
Your Honor, we would renew our objection to an expert who was not noticed. We have no prior indication of their conclusion or opinion or on what they based that upon. For example, if she was going to form a conclusion and testify that about the effects of the ongoing harassment on Ms. Matney and that her fear was in attendance was valid and reasonable, I would have wanted to question her on her qualifications to make that statement. Does she have mental health training? Is she licensed? Is she a physician, a psychiatrist? What are her qualifications to make such a conclusion? So we would have probably moved to exclude her on that basis. I don't know anything about her or what her qualifications are, but that certainly would have been an issue. If Mrs. Matney's mental state would, is going to be put at issue or would be put at issue through this witness, there are steps and procedures, as the court is well aware, under Rule 35, when a witness or a party's mental state is at issue, and the rules regarding examinations of that to be done and ordered by the court. And we would have asked for that in response to it. So I'm just, based on their proffer, not exactly sure where these opinions or conclusions would go or what they exactly would be and what they based it upon, whether or not they've reviewed all her medical records, et cetera. So I will just say that we would object to court considering any proffer of this testimony and stand by the court's ruling that remote testimony of a witness like this is improper.
Anything further?
Yeah, just to note again, Ms. Matney is not a party to this case, and her ability to conduct discovery, long periods, including interrogatories and depositions, and all other tools available to named parties and cases are not available to her in this matter.
Okay. Yes, ma'am.
All right, I call Mandy Matney.
I'm up and be sworn now.
Ms. Matney, would you step up here for me? If you will place your left hand on the Bible and raise your right hand, do you swear affirm, I'm sorry. Or do you swear affirm the testimony you give the court to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, and please be seated.
Ma'am, please tell us your name on the record and spell your last name, please, and ensure that microphone is adjusted for you. Can you see that?
My name is Mandy Matney, Matney.
Thank you. Yes, ma'am.
Thank you. Hey, how's it going?
Oh,
All right, we have already in prior testimony established your background, your training and experience as a reporter, and most of the facts around this issue, correct?
yes.
So I'm going to skip forward a little bit for sake of efficiency. How did you first meet defense attorney Debbie Barbier?
I never met her per se, but I became aware of her when she started representing Corey Fleming, which is Alex Murdoch's best friend, who we were exposing in the Murdoch Murders podcast, which was the #1 podcast based on my journalism. And that would be a few years ago, 2022 or 2022, I believe, is when I first became aware of her name.
How about Parker's defense attorney, Mark Moore?
Mark Moore, I believe I first became aware of his name also through the Murdoch case that I've been covering since 2019. He represented the banker, Mark Moore represented Alex Murdoch's banker, one of the only co-conspirators who was sentenced along with Corey in that case. And that's how I became aware of him. Russell Levy, is his name.
Have you ever met Greg Parker?
No,
Are you aware of a interview Mr. Parker gave to Valerie Bauerlein in 2022?
yes.
How did you become aware of this?
Your Honor, I'm gonna object. I don't know how this is relevant to the contempt proceeding that we're here for today.
Counsel?
Reasonable fear and ability to attend. This is a very complicated and ongoing issue that has been ongoing for years. So it is relevant. Mr. Parker is a defendant, and there are statements from party opponent contained within these articles.
Statements, Your Honor, I would ask the court, statements related to Ms. Matney's contempt of court? I'm unclear as to what this goes to.
Let's give her a little leeway. Go ahead.
So you're aware of this article that was published in the Wall Street Journal?
Yes.
All right, I am showing you what has been marked as Matney Exhibit 1. Did you read this online initially?
Yes.
Permission to approach? I have highlighted certain things. Do you recognize what I'm handing to you?
Yes.
What is it?
Is this the Wall Street Journal article?
Is it a fair and accurate depiction of what you saw online with the Wall Street Journal article?
Yes.
And did Mr. Parker give any quotes in this article?
Yes.
What did he say?
So it says, Mr. Parker said he hired people he described as investigative journalists because he was shocked of the incestuousness of South Carolina legal system, including the scope of the Murdoch's family influence. Quote, when I look back on this investigation, do I think, oh gosh, I wish I hadn't done that? Mr. Parker said, absolutely not. I am proud of the work we did. When asked whether he conducted a stealth investigation and specifically what it entailed, Mr. Parker paused and said, here's a better question. So what? Of course I did. Anybody in my situation would have done the exact same thing.
I move Matney Exhibit 1 into evidence.
Any objection?
No objection, Your Honor. I'll just keep an ongoing objection as to relevance.
Okay, and without objection, it's submitted.
When did you start receiving mean comments online?
Soon after I launched the Murdoch Murders podcast in June of 2021.
What was the general tenor of these comments?
A lot of sexist comments, a lot of people that really hated me, a lot of people making fun of me and threatening messages of veiled threats. I got a lot of that, but mostly I just suddenly became, when the podcast went from 0 to a million and we got several million viewers in less than a month, I believe. I just became aware of how much hate there was toward me in the world, and that made me very scared for my life and my safety.
Your Honor, I wish to ask Ms. Matney about several exhibits that were entered in the public filings, namely the objection in brief and opposition for the motion of contempt. I have a bound version of them for the court, if Your Honor would like it for ease of use. As far as entering, I would ask that you take judicial notice for it. If you'd rather, I will tear out the sheets and enter them as individually identified pages.
Have you shown opposing counsel?
Yes, Your Honor, they're all part of the publicly filed.
I'm not exactly sure what exhibit she's talking about or what references she's making.
Show them to her real quick.
No objection, Your Honor.
Okay,
As far as entering, Your Honor, how would you like me to handle that?
you want to make that number 2?
Perfect. Mandy, in January 2022, did you have any messages regarding, your physical appearance?
Yes. It, from my memory, which the I've been through a lot since then, but from my memory, January 2022 was when it got really bad. The online threats got so bad, and that's when I had to go on medication. I started seeing a therapist. I started really worrying about my mental health because of the online threats that I was getting and the things that people were saying to me.
All right, I am showing you what has been labeled for identification as Matney number 2 in the filings from May 13th. The harassment exhibits, it is identified as Matt 007. Do you recognize what I'm showing you?
Yes.
Is it a fair and accurate description of
Yes.
the message that we were previously talking about?
Yes.
Would you mind reading to the court what the message is?
So it is from somebody named Michael Matney, and that would be my brother who died when I was 7 and he was 9. Died very suddenly, the most horrible thing to ever happen in my life. That I've been very open about through my podcast and through my presence on social media, I talk about it all the time still to this day. And it says that it's from a Michael Matney, and then the email says, as a joke, it's from Matney@fitsnews.com. And the message says, "Goddamn girl, the camera adds 75 pounds to your fat ass on that 2020 commercial." So that would be me. That would be somebody posing as my dead brother from childhood, fat shaming me, to be clear.
And what's the date of that communication?
January 10th, 2022.
We move Matney Exhibit 2 into evidence.
No objection.
Without objection.
Was that the only hurtful communication you received at that time?
No.
Have you received threats to your safety?
Yes.
This is Matt 0013. I am showing you what's been labeled for identification is Matney 3. Do you recognize this?
Yes.
What is it?
It's a tweet that somebody sent me in August of 2022. It was right after I wrote a really big article about Parker's. I can't remember what the article was exactly. It was from an account that was just made on the same day that I created this account. Or this account was made on the same day that I published the article. I thought that was weird. But this account that came out of nowhere tweeted me, "You must have one hell of a vest."
How do you interpret that?
You must have, as a threat to my safety and a bulletproof vest is what I took that, and I contacted I contacted SLED at that time, and he said, and my contact at SLED said, you should be worried about that. What are you doing to protect yourself? He was aware of not only this, but other things that I was getting at that time. And a lot of people around me in my life were extremely worried for my safety. And that was just one of many threats that I was receiving.
And what was the date on that?
August 4th, 2022.
All right, I would move Matney Exhibit 3 into evidence.
Yeah, Judge.
Are you familiar with someone by the name Valerie Hallery?
Yes,
How do you know her?
I do not know her. I know that she has an account online that has posted horrific messages about myself, about my co-host Liz Farrell, about my husband. I remember the first time I saw a message from her, it was graphic and horrifying, and I didn't even tell anyone. I just blocked immediately because it freaked me out and I didn't want it to be real.
I am showing opposing counsel what's been labeled as Matney 4 for identification. And in the same attachment, the filing, it is Matt 0019. Do you recognize this?
Yes,
What is it?
I believe this is an email or a Facebook post, any different Facebook post. It says Valerie Hallery, this woman or this person, and this is another thing that has made me very concerned about my safety. Most of these people do not use their real names behind these accounts that they are saying these horrible threats about who they're threatening me from. And it becomes a situation where I'm afraid of every room that I enter because I don't know who these people are, what they look like. So this Valerie Hallery, to be clear, this is November 29th, 2025. It's me, Mandy. Why do they control you? Mandy, do you want me to read it?
Yes, please.
Mandy, could you just get a clue? Could you just get a clue like there's more to life than being famous, integrity, basic respect, being true? Tell me what it's like to write a story than rewriting his story. Because that Hulu show was so damn focused that it didn't even reflect the podcast. I wish the world would understand your hate for Paul and your tamper. Sure. Oh, and disminiated sled script. Our mass brain damage from episode 1, trying to frame Alec Murdoch. So I want you to know what it looks like talking about. I'd like you to know what a face to do so I can understand a bitch that sold her soul. Tell me you're a soulless sellout. Yeah. You don't do anything. Yeah, you do anything just to fit in. Congratulations. You're a piece and a puzzle and you fit into a noose.
I would move Matney Exhibit 4 into evidence.
No objection.
Without objection.
I am showing opposing counsel what has been identified as Matt 0020.
Your Honor, yeah, I have no objection as long as the dates on the holidays. No objection.
Is that 5?
This is 5, yes, Your Honor. I am handing you exhibit 5. Do you recognize this?
This is from December 14th, 2025. It was on the date of my brother's, the date of the anniversary of my brother's death, and I posted a picture of the two of us as little children, just in memory of him, and someone commented from our rotten or sewer side. Again, I don't know who this person is, and I believe the profile looked fake. Saying the wrong Matney died.
I would move Matney exhibit 5 into evidence.
That's without objection.
Objection.
Did these comments stop at the end of 2025?
No,
I am showing opposing counsel, has been identified as Matt 0022, and for identification, Matt 6.
No objection.
Without objection.
You recognize this?
yes,
What is it?
it's an email to Lunashark Media from what looks like a fake account. Do you want me to read it?
Yes.
It says Stephen Smith was murdered, but they won't find who did it. His mother is making money from his death and should be grateful. I hate this word, a faggot son helped her live a better life off blood money. Why are you wasting so much time on a useless, I'm sorry, faggot? Stop defaming the Murdoch family, SLED, and other government officials. You say you're so scared living on Hilton Head. Maybe stop causing trouble. You are wrecking the lives of other people living.
And what was the date on that?
That date was March 17th, 2026.
Okay, so within 10 days before your scheduled deposition.
Yeah.
I would move in Matney exhibit 5 into evidence.
That's
Six.
6.
6, sorry.
Yeah, she's already said no objection.
On that exhibit 6, can you turn the page?
Yes.
Is there's something printed on that page?
Yes, it's another Facebook post that I saw from April 20th, 2026. To be clear, Liz, it says, referring to my co-host and friend. They could have had a loaded gun in front of Mandy Matney, pressed the barrel to the back of her head, had it on one trigger, pull away from vacating her skull and embedding pellets in the top of her shoulder. And Alex Murdoch's courtroom is still more apparently criminal than what Mandy Matney endured. I personally know that Mandy deserves everything she has coming. It is insane to be all up in the middle of it and letting it tighten around your necks, referring to the news that she talked about before. I believe. How many times do you think I had to know right from wrong for myself, since not only was nobody looking, they weren't even able to see Liz?
Are you familiar with Jim Seidel?
Yes.
How did you make first contact?
Somewhat, I've never made contact with him, to be clear. Someone in 2023 sent me a video of him declaring Alex Murdoch was innocent, but I couldn't even open the video because he had blocked me already. And I thought that that was really weird. I'd never heard of this man or anything. And then pretty soon after, he started making more videos.
And I'm sorry, I need you to go back. If you could look at exhibit 5, it's the back of exhibit 5. identified as Matt 0021 for the board's reference. What is this?
This is another Valerie Hallery, who we still have not figured out who this person is, to be clear, song post. Or
What date?
on Facebook. It's from Christmas Eve of 2025.
And what merry well wishes was Valerie Hallery wishing you?
Mandy's hanging high in the gallows. She lied to the whole world, no recourse. Want to knock her daylights out now. Make it right. Yeah. Shouldn't even know her name. No, we ain't friends. I think she's making a song. I want to see her on trial for conspiring with law enforcement, framing, I don't know who, L. McMurdoch. You want me to read the rest of the part? Okay. Go sit your ass down, framed. Alec Murdoch, go sit your ass down. Call him Big Daddy when you sit your, and I'm sorry, I'm cursing, but that's what it says. Sit your ass down. Girl with the episodes, sit your ass down. Girl, you fucked up. Sit your ass down. Framed Alec Murdoch, go sit your ass down. Call him Big Daddy when you sit your ass down. Girl with the episode, sit your ass down. I know they can't stand it. Apparent done. Landed churches are appropriate and we're gonna get it. Y'all understand it. Tell me what in the world happened to Paul. Look.
Going back to Mr. Seidel, do you know what he does for work?
I'm confused of how he makes his money, so I don't actually know, but I do know that he posts on TikTok and Facebook. I don't know if he has an Instagram. I think he got kicked off of YouTube at some point, so I don't know if he has a YouTube, but he creates content about true crime,
And do you know anything about Mr. Seidel's background?
I know that he is a felon. I know that he pled guilty to lying to federal investigators for, I believe it was PPP fraud. I believe that he was a volleyball coach, and I've gotten a lot of messages about his time as a volleyball coach, but I'm aware that he was, I believe, removed from several positions, and he bounced around different girls volleyball coaches because of different accusations about him.
Does he currently report on cases that you also report on?
Yes.
And has he written any books?
As an actual author, I have a hard time saying that. I'm sorry, but that he wrote any books, because it's very easy to tell what is AI and what isn't AI, and the vast majority of all of his writing is AI written. And so yes, he has published books that I believe are written by AI that he says are written by him.
Was one regarding his belief that Alec Murdoch was innocent of the murders?
Yes.
Is another one regarding Stephen Smith's murder?
Yes.
Have you ever become aware of a post regarding you specifically?
Yes.
Do you recall when that was?
In the last 6 months, I want to say, he started to get very, to target me specifically within the last 6 months or a year. And it just kept increasing. I want to say it really started ramping up rapidly around the time that this case was ramping up and the subpoenas were ramping up. With just constant every day. Again, he blocked me, so I can't see his posts, but every day I get messages from people. It felt like every day, people screenshotting his post and saying, I'm scared for you. This man is obsessively posting about you. He hates you. I am scared for you. This man is unhinged. Getting a lot of that.
Okay. Did it ever come to your attention that let's go a little bit into the timeline first. I apologize. I am showing opposing counsel what's been labeled for identification is Matney number 7. It is a certified copy of James Seidel's indictment and plea agreement and criminal conviction.
No objection.
No objection.
I would move what has been labeled as Matney 7 into evidence as a self-authenticating document.
Yes, ma'am.
Quite the pile. At any point, did you feel like you were done with the Murdoch case?
No.
Did it lessen at some point?
I mean, lesson, yes, but it never went away. And the people that were constantly coming after me like that in that pile, really never let up. There were times when it would ramp up or times that it would go down, but I never felt free from it. And I always felt like my life was forever changed. I'm still on antidepressants because of it. I still have a hard time driving because of it. I still have a hard time doing things I used to do in my everyday life that I can't do anymore because of this case.
You had previously discussed the Hulu show in which you were a executive producer.
Yes,
And that is about the Murdoch case, correct?
yes,
And were you ever made aware of Mr. Seidel contacting Hulu?
yes, I was. I believe it was in November, around the time Greg Parker was subpoenaing Lunashark premium members, and we were getting very weirded out by everything going on in this case. What was the question again? Sorry.
If you became aware of him contacting Hulu?
Yes, I do, because my husband was very concerned. We got an email from a higher up person at Hulu that said, what is this about? And it was a defamatory email saying basically that I am a fraud and that it was a shame that the Hulu was working with me and it absolutely interfering with our work. And we had to explain, we had to send Hulu this man's conviction and say this is what he does. He's a fraudster and he's been after me hard in the last few years, especially.
I am showing opposing counsel what has been labeled for identification is Matney 8 and Matney 9.
No objection.
I am showing you Matney 8. Do you recognize this?
Yes.
What is it?
It says, Mandy Matney calls crime and cask report cruel lie.
And what's the date on that?
October 17th, 2025. That would be 2 days after the Hulu show came out.
I would move exhibit 8 into evidence.
Without objection.
Can you look at exhibit 9?
Yes.
Do you recognize this?
Yes,
What is it?
it is. I hate going to this website. It is, and I don't do it. Jim Seidel's website called Crime and Cask Investigations. And it's advertising his book at the top. A notice to watch your words wisely on social media from the article from November of 2025. And then right next to it, there's an advertisement for some sort of weapon, which is great.
I would move exhibit 9 into evidence.
It's without objection previously.
I am showing opposing counsel what has been labeled with identification is Matney 10.
Objection.
Without objection.
I would move in Matney 10 without objection. Do you recognize this?
I believe so, yes.
What is it?
Inside, it is an article from Jim Seidel. Inside the expanding legal, and the headline is Inside the Expanding Legal Assaults Targeting Attorney Mark Tensley.
And what's the date on that?
November 18th, 2025.
I am showing counsel what has been marked as Matney 11 for identification.
No objection.
I would move Matney 11 into evidence.
It's without objection.
Do you recognize this?
Yes.
What is it?
It is a Jim Seidel article, saying Mandy Matney sued for defamation, November 12th, 2025. And I want to be clear, this was a kind of misstated in the last hearing, but I've been sued by defamation by the same person twice, and I was, the first time it was dismissed. I want to be clear about that.
Who was the author of that article?
Jim Seidel.
I am showing opposing counsel what's been labeled for identification as Matney 11.
No objection.
I move Matney 11 into evidence.
Okay, I thought that was 11. Was this 10 or 11?
I'm
This
sorry,
is
this,
11, 12.
this will be 12. I apologize, Your Honor.
Okay,
I'm going off my memory, which is never a wise decision. I move exhibit 12 into evidence.
without objection.
Thank you.
Do you recognize this?
Yes.
What is it?
It is a Jim Seidel article that says what happens when a witness lies under oath.
And what's the date on that?
November 19th, 2025.
I am showing opposing counsel what has been marked for identification is Matney 13.
Objection.
I move Matney exhibit 13 into evidence.
Without objection.
Do you recognize this?
Yes.
What is it?
It is an article from Jim Seidel on Crime and Cast Network that says text messages from Liz Farrell and Mandy Matney reveal stark contradictions from what they say publicly, with a advertisement of a weapon right next to it.
And what was the date on that?
That would be November 25th, 2025.
So that's right around when we had our first motion to quash hearing, correct?
Exactly. It was right around Thanksgiving when there was a lot of articles where I felt like I was a target of this man for some reason, right around the time that the motion to quash hearing was about to happen for my deposition.
It references some text messages. And have you been provided a copy of these text messages?
No.
Do you know what text messages they're talking about?
I believe, so when this article came out, I can't really remember the timeline, but I remember being shocked and horrified. confused for the most part of how somebody could obtain my work text messages with my colleague Liz Farrell, specifically from the times when we were discussing very sensitive matters about the Murdoch murders, that those text messages had been obtained. And when I looked at the text messages, I noticed it was actually text messages from a group chat that we had with a colleague of ours that who we no longer work with or speak with, and her name is Jen Wood.
Give us a little more context. I know that, you know about the text messages. Did you ever have an employee named Callie Lyons?
Yes, briefly.
And, did she work with you?
Yes, she was a researcher for the Murdoch Murders podcast, Lunashark Media, from around the time when Russell's first trial was, so November 2022, I want to say, to July-ish of 2023, so not very long. And I never met her in person or anything.
Do you remember how much you paid her?
I don't.
Where did she go to work after she worked for you?
Fitz News, which was my former employer that I quit like a year before.
Did y'all ever work at Fix News together?
No.
Did, is she currently in the employment of Fix News?
No,
And, when you're with Fitz News, were you supplied a, phone?
no,
Were you supplied a laptop?
yes,
Were you allowed to keep your laptop when you went?
no,
Have you ever given Callie Lyons, permission or access to your prior messages?
absolutely not.
To make sure I'm clear on the timeline, how many text messages were released in November 2025?
Well, we found through this website, which I found was shocking, that there were thousands released, and then later find that this former employee of ours was paid by Parker's to obtain those text messages that were a work product between journalists.
And so you discovered this in November 2025?
In November 2025, we knew that the text messages had just been obtained. We were just shocked and didn't know how.
Were they current text messages?
No.
What time frame were the text messages referenced?
Old from 2022. I believe that was the only year, and we stopped talking to Jen when we left Fitz News, so. And that's when that stopped. That's when the text messages stopped in there, so there was thousands of text messages.
When did you leave Fitz News?
August of 2022?
Okay, so when these were released in October 2025, did you have any access to them in the intervening 3 years?
No,
Have you ever been provided a copy of these text messages in full?
no,
Has Parker's defendant ever given you the metadata or background on these text messages?
no,
Have you ever had the ability to sit down and analyze them?
no,
When you were deposed on April 8th, were you shown any of these alleged text messages?
yes, it was a big part of my deposition.
Were they text messages between you and others?
Yes, between, I believe, and like, I've deleted those texts since then, since it was 2022, so I had no way of verifying. But I believe they were between myself, Liz Farrell, and Jen Wood.
But again, you have never been provided anything to authenticate or analyze.
I'm gonna object. This is going far afield from contempt. I don't understand the relevance.
Yes, move along, please.
Let's get to February. The motion to quash was, denied at that point, correct?
Yes,
And then you filed a motion to reconsider?
Yes.
Why did you do that?
Well, at that point, and I want to talk briefly more about the text messages because it felt like a threat when these text messages were being posted online and at the same time that they were trying to depose me. It felt like it felt like people were trying to destroy my reputation with these text messages, and many of them that were posted on this website were mislabeled as text between, like I was not in a lot of the text messages that he got, but he mislabeled and said that they were all Liz and my text, like especially the bad ones. He said they were between Liz and I, and that wasn't true. It was other texts between Jen Wood. They looked like text between Jen Wood and Will Hawks. And so it appeared to be products obtained through this lawsuit to specifically defame me and intimidate me as they were trying to depose me.
Hunter, I have a bunch more of these prime and past articles directed at Ms. Matney. I would ask and see if opposing counsel would stipulate to us mass entering them to just expedite the process.
I'm happy to take a look quickly and agree to do that. I don't think we'll have any objection to that.
Okay.
I am showing. I'm making sure I have the numbers down. It has been labeled for identification as Matney 14 through 17.
Your Honor, I don't really have any objection. I would say that a note for the court that these have no relevance to contempt. I mean, there's an article here about Mr. Bland being reported to ODC, Sandy Smith talking about a sled agent, and, you know, Liz Farrell's article, but I mean, it doesn't have anything to do with contempt, but I have no objection.
What's it have to do with the contempt? Is it?
Your Honor, there has been a weaponized, strategized campaign against Ms. Matney and her co-producers to create fear and intimidation. And this again goes directly to the willfulness of disobeying.
Okay, she has no objection. They're admitted.
I'm now showing opposing counsel what's been labeled for identification is Matney 18 and 19. Ms. Matney, I have gotten the things out of order. I am showing you what has been, I would move to enter Matney 14 through 17.
And that's without objection.
Would you mind reading the headlines and the date on those?
Yes. December 9th, 2025, and the article says Sandy Smith, you've told me more than any sled agent. And that's a quote from her, and that's an article where, and I remember this, Sandy Smith is the mother of Stephen Smith, who I met in 2019 through my reporting. She's in the courtroom right now. I really became close with her and really, she's become like a second mom to me throughout the last few years. And people who know me and want to hurt me use Sandy, unfortunately and disgustingly, as a way to attack me. So that I wanted to provide that context. And this is a secret phone call that he apparently recorded with Sandy, and just mischaracterizing her and the investigation.
All right, what about exhibit 15?
It says ODC opens investigation into attorney Eric Bland. Eric Bland is my co-host on Cup of Justice. He's also in the courtroom supporting me today. In this article is about one of, I believe, 13, 14, or 15 complaints that this single person, Jim Seidel, has made about my co-host, Eric Bland, in the last few months. And just for the record, Eric has never represented Jim Seidel, has never met him. And that again came off as a threat to not only a threat to, it was threatening, it was clear that it was a threat to anyone who supports me. They will be dealing with ODC complaints like Eric is dealing with right now.
How about exhibit 16?
The Liz Farrell article that didn't survive the record, and that is from December 16th, 2025.
All right, is that the last one that we haven't talked about?
There's in this one is text and emails raise questions about preferential, I can't say that word, media access.
What's the date on that one?
And that is January 22nd. Again, this beating drum that they are just releasing and private text messages between journalists, threatening to reveal our sources, threatening to defame us, and from communications gained in this lawsuit. And that was very, very concerning to me.
No objection. Yeah. Yeah. I move, Matney exhibit 20, 21, 22, 23, and 24 into evidence.
Without objection.
Exhibit 20, what is that?
It's another article on Jim Seidel's site about me, saying, is Mandy Matney a public truth warrior or narrative strategist? And it has a photo of text messages. I remember this article because I wasn't a part of those text messages, and that was defamatory. And yeah.
Right, what about, the next exhibit?
Another one, Apple iPhone security questions about claims of stolen text messages. And that's about my private text messages that somehow made their way into evidence to this guy and in this case.
What is the date on that?
The date is March 12th, 2026.
On, just to make sure I'm not confusing all these different papers, because there's a lot. On exhibit Matney, 18, has that been entered?
No,
Defense counsel's already looked at it. I am also showing defense counsel Matney 25.
No objection.
I move Matney exhibit 18 and 25 into evidence.
So without objection.
Exhibit 18, what is that?
says Mandy Matney is ready to go to jail rather than be deposed.
What's the date on that?
February 6th, 2026.
Exhibit 25, what's that?
Mandy Matney from I'd rather go to jail to fighting over the room size about this case. And that's a Crime and Cast article from March 26th, 2026.
I am showing opposing counsel what's been labeled Matney 26 for identification and Matney 27.
Your Honor, no objection, but I would again say these have no relevance to contempt and they have no connection to brokers. They're news articles about Ms. Matney.
Again, what's the reference to these?
Your Honor, this is showing a repeated strategic time, intensifying pressure on Ms. Matney, culminating around the dates of the deposition.
Okay, we're getting close to being really redundant though, I understand.
Each one's, independent, Your Honor, and you have posted.
Your Honor, I would also note that there is no foundation to connect any of these news articles to Mr. Parker. And there's no evidence to suggest that because none exists. So I would say they're continuously highly irrelevant and it's wasting the court's time.
Put them in, but she didn't object to it. Let's move along.
I move Matney 26, 27, and 28 into evidence. On exhibit 26, what is that?
It's another article that says exclusive inside the gag order war of Beach v. Parker and a crime and cast card.
And what's the date of that one?
December 3rd, 2025.
Great. What about the next exhibit?
It's May 7th, 2025, why attorneys are seeking depositions of journalists and podcasters in beach case dispute.
All right, and the next exhibit?
It's a title from Jim Seidel of Crime and Cast that says that Mandy Matney staying in the sunlight or running from it.
These articles, are they fair and balanced in your opinion?
No,
What makes them not fair and balanced in your opinion?
they don't reflect the truth of the situation. And that's what journalists are supposed to do. We are supposed to find the truth and report on it. And this is not journalism. It's AI generated propaganda.
Is there an ongoing theme in these articles?
What's the question again?
Is there an ongoing theme in these articles?
They are pro Greg Parker and against me and anybody who supports me.
Going to the week of the deposition. We had various motions filed, correct?
Yes.
And, so are we in exhibit 29?
Yes.
Were there filings regarding the, request for the court to determine location?
Yes.
What day was that? Do you remember?
I'm not sure. It was I just remember this is where everything relevant. Those posts get really weird and were increasing that week. And I was really worried, again, not just because of the things that he has specifically posted, but because of the amount of hate I've received in the last 5 years. And I don't know, I don't trust a lot of people. And it just became extremely anxious and worried about this deposition and what they wanted to do. And so we filed a emergency motion a few days before, just, and then from my understanding and from of the court system, most other lawyers who want a deposition out of a person want to make them feel comfortable. And I thought that Parker's attorneys would want me to feel comfortable and safe at my deposition. And the fact that they clearly did not made me terrified for my safety, to be completely honest.
I'm showing opposing counsel Matney 29. Was there a point where you began to suspect something weird about crime and cast articles in the timing of court filings?
Yes, it was very clear that he had knowledge of things going on within the court case that were not in the public index.
I would move Matney 29 into evidence.
I'm sorry, excuse me.
I'm moving what's been marked as Matney 29 into evidence.
Your Honor, if she's using that exhibit to testify that it's very clear to her that the author, who's not here, of this news article had information outside the public index, I would say there's no foundation for that because there's no basis for it because no evidence exists of that. So I'm gonna have to start objecting to the admission of all these news articles that have nothing to do with Parker's and nothing to do with contempt.
What you got?
What I have is a news article. The 70-page motion in opposition of determining location for subpoena filed by Parker's attorney hits the public index, which is the only time this court knows the lawyers and the public actually get to see the filings. It hit the public index around, I want to say it was 2:30. And this article, which is quite in-depth, quite long, and quite critical of Ms. Matney's positions on the subpoena, was posted within 30 minutes of the file hitting the public index.
Your Honor, the deposition has been litigated since October of 2025. And Ms. Matney herself just testified that she believes these articles were written with AI. I'm not sure why she's.
I said that.
Hang on, man. Hang on.
That has allegedly been written with AI. But again, I go back to, these articles have zero connection to Parker's and zero connection to the issue that's before you today on contempt.
No, I'm gonna sustain the objection. That's not coming in.
Who's Sarah Glass?
She is a supporter of Lunashark Media. And I knew of her because she would support me on Twitter, specifically when I would get really horrible threats. And she would message me and try to find out who the person behind them are.
Do you know she was deposed in this case?
Yes,
And are you aware of any post by Mr. Seidel regarding that?
yes.
All right, we're moving on from the articles. I am showing what has been previously filed, again, in our harassment exhibits identified as MAT 66. Andy, I'm sorry, what number am I on?
29. And well, the last one was 29 that you didn't get to 30.
Your Honor, we are bumping up against that thumb drive issue. I don't know if you want me to address this and then we take it, or
Let us see what you have.
Yeah, I haven't seen you see it. Your Honor, I'm gonna have to object. This has no relevance to Parker's, it has no relevance to contempt, it has no relevance to the deposition.
it has relevance to the mental state, intent, and willful disregard of a court order, Your Honor.
No, I'm not gonna allow that. I sustain the objection.
I am showing defense counsel what has been labeled for identification as Matney 31.
Again, Your Honor, I object. It has no relevance to Parker.
Permission to approach, Your Honor?
Yes, ma'am.
Please note the date and the timing.
You object?
I do.
Okay, I'm not, this is staying, it's not coming in.
I am showing Parker's defense counsel what has been labeled for identification as Matney 32.
Same objection, Your Honor. No relevance to Parker's, no relevance to contempt.
Your Honor, I believe extensively in the last hearing, Ms. Matney's reasonable fear and impression was at issue, and these multiple social media posts increasing in frequency as the deposition gets closer are very relevant to her state of mind and her reasonable belief.
Over objection, I'm gonna allow 32, 32.
I move exhibit 32 into evidence.
Over objection.
Mandy, do you recognize this?
Yes.
What is it?
It is a March 3rd, 2026 Crime and Cask TikTok post, I believe, referencing Sunlight People, which my podcast is called True Sunlight. When sunlight people, it says, when sunlight people tried to destroy you, but you're working with God. And then on the back, there's a post, a picture of Parker's kitchen and a link to an article about judge orders beach key evidence in a major win for Parker.
I am showing opposing counsel what's been labeled for identification as mapping 33, which is map 0075, and Matney 34, which is map 0077.
Your Honor, the proposed exhibit 34 are pictures of Will Folks and David Moses wearing hats and who wore it better. I have no idea why that's relevant here. Proposed exhibit 33 is a post that says when the Hilton Head trolls keep trying their lame old tricks. I don't know what that has to do with anything we're here to talk about today. So I object.
Yes, ma'am.
Again, Your Honor, it goes to the state of mind and the willfulness of the witness in disobeying the court order. Mr. Moses is Ms. Matney's husband, and again, it's Mr. Seidel attacking someone close and personal to her. Then Matney 33 regarding the Hilton Head trolls, that is again approaching the subpoena date and where Ms. Matney lives.
They are overly broad. In 33, 34 are not, are are not coming in. Sustained. Was there a 35 or did I misunderstand?
I think that was 33, 34. I think that was 33 and 34.
Okay.
So the next one is 35. Let's get to March 27th. Did you think showing up at my office meant you were not available?
No,
What did you think was going to happen the morning of March 27th?
I thought that if Parker's attorneys wanted me to feel safe for my deposition, and I thought that any lawyer who truthfully wants a deposition out of anyone would want that they would show up to your office to get my deposition.
How are you feeling that morning?
Nervous,
Why?
stressed out. This has just been very extremely taxing on my husband and I. And again, and this is just a fraction of the social media hate and threats that I get online and my husband sees every day. To be summoned to a deposition for people that were making it very clear that they did not care about my safety. And people that I had believed and had reason to believe that they were in communication with the man who was making me feel the most unsafe and had threatened to show up at my deposition. I was feeling not okay. I was feeling worried. I was feeling knots in my stomach. Just disgusted by all of this and really wishing that the legal process cared more about my safety. Because I just did not feel safe. And I felt safe at your office, but
How long have you known me?
since 2021,
Are we just attorney, client relationship?
no,
How would you characterize our relationship?
you're my friend. We go on vacation together. I love your husband. He's amazing. You're a really good friend.
So did that add to your comfort at choosing your counsel's office for the deposition?
Absolutely, because we have discussed our threats to our safety at dinner with you and your husband so many times over the last few years. You've known more than most people of what I've gone through and why I had the right to feel scared on that morning, and you were taking it very seriously. You and David went out of your way to hire security and to have me go through a plan as to what happens if this man shows up, to show me the entry and exit of the building. You took my safety extremely seriously, and that's why I wanted it there.
Great. I am showing opposing counsel what has been labeled for identification as Matney exhibits 35 through 40.
Your Honor, I object for the same reasons. They have no connection to Parker, nothing to do with this hearing. They're irrelevant.
Can I see him?
Certainly, Your Honor. They show, again, escalating, very personal threats meant to mentally stress and intimidate Ms. Matney. And it was again, a lead up of this pressure to the deposition date.
Your Honor, I would just also note that none of those exhibits contain threats. And we're getting to the point of, I would say, cumulative as well. I'll base my objection on that.
That's the whole point here. It is cumulative because it was coming from all sides.
The objection is sustained. They're not coming in.
Permission to approach her.
Sure.
I just need to get what number they were.
35, 340. Let's just see the name just real quick. There you go.
It's also about a minute.
This time, the 60 minutes will reconvene at 2:15. 2:15. Let everybody get a chance to refresh themselves and get some lunch. Ma'am, you may leave the stand. You cannot talk to a single soul about your testimony. You understand?
Yes. A threat. I took it as he was communicating with Parker's counsel about my time, the time of my deposition. And he also posted a welcome to Bluffton sign, I believe that day or the night before, which to me indicated that he had knowledge of the time and place of my deposition. And I also want to be very clear to the court, he had threatened to show up at my deposition, and we'll show that.
I would move what's been labeled Matney 41 into evidence.
No, that's sustained.
I am showing opposing counsel a post from March 27th, 2026 at 11:37 a.m. Marked for identification as Matney 42.
Your Honor, same objection. Picture of Mr. Seidel, stuffed animal, or some type of, I don't know what it means. It's irrelevant. It's not about this contempt hearing. It doesn't have anything to do with Parker, and it has nothing to do with her deposition.
Counsel,
Yes, Your Honor. Remember how, we were talking about that sticker? The song playing on this post was Who's Afraid of Little Old Me, which was posted at 11:37 a.m. when Miss Matney and all counsel except for Mr. Parker's were still waiting to be deposed.
over objection. It's admitted.
I move, Matney Exhibit 42 into evidence. Mandy, can you tell us a little bit about that?
It freaks me out. It made me feel like, again, this person who was obsessively posting about me, as we see from this giant stack of evidence, and that's just a fraction of it, was aware, had details of my deposition that morning and possibly even a feed somehow. And I also just want to speak to, I know that sometimes it might appear like you're looking for things, but when you've been stalked and harassed to the extent that I have in the last 5 years, everything feels more threatening. So I was already feeling threatened that morning and that week, and that just confirmed that either had he had knowledge about my deposition that morning that appeared to be from Parker's attorneys.
How late did you stay at my office?
We left afternoon.
And, did you post me on social media about what happened?
No.
Did you make any phone calls?
No.
Did you observe any of your attorneys make any phone calls?
I don't believe so, no.
Do you know where, after the time for the deposition, where where Mark Tinsley was?
I believe he left and went on a plane somewhere.
And how about Mr. Fox and Mr. Nichols?
Everyone was just kind of like, it's the weekend, let's go.
And did they also
I
indicate,
think that's my memory.
did they indicate they were going to lunch together?
I think so.
At some point around 1:30 on Friday, March 27th, 2026, were you made aware of something that concerned you?
Yes.
What's that?
Another post from Jim Saito.
What was it?
A post indicating that he knew that the deposition did not happen and was over, and something about him declaring that I violated a court order.
At that point,
And less than 10 people were aware of what happened that morning. And I knew everybody but Parker's attorneys would never communicate with him the details of what happened that morning. So that was very concerning.
did anything else concerning you happen that day? Did he post an AI post of him and Buster Murdoch?
Yeah, which I thought was disrespectful and strange.
Why?
Just because Buster is a victim of tragedy and shouldn't be used as a figure for people to put on social media and AI them to make other
Excuse
people
me,
feel
hold on just a minute. I think we got a feed problem here.
happy.
It's going, it's moving it in and out.
We still.
Yeah. Yeah, we're hotspot. Test. You know, some folks are out there. Can you hear me? Test. I got a yes. Yes, better now. I can hear you. Okay, thank you very much. We got some people out there that are watching and they're saying they're saying they have an echo. AJ? I'm muted. No echo. It's better. Okay. Man, if you keep your voice up, that might help.
Try that.
Okay, thank
Sorry.
you. We were getting a message on the here saying, okay, keep your voice up, please.
Got it.
Okay, Council.
Your Honor. Um, on, that same Friday, before you had posted anything regarding the deposition or social media, did Mr. Seidel post anything, in reference to that occurred in the deposition?
I think that I didn't do the deposit. Some facts, something about what happened that day. I think he said that I didn't do the deposition or that I violated a court order. He posted information that, again, only a few people would have known.
I am showing opposing counsel. What's been marked for identification is Matt E43 corresponding with Matt 108, and then Matt E44 corresponding with Matt 106.
Your Honor, first of all, on March 27th, Ms. Matney's counsel put on the public index a status update that she did not attend the deposition. So anybody who's following the pleadings in the public index would know that she violated the court order.
Except, Your Honor, if you look at the timestamps, those were filed after all of these notes.
I don't have that in front of me, but with respect to Matney 43 and 44, these proposed exhibits, they have nothing to do with Parker's, they have nothing to do with the deposition, and they have nothing to do with the contempt. They're irrelevant.
Council.
Your Honor, one at 2:30 on the day of the deposition says, is mocking a security detail. Ms. Matney had security at my office on March 27th, something that only the people who were present or who were on the Zoom would have known at that time at 2:30. In regards to the other one, it is a picture of Mr. Seidel in front of Parker's, and he makes the comment, watching someone lose their ever-loving mind from a meme, then watch them think it's funny to play games with the SC court, only to be watched from hundreds of miles away as they'll likely get fined, sanctioned, and pay high prices, attorney fees, and expenses, all because they think they're untouchable and to think all I did was go fishing today. Drink up, Johnny. Hashtag margarita, hashtag crime and cast, hashtag Parker's Kitchen. I have the power and living rent free in your head.
No, it's a stain. They're not coming in. Thank you.
So those things that we just talked about, Mandy, why did they concern you?
I work in news. I've worked in news since forever, since I was 22, so 13, almost 14 years now. And I am aware of how dangerous it is when a man obsessively posts about a woman and appears to be unhinged and obsessed with that woman, especially in a way that's hateful, as Jim Seidel is. I am aware of how dangerous that is. And again, it was just a beating drum of the last 5 years with all of these people online threatening me and reminding me of how much they hate me and how much they want me to die. I didn't know what this person, and I still don't know what this person really wants from me, except for to drive me crazy and to make me look crazy and to it felt like it felt like make my fears look ill and not legitimate and make me look like the crazy one. And again, he wants me to be in trouble with the court.
Do you remember when you found out about the denial of the motion to determine location?
I believe you wrote about it.
Was the first time you heard about the denial Monday, after the deposition in the afternoon?
Yes.
After we were unable to complete the deposition, did you reach out to the Parker's attorneys and offer other possible locations?
Yes, and I believe we even offered the weekend, like, again, because I wanted to get this over with. I wanted to tell them the truth about what I knew, and I just wanted to feel safe while doing it.
Did you also offer to do the deposition in Columbia, Charleston, Pooler, Charlotte, or the Beaufort County Courthouse?
Yes.
And what was their response?
I don't know if they responded or just said a flat out no, but at that point we knew that they were unwilling to compromise. And again, that made me just more fearful.
Did you sit for the deposition?
I did.
All right, getting back to the actual crux of the case for which you are not a party to. Did you leak the sizzle reel photos?
No,
Did you leak the mediation video?
no,
Have you ever been paid to write a story with a particular site?
no,
Are you working with the Beach family and their attorneys to leak photos of Mallory to gain an upper hand in this litigation?
no.
Let's go back to Callie Lyons. At some point, were you made aware that she had been deposed?
Yes,
And have you received a copy of that deposition?
yes,
Your Honor, I would ask that the defense counsel stipulates that it is a fair and accurate deposition for which they took part, had the opportunity to question and cross-examine and allow us to read from the sworn testimony elicited in this case, to which we are not a party, but bears relevant information on Ms. Matney.
Your Honor, that has, again, nothing to do with contempt, nothing to do with why we're here today, nothing to do with the issue at hand. They have put Ms. Lyons, first of all, I don't know how a non-party got a copy of the deposition in this case. We did not give that to Ms. Matney's attorneys. Despite that, they filed it publicly on the public index, the entire transcript of it. And so Your Honor now has it as well. I don't know what the purpose of reading any of the portions of it is. I don't know why it's relevant to the issue that we're here for today.
Okay, you want some excerpt from it, like in a deposition or something? There you go.
Yes, is sworn testimony regarding Parker's attorneys paying Ms. Lyons for the text messages.
That's inaccurate. That's a mischaracterization. That didn't happen. So I object on that basis as well.
Okay, so let me see what designation you want.
Page and numbers.
Well, what's the relevance of that, even if it's true? What's the relevance?
Parkers and Mr. Seidel have colluded to create a situation where emotionally and mentally Miss Matney could not comply with the court order. They have then strong-armed this through the court while allowing other witnesses much more leisure.
Did you like to approach so we can?
Come on, yes. Page 44, is that where you're talking about?
It looks like page 13 is the first one.
Okay.
So, are you familiar with the deposition of, Kelly Lyons?
Yes,
And, do you know if it was in person or via Zoom?
I think via Zoom. I'm not sure.
And do you know if it occurred at the location where she was initially subpoenaed to appear?
I know that, they were a lot more cooperative with Callie than they were with me.
Objection, Your Honor. This witness has no firsthand knowledge of how Ms. Lyons was deposed. She was deposed in person. And she has no firsthand knowledge of the discussions beforehand about where and when she would be deposed. And so I'm going to object to this entire line of questioning and also as to relevance.
Counsel,
I am happy to call Ms. Barbier and read back the quotes if she so desires this. Or we could read from the transcript because I have heard that they're upset we have it, but they haven't said it's an accurate or an unfair depiction of what occurred that day.
just ask her what she knows from personal knowledge.
Yeah, from personal knowledge, I know that there was a different place, originally proposed and Callie wanted something else, and I know this from a source, by the way. And they were accommodating to them, and it wasn't, in my case, it's down the street, it wasn't a down the street situation. But yeah, the treatment was vastly different. From my knowledge of it.
Object on the basis of hearsay, Your Honor.
Look. Next question.
Do you know if it happened before or after your deposition?
Before.
So we talked about James Seidel. Do you know why we're talking about Kelly Lyons and Jim Seidel together?
Yes.
Tell us about it.
Callie Lyons' deposition confirms what I had feared for a very long time and was gaslit about in court the last time we were in court together. That Jim Seidel had worked together with Parker's attorneys, and he was the reason why those text messages came out on the internet to begin with. According to Callie, he basically said that he brokered the deal between Callie.
Objection, Your Honor. Hearsay, inaccurate, no foundation, no firsthand knowledge.
We're not a party, Your Honor. We would have gone really hard and deep into this if we had had the privilege of attending that deposition, but we didn't because we were really in the party.
Well, do you want them to put some part of the deposition in?
The deposition doesn't have anything to do with her being in contempt. So I don't know the purpose of it. I mean, I don't have any problem with the deposition. I was there. I mean, we got testimony that was relevant to the case. She's a fact witness as well. It has nothing to do with Ms. Matney's failure to obey a court order and whether or not she's willfully in contempt of this court. So I would object to her and her attorneys continuously wasting the court's time with issues that have no relevance to this proceeding.
What's the relevance of it?
The relevance, Your Honor, if we could stick a pin in this, I'm about to tie it up real quick. Mandy, have there been posts after your deposition occurred?
Yes.
In particular, have there been posts in the last 10 days regarding your deposition?
Yes.
I believe I'm on exhibit 44.
I have 42 here, but I don't know.
Okay, yeah, okay, so 44. Did you see a post from Mr. Seidel referencing the Parker attorneys?
Yes.
What was that?
Can you show me? I don't remember. I mean, there's been a lot of posts.
I'm showing defense counsel what's been marked for identification as Matney 44.
I think I previously said that was, that objection was sustained in 44 through 47.
I think I have my numbers wrong, so this would be 48.
Okay.
I object for the same reasons. I've never seen this before. I don't know what it has to do, again, with why we're here today.
Again, Your Honor, we are not subject to discovery rules because we are not a party, and this was disclosed in Matney 117 in the filings in this case.
Your Honor, in addition, it can't be authenticated through this witness.
Effect on the listener as well as,
She just indicated it was posted after the deposition was supposed to take place. So what in the world relevance could it have to her state of mind before the deposition?
Okay, it's a stain. It's not relevant.
it's not coming in.
Oops.
Ms. Matney, what is your personal knowledge of Mr. Seidel working with the Parker's attorneys?
From Callie's deposition and what I have read in Callie's deposition.
Does anything corroborate Callie's deposition?
Yes, the timings of his post and the information that is only known to a few parties in this case, that he was aware of. So the combination of both of those things.
Has he made posts regarding working with the Parker's attorneys in this case?
I don't know. I know that he's made posts, supporting them in very weird ways.
Would it surprise you to find out he has posted that he is working with their team?
No.
Again, Your Honor, I believe this is a very relevant piece of evidence that should be admitted or in the record.
Oh, man, doesn't.
Have you incurred expenses for dealing with this deposition?
Yes. And a huge amount.
Have you compiled a list of the expenses that you paid, just in regards to defending your deposition?
And my husband has, but I know the ballpark.
During your deposition, were you provided documents you'd never seen before?
Yes.
And, was one of them a affidavit of Vicky Ward?
Yes.
Who's Vicky Ward?
She was a party to this case. She's a journalist, who was accused of having knowledge or something to do with the leaked photos of Mallory Beach.
These leaked photos of Mallory Beach, that's the whole point of this case, right?
It's a huge part, yes.
And so during your deposition, were you shown a exhibit? That had previously not been provided to you regarding the identity of who leaked the photos?
Yes.
What was it?
I just remember the affidavit of Vicky Ward. Greg Roman, is that what you're?
Your Honor, at this point, I would move to enter Matney 49, which is a sworn affidavit that was made as Defendant's Exhibit 19 during Ms. Matney's deposition on April 8th, 2026, and the contents thereof.
Your Honor, I don't, Vicky Ward has given several affidavits in this case, and they have nothing to do with whether or not Ms. Matney is in contempt of court. I don't know why, when she finally was court ordered to go to the Spartanburg courthouse and take a deposition and did it, I don't know why anything that occurred within the deposition is relevant to whether or not she's in willful contempt of this court's order having ordered her to previously do it.
What's the relevance?
The whole point, Your Honor, is that Ms. Ward, in her affidavit, who was a named party,
states, and this affidavit has not been clocked before, so there was no way for us as a non-party to have any idea it existed, nor was it provided to us prior to the deposition, that she received the video and the photo that is in controversy in this case from Greg Roman.
I'm not trying this case. I'm in a rule to show cause, okay? It's not relevant, sustain.
Your Honor, it is relevant because it shows the sole purpose of this entire process has been to harass and intimidate Ms. Matt.
I get it. Let's move along.
No further questions.
Thank you. All right, let's see the lawyers. You good? Okay. All right, everybody. Ladies and gentlemen, we are going to recess this case. We cannot possibly finish it today. And we have used the time that we have allotted. I've been in conversations with the lawyers, and my law clerk over the lunch hour has tried to figure out our schedule for the next couple of weeks here. We're bouncing around the state. We're in Lexington, we're in Williamsburg, we're in Spartanburg, Cherokee County. So we will have to reconvene this, and it will be on WebEx. It will be on WebEx, so everybody can get notice of that. We're not trying to hide anything or cut anybody off. It's just we cannot finish this today. We have used up our allotted time here. Okay. All right. With that, ma'am, you may leave the witness stand. You are not to talk to your lawyers, and they know not to talk to you about your testimony. You understand?
Mhm.
And you'll be asked that question when we reconvene under oath. Okay. Okay. You may leave the stand. All right, ladies and gentlemen, we'll be in recess until we can get a time slot to reconvene. Thank you.
I have a brief issue to take up with Your Honor regarding media coverage from the last several hearings. Your Honor, under media's.
Battery level high. Red standby.
No objection that we mentioned in chambers for the record, and Lunashark is not waiving that jurisdictional objection by Mr. Bannister first.
Okay, I understand. Let me address a couple of things about the media. This might help us. If you are recording or taking still shots, you have to be in the very back of my courtroom. I've been doing this for 13 years on the bench and 25 years when I was sitting at counsel table. So about 38 and a half years of doing this. The media has always been at the back. So if you want to take a picture, if you want to record something, do that. Otherwise, telephones have to be turned in the off position. In the off position. I'm not talking about silent. I'm talking about in the off position. And I have the authority to do that under the Supreme Court's order, and it's posted in the hallway if you want to get a copy of it or take a picture of it out there, okay? Filming will only be done while I'm on the bench and none during breaks. There'll be no recording of the lawyer's private communications between each other or their clients. And you can see this under that 605, is that what it is? 605 under limiting instructions, okay? Got it on the screen right here, Roman numeral number 2, media coverage, and under limitations, number 2. Mr. Bannister, you're recognized.
Your Honor, thank you for placing that on the record. Shouldn't have had to do Rule 605, it's pretty clear. The general rule is you cannot have media in the courtroom record any proceeding without permission of the court. And that is subject to the Rule 605 general provisions. And I'll just point out, Judge, that under F1, subparagraph I, it only includes proceedings in the courts. I have never been part of a case where a recess or break, there was permission for recording. We provided, Your Honor, with a violation of what we will be clear under F1, subparagraph I. I'll also point out, Judge, that under FB subsection 6, compliance with the rule is mandatory for all individuals that are participating as representatives of the media. And failure to comply with the rule shall subject them to appropriate sanctions. So when there is a violation, it results in a sanction. What that sanction is up to Your Honor. Your Honor, I think we, that's all. Thank you.
Okay. Yes, ma'am.
Good morning, Your Honor. Becky Lindahl on behalf of Ms. Matney. And also appearing for Lunashark for the limited purpose of contesting that this matter be heard this morning. Your Honor, I understand that the courthouse was having some communication issues last week, and my sincere sympathies for that. I know that can be very frustrating. But just as a recap, because I understand that the court and the court personnel may not have had an opportunity to review all of the filings. On Thursday afternoon at approximately 12:30 and again a few minutes later, the Parker defendants submitted by email, not by a motion filed with index, a request aimed at Lunashark to punish Lunashark and Lunashark only for a purported Rule 605 violation at the last hearing that this court conducted. And the two explanations that were given in that email of how Lunashark violated Rule 605 were, one, by reporting when the court was on a break or a recess, and two, by accessing or somehow capturing visually or physically unflattering photos of counsel. And we have attached to our motion we filed an objection on the public index. Due to the timing being so close to today's hearing and the Juneteenth federal holiday on Friday, we were not able to get that filing filed until after 6 o'clock on Friday. It has not been accepted by the clerk. We included the email that the Parker defendants submitted to Your Honor in our filing, as well as the full text of 605, which lays out what the court can authorize and what the media can do pursuant to the duly signed Rule 605 order, which Your Honor did sign in this case for Lunashark to record this hearing. So beginning with the jurisdictional issue, Your Honor, Ms. Matney is a principal of Lunashark, but Lunashark is not a party to this particular third-party motion. Ms. Matney was subpoenaed as Ms. Matney, not as Ms. Matney, principal of Lunashark, or Ms. Matney on behalf of Lunashark. Lunashark has never been served with process to become a party to this third-party proceeding. And although there is an overlap of counsel between Ms. Matney and Lunashark on other matters that can preserve privilege, which has come up before, Lunashark has never needed counsel in this matter because they've never been a party. So email notice less than, you take out the federal holiday, which Rule 6 of the South Carolina Rules of Civil Procedure does on certain occasions for meeting time, then Lunashark, the only way they received notice of this hearing was through an email from counsel to the court, to counsel for Ms. Matney. There was no attempt made whatsoever to serve Lunashark with any type of process or notice and opportunity to be heard pursuant to Rules 4 or 5 of South Carolina Rules of Civil Procedure. And when I know that Your Honor made an argument that because Ms. Bannon and I may have general engagement letters with Lunashark on other matters, that means that we receive email service on behalf of Lunashark. Now, I know, Your Honor, as you know, that being counsel in an unrepresented matter does not confer onto counsel authority to accept service of process, nor does email service of a hearing less than 24 business hours excluding the holiday before a hearing. That is not sufficient under the South Carolina Rules of Civil Procedure for notice of hearing. So we would object on jurisdictional grounds to this motion being heard at all. That said, Your Honor, Lunashark's cameraman is in the back of the courtroom. He has complied with all directives from the courtroom staff and deputies, and he intends to comply with Your Honor's further rulings and limitations, if any, on the Rule 605 order that Your Honor has already signed. I'll note that in the email, counsel for the Parker defendants makes reference to prior violations at, I suppose, earlier hearings by Lunashark, and they have never been raised to Ms. Bannon or I, to Lunashark, to anyone, other than in the email that was sent on Thursday afternoon, less than 40 business hours, less than 24 business hours, including the federal holiday. So to the extent that the Parker defendants have been observing some sort of violation when Lunashark was recording hearings pursuant to Rule 605 and in accordance with Your Honor's orders in November, in April, and in May, they were only raised for the first time last week. So there's that additional timeliness and notice issue that I think if Lunashark had been properly a party to this proceeding and served, that it would be entitled to raise as a merit-based argument. With respect to, we also submitted in our brief, we included a number of additional arguments with respect to what Rule 605 allows and doesn't allow, and I won't reiterate those here, but I understand we are hoping to get this done today. So I'll rest on our brief on that issue. Other than, Your Honor, just to make the point that Lunashark has in the past, when it's received its 605 orders from Your Honor, there have been some limitations, including related to the WebEx. Lunashark has fully complied with any limitations the court has previously put on it pursuant to signing Rule 605 Form 1, which is what Lunashark has submitted in order to keep the rule on all prior occasions. We did include as an exhibit to our filing the full text of Rule 605. I encourage Parker defendants to review it carefully because recording during breaks is not included as a prohibited activity. And those of us who are litigators and have been litigators for several decades, I know, have the unfortunate habit sometimes of watching court proceedings on WebEx, especially trials. And it is certainly not uncommon for the video of a trial, such as on Court TV, video trials in South Carolina, to keep the cameras rolling during a recess. Sometimes they're aimed at the light fixture, sometimes they're aimed at the portrait, sometimes they're just showing the courtroom. And that is not unusual, Your Honor. In fact, I would say it's more unusual for there to be no recording at all during the court breaks because, as Your Honor knows, the cameraman for a Rule 605, we're operating under a duly issued Rule 605 Form 1, isn't part of the proceeding itself, so they don't know necessarily when the hearing is going to resume. So they're on standby so that when the judge takes the bench, they can pop back to action so that the public can have the access to the courts that is inherent, dictated, and critical to the functioning of the American judicial system. We also noted in our filing, Your Honor, that there have been other actors, other podcasts that have violated Rule 605 by recording, for example, WebEx of prior proceedings and posting it online. And, curiously, those podcasts were not mentioned in the email that Parker defendants submitted to Your Honor 48 hours before this hearing. We also included in our filing, Your Honor, there's very limited authority on Rule 605 generally. My research in South Carolina law indicated that there are probably 4 cases that have ever looked at Rule 605. There's some limited secondary authority, which we did study in our filing, and we included some commentary from Judge Kitteridge from 2002 related to a very homicide trial, Corey Harris, for the murder of Deputy Marcus Whitfield, which attracted significant attention. And I think those we quoted from some comments related to that case in our filing, including, and I read this because I think it's important, Your Honor. With respect to camera coverage, Judge Kitteridge noted that media presence in the courtroom enabled the community to properly understand various unique aspects of the case, and that it has been his experience that a camera neither detracts from the dignity of the courtroom nor impairs the party's right to a fair and impartial trial, but rather that a camera in the courtroom fosters the truth-seeking of the process because it fosters accountability, which is especially significant in high-profile cases which capture the public's interest and attention. And as we have discussed in prior hearings and in discussions with Your Honor, this certainly is a matter, although not a criminal homicide proceeding, this certainly is a matter that has attracted some public interest. And depriving the public of the ability to observe this hearing, which Ms. Matney wants to be recorded. She is, in a sense, although this is a civil proceeding, she is the accused here. And Ms. Matney wants sunlight on this hearing. And depriving the public of that sunlight does violate both the inherent critical function of the Constitution in providing access to the courts to the public, but also it deprives Ms. Matney and Lunashark of their important First Amendment rights to freedom of press and freedom of speech. Other than that, Your Honor, if I could just confer with my co-counsel that I think we covered what the critical points of our filing are. We would point to our filing for more detailed arguments, but we would request that the accommodation that has already been made by complying with deputy's instructions to move to the back of the courtroom resolve this issue. To the extent that there is a violation that anyone observes, we would ask for notice and an opportunity to be heard on that. And to the extent that there is going to be a wholesale limitation of Lunashark to record and broadcast these proceedings in accordance with Rule 605. Even though the rule says there's no appellate review anticipated, I believe is the rule that rules, the language that rules uses, we would ask Your Honor to certify that issue for immediate appeal if there were an order depriving the public access to this hearing pursuant to some sort of ruling under 605. I could just confirm.
Yeah, you can, but understand this, I have granted them any media back there. I have not signed anything that prohibited them from taking any picture, any video.
Thank you, Your Honor. Thank you for letting me make that record.
Yes, make the record, but I've not done that.
Thank you.
You're welcome. I don't think in my 13 years I have ever refused to sign one of those 605s.
Thank you, Your Honor. We appreciate it.
Yeah. Okay, very good. Anything, dog?
Nothing, Your Honor.
Okay, we ready to go? Ma'am, I need you to come back and take the stand. You were previously sworn and you remain sworn. You don't, we don't need one.
Your Honor, if I could just say one more thing. I apologize. I'll be brief. We had previously objected at the beginning of last hearing to the jurisdictional defect that there was no affidavit accompanying the contempt motion. So we reviewed that objection for the same reasons that we argued in court at the prior hearing. I will not belabor that. I'll just review the objection. The other thing, Your Honor, is I do have some argument that I would like to make with respect to undue burden and Rule 45. I think in light of where we are procedurally, it makes sense to do that at the conclusion of testimony. Ms. Bannon is intending to do our closing, so I would ask before I yield the podium, if it's acceptable, Your Honor, that Ms. Bannon and I both be able to speak at the conclusion of the hearing.
Give the lawyers all the time you need.
Thank you, Your Honor.
Have a seat, ma'am. Please adjust the microphone to suit yourself. There you go. Counsel.
May it please the court, Your Honor, permission to proceed. Good morning, Ms. Matney. Ms. Matney, you testified in your direct testimony that you are the owner and the CEO of Lunashark Media, is that correct? Correct. Okay. And who are the other owners of Lunashark? Anyone else? Is he the only other owner? What percentage of Lunashark do you own?
Full microphone.
Is this better? Yeah.
Yes.
Okay.
Objection, relevance, Your Honor? Objection to the question as to relevance.
The question was, Your Honor, what percentage of Lunashark Media do you own?
What is the relevance of that?
Well, Your Honor, developments, as I'm going to show in the following questions, is that she has a financial interest in Lunashark Media, and Lunashark Media has highly publicized this dispute in many different ways and many different forums and platforms. And so I want to know where the profits from that monetization are going.
Counsel.
This is beyond the scope of direct, and also it's not relevant to the issue before the court. Further, Ms. Matney, as CEO and owner, obviously makes money from Lunashark action, so we will completely consent that she makes money
Your
from
Honor,
her business.
in the beginning of the last hearing, you made very clear that the motivations for Mrs. Matney's failure to attend the court order deposition were highly at issue here, particularly relevant to whether a financial interest in prolonging this dispute and in monetizing this dispute. And so the ownership percentage that she and Mr. Moses have in Lunashark Media is very relevant.
Okay, it's overruled. You're protected. Go ahead.
I just have to say that I had to laugh a little bit at you thinking that this is financially gaining for me in any way, shape, or form. I'm drowning from all of this. And again, this is, I don't know, the 5th day that I've had to take off of work because of this. And I have my colleagues here. That costs money as well. I have attorneys that I have to pay for. This would be the dumbest way in the world for me as a journalist or a content creator to make any sort of money.
Ms. Matney, I'm glad that you're amused, but I'd ask that you please answer my question. My question was, what percentage of Lunashark Media do you own?
I don't know. I own it with my husband.
You're the CEO, and you don't know the percentage of what you own?
I don't believe that this is relevant.
Madam, your lawyer gives the objection. You answer the question.
Asked and answered, Your Honor.
Yeah. I own it with my husband.
Overruled. Answer the question.
I own it with my husband.
You and your husband own it 100%, is that correct?
Yes.
Okay. And Lunashark Media is a for-profit business, correct?
Yes.
And the podcast True Sunlight and Cup of Justice are produced by Lunashark Media, correct?
Yes.
And you have publicly stated that you built a multi-million-dollar media company, is that correct?
That is true.
You said that in postings, that it's a multi-million-dollar media company, is that right?
Yes,
How many $1 million is it worth?
I don't know. I don't know. My husband does the money.
But in building this multi-million-dollar media company, you've become familiar and knowledgeable with how revenue is generated by Lunashark, correct?
Somewhat. I'm the creative side.
But you're the CEO, correct?
I am the CEO, but I'm the creative CEO.
And you're one of the producers of these podcasts,
Yes.
correct?
Yes,
And part of your job is to create content, is that right?
mhm,
And because content helps generate revenue, you are in part responsible for raising revenue, correct?
correct.
And one of the ways that Lunashark generates revenue is through advertising, correct?
Correct,
And another way that they generate revenue is through subscriptions, is that right?
correct.
And Lunashark has different levels of subscriptions. They have a Soak Up the Sun Lunashark Premium for $14 a month, is that right?
Correct.
And they have a Pocket Full of Sunshine ad-free podcast subscription for $7 a month, is that right?
Correct.
How many premium Lunashark members do you currently have?
I don't know at the moment.
Approximately how many do you have?
I don't know at the moment.
You don't know if it's thousands? You don't know?
No, because I'm on the journalism creative side, and I still like to separate that from I never wanted to be a journalist / creator that was constantly chasing clicks and constantly chasing subscriptions and constantly chasing money. My husband handles the money. I handle the content.
So you're asking this court to believe that you're the CEO and you don't know how many premium subscribers you have right now?
Objection, asked and answered.
Is that
Correct.
right? You don't have an approximate number?
Objection, asked and answered.
Now, you also generate revenue through sponsorships, is that right?
Define sponsorship.
You tell me, what is a sponsorship?
I don't know what you're talking about.
You don't have national advertisers that sponsor ads on your podcast?
Yeah, that would be advertising.
Okay. You have national advertisers?
Yes. It's not a national, it's a global podcast, so.
And do you engage in crowdfunding on behalf of Lunashark?
Not for myself, for other people. I have shared GoFundMe's for victims that are being abused by the court system.
You've also asked your followers to help you pay your legal fees, haven't you?
No,
You haven't posted about helping to pay your legal fees?
I said I probably will have to get there at some point, but again, this has been dragging out for a very long time. And I have not asked for money specifically because we have not had to pay money from you. This is not over.
Do you recall asking your followers to click on certain videos on repeat to help you pay your legal fees?
Yeah, and that's kind of a joke.
Oh, okay. And you also generate revenue through merchandise, is that right?
Yes, a good percentage of it goes to charity, though.
Do 100% of the proceeds go to charity?
I believe so.
Do you believe so or you know?
Again, my husband does the money. I pick the charity every few months, and I know that my husband is constantly angry because merch makes us no money. And it's just, I like to do it. It's a fun thing and it's fun for the fans, but it does not make us money.
Does it not make you a lot of money or does it make you any money?
Money, no money.
So you make no money on merchandise, that's your testimony?
Yes.
Now, would you agree with me, Ms. Matney, that audience engagement greatly affects Lunashark's revenue?
For the podcast.
And on social media as well, correct?
No. We have a very solid following from our podcast, from the Murdoch Murders podcast days that, as you can see in this courtroom, people are very loyal, have traveled across the United States to come here and really, really care about our podcast. So we are lucky in the fact that social media is not our number one way of getting to people, and people just listen to the feed. Social media is a way to market but it doesn't do much beyond that.
So you agree that you do make money from your podcast, correct?
Yes,
Okay. And you do make money from social media, you're just saying it's not a lot of money, right?
it's not a lot of money.
What's a lot of money to you, Ms. Matney?
I don't know, but it's from one of your posts, from one of the posts that I've done about Parker's, I made $25. So that'll give you a good estimate.
Would you agree with me, Ms. Matney, that the more controversial the content of your podcast is, the higher an audience engagement you get?
I don't know.
Well, you have to make these podcasts interesting in order for people to tune in, don't you?
I don't make them interested. The content is interesting to begin with, so
But you have to have interesting content in order to generate audience engagement, correct?
sure.
And would you agree with me that controversy creates interest in your followers?
No,
You don't agree with that? But you do agree it has to be interesting, right?
yes,
And you do agree that on social media, every click that you get generates cash. It may not be a lot of money to you.
No, that's
but it
not-
generates cash.
no. Most of my posts make $0. Or
Well,
zero
you just
pennies.
testified a post that you made about Parker's made you $25, right?
Yeah, that's
And that's $25 more than you had the day before that, right?
sure.
Okay. Now, your Instagram handle is at Mandy Matney, is that right?
Mandy_Matney.
Okay, and what's your Facebook handle?
Mandy Matney Investigates, I believe.
What's your Threads handle?
Mandy Matney, I believe. Mandy_Matney.
And you control access to those accounts, don't you?
Yes,
And you're verified on those accounts, aren't you?
yes.
And so those are accounts that, although you might not think it's a lot of money, you profit from those accounts, don't you?
I don't profit from threads, and it depends on the month. I know that you're not familiar with social media, but every month they have different variables for what, like sometimes reels get money, sometimes reels make no money, sometimes photos with text make the most, like it completely depends on the month, and there's some months where I'll literally make $0 on social media.
Okay. But you do make money on Facebook and Instagram, correct?
Correct.
You don't make money on Threads. Is that your testimony?
I believe so.
Okay. And you do make money on your podcast, right?
Correct.
And can we agree that you have devoted numerous social media posts to this dispute over your deposition?
Yes.
In fact, you have commented online a great deal about how the Parker's attorneys have used your social media posts in numerous court filings, right?
Mm-hmm.
And you don't dispute that those are your social media posts, do you?
I don't.
Okay. Now, since receiving the subpoena for your deposition on October 14th of 2025, would you dispute that you posted about this deposition dispute more than 260 times?
That seems like a lot, but I don't know. I haven't counted.
Right. Well, if I represented to you that certain people on the Parker's team have done research and found more than 260 posts that you've made about this deposition dispute, would you have a reason to dispute that?
Are you saying like comments? Or are you saying like a lot of my Facebook posts go to my, a lot of my Instagram posts go to my Facebook, etc. So I don't, there could be a lot of duplicates in there.
There could be duplicates because you do this across multiple platforms, right?
Right,
So if you post something on Instagram, you also post it on Facebook, right?
usually,
And then sometimes you put the same thing on Threads, right?
sometimes.
Because you want to get these messages out to the largest audience possible, right?
Yes,
And
somewhat.
many of these social media posts are aimed at disparaging Parker and Harvard Council. Is that right?
No, they are aimed at what you have done to me in the past few months and dragging this court proceeding out when this could have ended a very long time ago. I wanted to be deposed a very long time ago. I was ready, willing, and able to be deposed a long time ago. I just wanted my safety, and I do not believe that it's right that you are doing this. So that is what I've been spreading sunlight and spreading the word about. I think people need to know who you are and what you're doing.
And you have made very negative comments about my client, Mr. Parker's, Parker's Company, and other members of Parker Council, including myself, right? You agree they're negative, right? No, you haven't been flattering. Is that right?
Correct.
Okay. And you have, as recently as this last night, been posting about negatively about this court and about Judge Kelly and his rulings. Is that right?
Absolutely.
A t-shirt that says take zero shit and a exhibit that says bitchy little footnote. Or it's a notepad. It says bitchy little footnote.
And you have made social media posts about Parker's bitchy little fitness. Is that right?
I made a post about the amount of times that you all had gone out of your way during filings to disparage me and Liz Farrell over and over and over again and call us non-journalist and be pretty nasty. So yeah, I have mentioned bitchy little footnotes. I don't know why you think that take zero shit is related to you though.
So, Your Honor, I'm reading exhibits 3 through 6 into evidence.
No objection, Your Honor.
Not object.
Ms. Matney, you received a subpoena originally for your deposition on October 14th, 2025, is that correct?
Correct.
And you're, on October 14th also, you had a red carpet premiere for the Murdaugh Death in the Family Hulu series, is that right?
Correct. I think. I don't know. I would have to look.
Okay. But that was right around the same time, did you agree with that?
Yeah.
Okay. And you were an executive producer on that series?
Yes.
Okay. And you actually went to New York and attended the red carpet, didn't you?
Yes.
Okay. And you actually have made a number of public appearances in connection with that. You did press interviews, you did podcast appearances, you did promotional events associated with promoting that, right?
I did. It's my job.
And that, anytime during those promotional activities or on your red carpet, did you bring a security guard with you, did you?
We had security with Disney the entire time.
Did you bring your own security guard?
No, they had hired security that we worked with.
Okay. I'm asking you, did you bring your own security?
Objection, asked and answered, Your Honor.
I think so. Go ahead.
Did you bring your own security?
But no, because they already had it there and it was already worked out with Hulu and Disney.
Did you bring security with you today?
I did.
And you understand this courthouse has security, right?
Yes.
Okay. But you don't believe the courthouse security can protect you?
The further I want to feel safe and I don't feel safe around you and I don't feel safe around you and
But you felt safe enough on the red carpet not to bring your own security?
yeah, that was far away from you.
Now, Ms. Matney, you didn't, you in fact, you routinely make public appearances for your job, right?
I defined it routinely.
Well, in October of 2023, you appeared at the College of Charleston for a conversation with Mandy Matney, and that was open to the public, right?
That was a long time ago, so I would not define that routinely. That was during a book launch, so I had public events during my book launch.
Did you take your own security guard with you to College of Charleston?
I believe we did. We had security, I remember them.
Did you bring your own security to College?
We had security.
I'm not asking.
I don't, are you trying, I'm sorry.
I got the best court reporter in South Carolina. She can only give one voice at a time.
Sorry.
Ms. Matney, I appreciate if you'd answer my question. My question to you is, when you appeared at the College of Charleston in October of 2023, did you personally bring your own security guard?
We had some sort of security. I can't go back in my mind and think was there a security guard that we physically brought with us? But there was somebody at the door, I remember, that made me feel safe. And I believe David hired him. I can't remember the details. Again, you're asking me to recall details from an event 3 years ago.
When you appeared in November of 2023 at the University of South Carolina for True Sunlight with Mandy Matney, that was open to the public too, wasn't it?
Yes, and there was security on the premises.
Right, I understand universities have security. What I'm asking you is, did you bring your own security guard?
No, we worked with the university.
So you did not bring your own security guard,
I
correct?
believe, I don't remember this. I just remember we had security and I felt safe.
Okay.
And I have the right to do that, to feel
You
safe.
certainly do. I'm
And that's
asking
what I'm doing
whether you
today.
did.
Yeah, but I mean, I just want to say that I have the right to feel safe and I have the right to, and again, it's very expensive to hire your own security guards. But I have the right to feel safe and I should not feel bad about that.
Ms. Matney, nobody here disputes the fact that you have the right to feel safe. These are questions that I'm asking you to answer. They're yes/no questions. The next question is, when you went to Arizona State University in November of 2023, and you had a Suns Devils in the details, a conversation with Mandy Matney, that was open to the public, wasn't it?
I don't know what you're talking about.
Did you appear at Arizona State University?
No,
Okay, you didn't have that.
no, I don't know what you're talking about.
Okay, have you done other appearances at major universities?
Yeah, Indiana, University of Indiana, University of Kansas, and University of Missouri.
Did you bring your own security guard to those events?
No, and again, I just need to say this too, I feel safer when I'm out of the state of South Carolina.
Okay. When you did your book tour and you had book signing events at public places like Barnes and Nobles, did you bring your own security guard?
I also think it's really relevant to know that like security needs change within time, and my security needs have increased exponentially this year. So asking me about random dates from 3 years ago, I don't understand.
Ms. Matney, you testified on direct that you started receiving online harassment and online threats in 2021, correct?
Correct.
Okay. And so the time period from there on is relevant, and it's relevant to my question. So I appreciate if you just answer my question.
But it builds, and the harassment builds and then it goes away, and then it builds and it goes away. So there are different times when I do feel safer. And when you're asking me about, I think we had security at Barnes and Noble. I don't remember. You would have to ask my husband.
Okay. When you did your book signing events, in general, did you bring a security guard with you?
Usually, and I usually had my husband, and I always had my husband next to me. And we always are safe with securing the room and making sure most of our events are not open to the public. They are premium Lunashark member events only. We are not advertising them on the internet. I'm very safe about that.
Objection, Your Honor. Again, same objection. However, this is even weirder because it looks to be a unofficial transcript from somewhere, and it picks and chooses, and it doesn't state who's talking. So basically, it has the name of a podcast and then some paragraphs, but it doesn't identify anything or clearly state anything.
Well, is it her work product, something she did?
We don't know, Your Honor, because it was a verbal podcast, and there are actual transcripts through Apple Podcasts, which we could look at, but these are not it. I don't know where any of these came from. They're not the official.
Let her find out.
Ms. Matney, did you have an opportunity to review that notebook?
Yes.
Okay, and are those excerpts from podcasts that you've given,
What do you mean given?
or that you've been on?
I've been on them, yes.
Okay,
I believe so. Again, I would take a very long time.
we
Go
can,
through every
we can
single
have you look at them further at the lunch break. I'll move on and ask you about some other public appearances that you've made. You had a event at the Roasting Room in Bluffton, South Carolina. Do you recall that? It was called Stay Pesky and Perky. You remember that?
What year, what?
was very recently, in 2025?
I don't know what you're talking about. 2025,
Have you ever had an event at the roasting room?
years ago.
Okay. And did you take a security guard with you?
I believe we had security.
Okay. I'm not asking you about.
And it was a
whether the bar had
premium-
security.
it was
I'm
a
asking-
premium-
I'm asking you whether you had a personal security guard that you brought with you.
Yes,
Okay. What was the name of this person?
his name was Steve.
Steve what?
I don't know the last name.
How long have you used this man for security?
But we use different people for security.
Okay. Do you have a security company that you use?
My husband does.
Okay, what's the name of the security company?
I don't know. Again, you should ask my husband a lot of these questions.
Okay. And your testimony is that at the roasting room, you brought your personal security guard.
We had a security, but also it's very important to know that only premium members knew about the roasting room event. It was a very private, very quaint. I think like 30 people were there. It's very different for me to go somewhere where I would post on Facebook and say, everybody, like today, everybody show up here. That makes the situation more dangerous, and that makes me need a security guard. For a premium only event where we're only inviting a few people and we know who's coming and we have vetted the list, the security concerns are a lot less. Does that make sense?
So Ms. Matney, I think what you're saying is that the more people that attend something, the more danger that presents to you. Is that right?
Not necessarily.
You just said that when there's a bigger crowd, that means you're less safe.
When more people are.
Objection, mischaracterization of testimony.
Overruled, go ahead.
When more people, no.
Okay. Okay. Well, tell me what you are saying. When is it you choose to bring a security guard and when do you not?
When the public is aware of where I'm going to be.
And you've done that on every occasion the public's aware that where you're going to be?
Typically,
Oh, okay.
especially in the last few months, the security concerns have been a lot worse.
And you have invoices and receipts for all of these security guards you claim to have used over the years?
Objection, Your Honor. Relevance.
Did you attend the co-op in Nashville, Tennessee, a public appearance there?
Years ago,
Did you take a security guard with you?
I don't know. And I've told you this many times, but I don't feel safe in South Carolina and I feel safer in other states.
Oh, okay. You attended a public rally on March 21st of 2024 for the Victims Assistance Network. Do you recall that?
Yes.
And there's lots of pictures of you at this public rally. Do you know that they're on the internet?
The victims rally? I don't know what you're talking about.
Did you attend this public rally in March of 2024?
Tell me what it was
It
and
was a
where.
rally, a public rally for the South Carolina Victims Assistance Network. Do you recall that?
Yeah, I went with Sandy Smith, I believe.
Okay. Did you bring a security guard with you?
Brought my husband.
My question is, did you bring a security guard with you?
And we were on State House grounds. And I remember going over, there were safety precautions. And so, no, I did not bring a security guard with me.
Okay. And you've also had live broadcasts of Cup of Justice and True Sunlight, correct?
I don't believe so.
You've never had a live broadcast?
I don't know. What's a live broadcast to you? What are you,
Ms. Matney, you testified earlier that that Mr. Bland is your co-host on Cup of Justice, correct?
Yes,
And he's a lawyer, correct?
correct.
And he was with you when you had the discussion on your podcast in June, 11 days ago, about this hearing, correct?
Correct.
And you discussed this case with him and discussed this hearing with him, right?
I believe so. I need to look at that.
And you're very aware that he's a lawyer, right?
Yes, he's not my lawyer, though.
But you think he's a great lawyer, right?
I think he's a great lawyer. Yes.
Okay.
He's not my lawyer though. I think there's a big difference.
You have approximately 73,000 Instagram followers, is that right?
Yes.
And you have about 55,000 Facebook followers?
I think it's like 58 now.
Okay. And you would agree with me that you routinely share your location with all these thousands of people, right?
I don't.
You don't do that?
I don't.
Okay. Is this a posting that you made in December of 2025?
Yes.
And you say in this posting, me walking into the Beaufort County Courthouse, knowing how many people hate to see me coming. You see that?
Yes.
So you're telling people you're at the Beaufort County Courthouse, right?
That I posted this days after I was excused from jury duty. I have a rule for myself where I never post about a location, and I haven't in the last 4 years from a location because of safety concerns. So I do not post. If I'm going to be somewhere the next day, I'm not going to post. Even when I'm in a city, I usually take a couple days to post from that city. So when I post with locations involved, I think you're misunderstanding what's going on there. It's days later that I was at that location.
Miss Matney, did you take a security guard with you that day to the Beaufort County Courthouse?
I did not.
Okay. But you were in South Carolina, right?
And nobody knew that I was going to jury duty.
Okay. But you did not take security with you, right?
I did not.
And there's another posting. You talk about this posting about how people recognize you all the time when you're out to dinner, right? Never weird when we walk into a place and hear that's Mandy and David with that podcast. LOL, LOL, right?
Correct.
So you get recognized all the time when you go out to dinner and when you go out into public places, right?
Yes.
And you don't have security guards with you then, do you?
I have my husband with me.
Your husband's not a security guard though, is he?
He's not, but he's just as good as one.
Okay.
I feel safe with my husband, and I think that that's important.
Okay. Post you made when you and your husband were at a bar. Do you remember that?
Again, correction, so you're not mischaracterizing me. I posted this way after I was at that bar. I do not post from bars that I'm at a location.
Did you take a security guard with you to the bar?
No, I did not. I took my husband, who I feel safe with, who arms himself.
But you get approached by strangers all the time, don't you?
I do a lot.
And you don't have security guards with you, do you?
I can't afford that. I don't make that much money.
Okay.
I would love to.
You have a travel podcast and you travel through multiple states and foreign countries and you post about where you went, right?
Yes.
Okay. And you don't take a security guard with you on those trips, do you?
Because I'm not nobody knows where I'm at the time.
You never post simultaneously that you're in a certain location. Is that your testimony?
Typically, like I'm really good about not, again, because I've been harassed for so many years and it changes you as a human being. Everything that you do is about your safety, and everything that I do. So when I go to post online, I always consider, do I want, like, I'm not like a normal person that can post from a bar and everything's fine. I have to be careful about that. And I think that you're mischaracterizing a majority of my Facebook posts just because they're at a certain location. I do not post from that location, so therefore it's not a security concern.
Do you recall inviting your followers to a public meetup in Colorado called the Brews and News?
It was not a public meetup.
Do you recall inviting your people to the Brews and News?
It was a premium only event where we had the guest list again.
Okay. Did you bring a security guard with you to that?
I did not. I felt extremely safe in Colorado.
And you routinely, walk on the beach in public places, right?
I don't. Do you know that, Debbie?
Well, you
Then
post
I-
pictures of yourself on the beach walking.
Do I?
You do.
I haven't seen those in this giant notebook. I have walked on the beach. I'm not a criminal. I'm allowed to do that. I'm allowed to live my life.
The point, Miss Matney, is that you don't take security with you. do
Take
you?
my husband.
Okay. But you don't take security guards with you, do you?
I take my husband. I could not afford a security guard to go with me everywhere. You might be able to do that, but I cannot.
Okay. Now, Miss Matney, on the day before March 27th, you made public appearances, right?
Before what?
Before March 27th of this year, you made public appearances, right?
Define.
Well, you already testified you went to the red carpet event for your Hulu series. That's a public event, right?
It was not a public event. It was extremely private inside Disney's headquarters with a very, I don't know if you've been to Disney's headquarters, but the vet or any sort of event like this, but the vetting process to get into it is extreme and only certain people are allowed.
Okay.
You feel very safe there.
Well, maybe that wasn't a
It's
good
not
example.
a public event.
But tell me, you made public appearances before March 27th of 2026, correct?
Yes, I've made public appearances.
Okay. And post March 27th to this day, you still make public appearances, right?
Define a public appearance.
You go out in public, right? You make public appearances at bookstores, at events that promote your podcast.
I'm a
that
little
promote your
weirded out,
book.
Miss Debbie. I'm really weirded out by this line of questioning. And again, I'm not a criminal. I'm allowed to go outside. I'm allowed to live my life. And I want all women who are in a position like I am, who have been harassed and stalked and scared, that they should know that they also can go outside and live their lives without an attorney yelling at them for that. I think that we all should have that right.
Miss Matney, no one challenges whether or not you should be allowed to go out in public and do anything that you want to do. The point is, when you make those public appearances, you don't bring your own security guard, do you?
I bring my husband for the 100th time.
Yes or no? You don't bring
I
a
bring my
security guard.
husband. My husband is my security guard.
Okay.
He is
That
safe.
your husband, you don't bring a security guard, right?
Typically, no, because I cannot afford that.
Okay. And on the day that you were court ordered to have your deposition, you appeared publicly in Savannah, Georgia in an outside restaurant, right?
It was like I didn't tell people that I was there.
Well, you posted a picture about it, and you posted a picture saying that you were eating and drinking your way through
I posted-
Savannah after standing your ground and not showing up for your deposition,
I
right?
posted pictures the next day after I was in Savannah.
Okay. And you described the trip, and there's no security with you when you went out to eat after your deposition, right?
There was my husband who was armed.
Okay. Other than your husband, there is no security guard with you at this restaurant where you went to celebrate not showing up for your deposition.
I didn't think we were being followed, and I'm curious now if we were.
That is not the question, Miss Matney. The question is, when you went out to celebrate and eat and drink after the deposition was supposed to take place, you didn't have a security guard with you, did you?
I had my husband, who I believe is just as good as a security guard. And we had a security guard at that location that day.
You publicly referred to it as a deposition standoff, correct?
Yes.
Okay. And you posted these pictures celebrating that you were standing your ground, right?
Yes.
And since March 27th, you have continued posting from
public places, like public restaurants and public bars, correct?
Not posting from, you really, please do not mischaracterize me. I do not post from places. I post after the fact. So that's a huge difference.
And you have gone online before both the May 15th hearing and this June 22nd hearing and asked as many people as possible to come to crowd this courthouse, correct?
Yep.
And you did that to have, so that you would have supporters here, right?
Yes.
And you weren't worried about the number of people or even who you were drawing as a crowd, were you?
Because I have security here.
Okay. And so you wanted as many people as possible to attend today, correct?
Because I have security here.
But you realize that those posts where you're inviting people to come alert people to where your location is and when you're going to be there, to the date and to the time of this event, right?
Objection, Your Honor. There's no real question here, and court is a public docket, so I don't understand what she's driving at.
Your Honor, it's clear that Ms. Matney is not afraid of being in large crowds or afraid of being in South Carolina as she's testified, because she's asked as many people as possible on the internet to come to her hearing, alerting them to her date, the time, and the location of where she will be.
Yeah, I understand. Let's move along on
Okay.
that. I got the point.
All right. Thank you, Your Honor. Ms. Matney, when you filed your motion to quash on November 25th of 2025, you did not identify a safety concern in that affidavit, did you?
I don't believe so.
And you did not mention any type of security concern until after both of your legal arguments had failed and you were ordered to attend a deposition. Isn't that right?
After both of during that time period, though, there was escalating posts from a felon who was threatening to show up at my deposition. I feel like that's absolutely relevant and someone who I am afraid of and did not want to be around.
And I'm assuming, referring to a man named Mr. James Seidel, is that correct?
Yes.
Okay. And Mr. Seidel has never called you on the telephone, has he?
I don't believe so.
And he's never sent you a text message, has he?
I don't know.
You've never even spoken to him, have you?
No, I try not to.
Okay. He's never shown up at your house, has he?
I hope not.
Are you aware of any instance where he has?
I fear that he does all the time.
But are you aware of an instance where he did?
I'm not.
Okay. And you've never taken out a restraining order against Mr. Seidel, have you?
I filed a police report and in the process of a restraining order.
And what process are you in?
In the process of filing a restraining order.
Okay. But you had this concern since last year and you haven't filed for a restraining order yet?
I know a number of women who have gotten restraining orders and ended up murdered after getting restraining orders. So I don't really believe that it protects you a whole lot.
Ms. Matney, the fact of the matter is, Mr. Seidel has never threatened your safety. He's never threatened you. And it has nothing to do with your failure to appear at your deposition. Isn't that right?
That's not a fact.
You posted, in fact, on February 5th of 2026, 7 weeks before your scheduled deposition, that you would rather go to jail than show up for your deposition and have to spend time with myself or Mr. Moore. Isn't that right?
It's kind of a joke, but yeah.
You said that, right?
It's a joke.
You've also posted that you hate our legal system, correct?
I don't know what that had. I hate our legal system. I want it to be better.
Those are your words, Miss Matney. You said,
Sure.
I hate our legal system. Did you say that?
I can be upset sometimes and say I hate a legal system, but I also respect it and respect the people in it, especially the people that are ethical and do the right thing every day. I
Ms. Matney,
work with a lot of those people.
You have described being subpoenaed for a deposition as being punished by the judicial system, correct?
Being subpoenaed for a deposition in a case that I believe I don't have any part of, yes.
Yes, you described that as being punished by the judicial system, right?
Yes, you have to take off work. You have to, it's awful. Yeah.
And you wrote that you would never stop exposing what you called the evil in the system, correct?
Correct.
And you've referred to people involved in this case as dumb old men, right?
Maybe, I don't know.
Okay. You have publicly criticized Judge Kelly since this last hearing, since the May 15th hearing. You said that he failed to acknowledge your attorney's legal arguments. Do you remember that?
I don't know if I said that. I was very confused that that we did not get any clarity on my attorney's legal arguments. And I believe that I had the right to exercise my First Amendment rights to talk about that. And again, with the restrictions that I had to not talk to my attorney, I did not believe that there was anything wrong with that.
Ms. Matney, during the Cup of Justice episode number 180, you said in describing these proceedings to your followers that Debbie stood up and said, like, pounded her fist. Me, me, me. She did not have the law to argue with. She did nothing. And what did the judge do? The judge didn't even acknowledge why they didn't have to have an affidavit. He didn't even acknowledge Becky's very, very sound and full of logic argument based on the law. He just moved on. Are those your words?
I don't know if those are my words or Liz's.
Okay. But you have a video of the May 15th proceeding, and you are aware that I've never pounded my fist in the courtroom.
I think pound your fist is more of a expression.
It's an expression, but it didn't happen. It's a false characterization and a false narrative of what occurred in that court proceeding, isn't it?
I don't know.
Well, you have the video. Is there any video of me pounding my fist?
It's an expression of when you don't have the law, you pound your fist.
That you weren't really being accurate. You were just using expressions.
I think they know when I'm using expressions.
Okay. You also said you blamed Judge Kelly for not going to the deposition because he didn't file his order fast enough denying your emergency motion. Do you remember that?
I believe that mischaracterizes. I believe that I said that I wanted clarity on the location of my deposition. All I wanted was for my deposition to be held in a safe place, and I was asking the court to do that. I did not want any of this to happen. If a court order was filed that morning that any one of us saw, we would have gone to that office. We were ready, willing, and able to be, I was ready, willing, and able to be deposed. I don't know,
Ms. Matney, did you or did you not say that the reason you didn't show up is because Judge Kelly didn't communicate his order fast enough?
I would have liked a communication. I did not say that's the reason I didn't show. Again, I believe that you're mischaracterizing my words.
Okay. Well, in Cup of Justice number 180, it says, it's at the heart of this whole thing. He, and you're talking about Judge Kelly, signed this thing on the day of your deposition and didn't file it till Monday. And no one on Friday knew that he had ruled on Mandy's emergency motion.
That could have been me or Liz. I'm not sure.
Okay. But you agree that you were discussing the rulings of this court while you were a live witness?
Objection, Your Honor. This is public filing. It is a statement of fact, and it is in the record that your order was signed at 7:26 in the morning on March 27th and was not circulated on the public index until after 1 o'clock the following Monday.
Your Honor, that doesn't have anything to do with my question. I mean, I'm asking Ms. Matney, she says she has respect for this court, and her statements on her podcast clearly demonstrate she doesn't have respect because she's creating a false narrative with the public about what actually occurred and what rulings have taken place in this proceeding.
How is it false, Your Honor? That is literally what's on the multi-court index.
Well, let's move along on relevance there. Just move along.
You also said, Ms. Matney, thank you, Your Honor, I will, that this judge allows Parker's lawyers to lie in the courtroom and that his rulings make you think he doesn't understand what's going on. Is that right?
I don't know if I said that or Liz. I don't know.
Okay. And you said that Judge Kelly either doesn't get it or he's on the wrong side of this. That was in Cup of Justice number 170. You recall that?
I don't know who said that, but I have felt that at times.
You said that he's letting you be bullied and humiliated in court. Is that right?
Yes.
Okay. And you don't like that, do you?
Don't.
And
but
so
can I
openly criticizing these proceedings and while you're a live witness, is that right?
I was never told that I could not do that. And I think there's a big difference between respecting the court and criticizing it. By criticizing the court, you want it to be better and you want to share your experiences with the justice system so it's better for everyone.
Respect for the court includes complying with court orders, and Judge Kelly ordered you not to speak about this case. And you failed to do that.
Characterization of testimony.
Counsel,
Your Honor, she keeps saying that she has respect for this court and that she has respect for this court's orders, but everything she says and everything she does from October 14th, 2025 onward demonstrates she has zero respect for this court, zero respect for these proceedings, and that she has taken this dispute, escalated it, and monetized it for her own financial gain.
I understand where you're going with that. I get it. Okay, but let's get
Okay.
back to the
I'm
point.
almost finishing up, Your Honor. Ms. Matney, you have covered, according to you, courts and legal proceedings for over the years, correct?
Yes.
And you've already admitted under oath that you knew what a subpoena was, right?
Yes.
You've already admitted under oath that you were represented by counsel throughout this whole process, right?
Correct.
And you admitted that you knew that you filed a motion to quash and that motion to quash was denied, right?
Objection, that was again mischaracterization. Debbie, are you talking about the motion to quash where we had oral arguments in November and then the judge ruled on it in February?
Your Honor, it's very simple. She filed a motion to quash her deposition subpoena in November of 2025. We did have oral argument. We ruled on it. I feel like her objections are trying to coach the witness.
Well, let's just move along on this issue because I got that.
Okay. Ms. Matney, is it correct that you understood that your motion to quash and your motion to reconsider had been denied?
You're going to have to redefine when. At what point?
When they were denied, the day these orders came out, was it communicated to you that you lost those arguments? You've already admitted under oath that that's the case.
Okay.
Are you going to change your testimony?
No.
Okay. Now, you also admitted under oath that you understood the court's rulings. You recall that?
Yes.
Okay. So nothing in any court order permitted you to choose your own deposition location, did it?
Objection, calls for a legal conclusion, Your Honor.
Counsel.
Are you aware of anything in either of the court's orders that allowed you to choose your own deposition location?
Objection, again, it's argumentative, Your Honor, and the flip side of the argument could be argued of there's nothing prohibiting parties from agreeing to change the location.
I understand that, but she asked a question. Is there anything in the order?
Say that again.
Was there anything in either of the court's orders denying your motions that you thought allowed you to choose your own deposition location?
I don't know. I don't know because I just remember seeing emails between y'all and my attorneys about the location afterwards. So I just assumed that the location was up for choosing.
Okay. I didn't ask you that, Ms. Matney. What I asked you is, in either of the court orders that this honorable court issued, is there any language in those orders that allows you to choose your own deposition location?
Objection, Your Honor. Again, I believe the orders have been admitted. It is the court record. I don't see what the point is asking about the contents of an already admitted filing.
Well, it's overruled. She's asking her about her understanding of it. Go ahead.
Can you ask that again?
Ms. Matney, is anything in the language of the orders that the court issued regarding denying your legal motions? Did any language in those orders allow you to choose your own deposition location?
All I remember is they said within 14 days to be deposed.
So are you claiming that you don't know?
I would
What's
have to
your
look.
answer?
I would have to look at it.
Okay, we can arrange that. So Ms. Matney, just to be clear, as far as the day of the deposition that it was supposed to take place, you had transportation available to you to attend your deposition, right? We've already covered that.
Define transportation.
You had the ability to get to the office where the deposition location was noticed, right?
Correct.
You could have gone, right?
Correct. And the other side could have gone to our office as well. And I also believe that I was told the attorneys were supposed to not burden non-parties in situations like this and accommodate them. And I believed that your team would have respected my right to feel safe and would have, and you guys wanted information from me. I, again, thought the best solution, I came up with the best solution. I was willing and able to be deposed at my attorney's office in a place where I felt safe. And I never got a reason from Team Parker as to why they did not want to do that.
Ms. Matney, you weren't hospitalized that day, right?
No.
And you weren't incapacitated, right?
Objection, Your Honor, asked and answered. They relied on the rule to show cause, direct, which all these questions were asked at that time on April 7th.
Yeah, let's move along about that.
Okay. Ms. Matney, isn't it correct that on February 5th, well before you raised a safety concern to this court, that you publicly stated you'd rather go to jail than attend a deposition with opposing counsel?
Objection, asked and answered, Your Honor.
Are those your words, Ms. Matney?
I believe that's true.
Yeah, I believe
You said that, didn't you?
as a joke.
You made a decision.
Again, Your Honor, we have an open
Let's move
objection.
along.
Okay. And you made that decision and you followed through with it because you simply decided you weren't going to obey the court's order.
That's
Is that
not
right,
true.
Ms. Matney?
That's not true.
Beg the court's indulgence. Your Honor, I would ask that during the lunch break, Ms. Matney be asked to review those notebooks. We'd like to put them in evidence. And I believe I'm almost done. If we could hold it open for her to have reviewed them. She claimed she didn't have enough time during the break.
I'll take that under advisement.
Your Honor, I don't have any further questions. I'm just asking to keep it open for that limited purpose of admitting those notebooks of her excerpts of her podcasts and her social media posts.
Okay, it's under advisement.
Thank you, Your Honor.
Counsel, anything?
Are you asking if I have an objection to keeping testimony open to allow her to review, or if I have redirect?
You have any redirect?
I do have some redirect, Your Honor. Question to approach, Your Honor?
Yes, ma'am.
This could be identified as argument.
You have a copy for us, Ms. Van?
Yeah, I can do it.
Why don't we just do this? He thinks there's a 36. Why don't we just start it at numeral 50? How about that?
Recognize this?
Yes.
What is it?
Is this the court order or is a subpoena?
For what date?
It does not say the date and time.
If I may, if you could look in the center page.
Oh, sorry. I was looking at the bottom. Place of deposition, Joan Simpson in Newton, 7 Plantation Park on March 2nd at 10 a.m.
I would move non-party Matney's exhibit. No objection. Your Honor.
Without objection.
Yes. The subpoena.
And is it for this case?
I believe so. Yes.
And what is the place of the deposition?
And I need to also point out my address is wrong on there. Joan Simpson and Newton. And then the time is March 23rd, 2026 at 10 a.m. Yes.
Non-party Matney moves in exhibit.
Any objection?
No, Your Honor.
Without objection.
Simply hold this non-party Matney exhibit. Do you recognize this?
Yes.
What is it?
It's another subpoena in this case.
And what is the location?
The location is Joan Simpson and Newton. And the time and date is March 27th at 9 a.m.
I move non-party Matney's exhibit 52. No objection, Your Honor.
Without objection.
We can label this non-party Matney's exhibit 53. I am showing you a certificate of electronic notification. Can you read what time it indicates it was filed?
March 30th at 1:01 p.m.
And do you know what this is regarding?
This is my motion, my emergency motion and the response to it, I believe.
So this is court order denying.
Yes, this is the court order. Yes, which is days after my deposition. Supposed to.
I would move non-party Matney's exhibit 53.
Any objection?
No, Your Honor. No objection, Your Honor. It's a matter of the public index.
Without objection.
Label this non-party Matney's exhibit 54. Your Honor, I'd object to this and I'd ask what the relevance is. It's an affidavit of a third party that has nothing to do with this contempt proceeding.
What's the relevance?
Your Honor, it was an exhibit provided during the deposition, and it was also a disclosed fact where Ms. Vicky Ward states that she got the photos in real at issue from a grave building. Your Honor, You've already ruled on this in the May 15th hearing, and you sustained it. And it has absolutely zero relevance to this contempt proceeding.
What's the relevance to the contempt?
To the contempt, Your Honor, is to go that they, to prove the undue burden and that Parker's defendants have been acting maliciously and not in good faith in abusing the court process to harass Ms. Matney when they know in good faith that she was not the one who disclosed the pictures.
We're not here about the disclosure of the picture, here about contempt and sustained.
Were you aware of the word statements for Parker?
Objection, Your Honor, relevance.
Listen,
And hearsay.
I'm not here about the pictures. I'm here about the contempt.
correct. And her knowledge, if she had it prior to March 27th, would go to inform her belief in actions and interpretation of it.
Your Honor, Ms. Ward's affidavit has nothing to do with her decision to not attend her deposition and ignore a court order.
So what did it have to do with her not being there? I mean, she's admitted she was not there.
Correct, but we have to, we don't have to show. And if Parker has to show that it was a willful violation, meant to inflame and disregard the court's authority, which goes directly into the impact and effect on the listener and the present sense impressions of what she knew and had heard and believed at the time that she had made clear she was available less than half a mile away for her deposition.
No, ma'am, I don't think so. Move along.
His label, non-party Matney, 55, 56, and
Your Honor, I object to this exhibit. It has no relevance to this contempt proceeding as well. It has, there are pleadings that are filed in this case where the non-party Ms. Matney talks about her belief of, the merits of the case. Has nothing to do with her decision not to attend her deposition or to disregard court order.
Your Honor, that's a mischaracterization of this filing. It's an admission by party opponent, and they're certified self-authenticating, self-proving documents. And in this argument, Parker's defendant was on the receiving end of a rule to show cause, seeking sanctions and contempt. And in these filings, Ms. Barbier, as well as Mr. Moore, on behalf of their client, state that lacking an affidavit in a rule to show cause hearing causes the complete rule to show cause to fail in its entirety. We would offer these as a statement by party opponent showing inconsistent argument, and it's essentially a sword and shield argument. They earlier in this case have argued one thing, and now they're flipping it, having not filed the affidavit and are arguing.
Your Honor, this took place in a different case, in a case that stayed in 2021. And it has, Mr. Moore and I are not the counsel of record, it's Mitch Griffith. And it has nothing to do with the contempt proceedings today.
Yeah, it has nothing to do with the contempt proceedings at all.
It does, Your Honor, because again, it is the defendant Parker's statement by previous attorneys, and it is a mission by defendant Parker that not having an affidavit for the rule to show cause causes it to fail ab initio.
Okay, that's a matter of law and it's overruled. I mean, it's sustained. We're not coming in.
Mandy, do you live your life on the internet?
No,
Is everything that we read on the internet real?
no,
So sometimes are your posts made at different points of time than the reader is led to believe?
they almost always are.
Did you willingly have your deposition taken?
Yes,
And after the March 27th deposition, where you made it clear where you would be and defense counsel failed to show up, did you reach out to defense counsel to reschedule the failed deposition?
my counsel reached out several times, offering, I believe, we even offered a Sunday. Mark Moore said he couldn't do it. Several courthouses we offered. We're really trying to get it done.
Did you also offer Columbia?
Yes,
Did you offer not your attorney's office in Columbia?
I believe so. Yes.
Did you offer Charleston?
Yep.
Did you offer Bluffton again?
Yes.
Did you offer Savannah?
Yes.
Did you offer Charlotte?
Yes.
And at any point, were these offers accepted?
No.
And so after the failed deposition, what was the next communication you received from defendant Parker?
I believe that we were summoned to Gaffney for a hearing. I don't remember.
Right, no further questions.
Anything at all?
Ms. Matney, your counsel just entered into 3 subpoenas for your depositions. Is that right?
I believe so.
Okay. And the first subpoena is dated March 2nd. The date and time for the deposition notice is March 2nd, 2026 at 10 a.m., correct?
Correct.
And the place of the deposition is Jones, Simpson, and Newton, PA, 7 Plantation Park Drive, Bluffton, South Carolina, 29910. Is that right?
Correct.
Okay. The next subpoena is noticing it for March 23rd, 2026 at 10 a.m. And it's the very same location, correct?
Correct.
And your lawyers did not object to this location when this first March 2nd subpoena was issued. Is that right? No objection made to that location, right?
I'm not sure.
Well, are you aware of one?
I just don't know. I would have to look at the court filings of what was going on at that time and what
Are you or are you
what
not
motions we had going.
Are you or are you not aware of an objection that was made by your lawyers to that location at that time?
Objection asked and answered, Your Honor. She already said she doesn't know.
Answer it one more time. Go ahead.
Was I aware?
Were you aware of an objection made to that location?
I don't know.
Okay, well, did you tell anybody you can't do it at that location?
Yes.
Did you tell them that?
I
on the
believe
day
that
of
would be
this-
attorney-client privilege.
On February 10th, did you or your lawyers make an objection to this location?
I don't know.
And then when your lawyers objected to that date and time because of their schedules, the subpoena was reissued for March 23rd, 2026 at 10 a.m. Do you recall that?
Yes.
And it was for the exact same location, again, to which there was no objection made, right?
Yes. I believe. I don't know.
Then again, your lawyers had a conflict. And so in order to accommodate your lawyers' schedules, we agreed to do it March 27th at 9 a.m. at the same exact location. You recall that?
I believe so. I don't know.
Okay. And Ms. Matney, you would not dispute, because there is absolutely zero record of it, that there was never an objection to that location until just a few days before the deposition.
I don't know, define a few days. I don't know when. It was when
That week, the week of the deposition, your lawyers suddenly objected to the location. You recall that?
yes,
And then do you recall that we offered an alternative location in an office building where there's security at the bottom and no one can get up on the elevator without being admitted through the security at the bottom of the building? And that was in Columbia. Do you remember that offer was made?
yes, there was something wrong with it, with security wise. And also, I knew that I had the right to be deposed in my own county, and I stuck with that.
So you would agree with me that you declined to go to the building where they had security at the bottom of the building where nobody could get up on the elevator without permission, right?
I don't know the details. I just remember I did not want to do that. I did not feel safe doing that at that location, and I can't. But again, we offered a number of locations.
And one of the locations you offered was at your co-podcaster's building, Mr. Bland's office, correct?
Correct.
And they don't have security at his building at the bottom. He just is in an office building, correct?
We would have brought security.
But that building itself didn't have security, did it?
I don't know, but I feel very safe with Eric Bland around.
We also offered to have your deposition in Bluffton or Hilton Head at a hotel. And the hotel would have had security, and you declined that offer too, didn't you?
You said that I would have to pay for it, which this is your case. And so I thought that was ridiculous. And
No,
I
Ms.
thought that
Madden.
was abusing the process.
In fact, we offered to split the cost of that if you all are agreeable to changing the location to there. And you declined that offer, didn't you?
Should I have to pay for being deposed? I mean, I'm paying a lot already.
No, Ms. Matney, but what you should have to do is, like everybody else, follow the rules and follow the court orders. And when you're ordered to show up for deposition.
Objection. This is testifying.
Let's don't get into making statements. Anything?
One more thing, Ms. Matney, this other exhibit that your lawyer entered into evidence, which is the notice of when Judge Kelly's order ruling on your emergency motion came out, which was 3/30/2026. Do you recall that?
Yes.
Okay. And so this goes back to when we were talking on your cross-examination about the fact that you blame Judge Kelly for not coming to the deposition because he didn't rule fast enough for you, did he?
I did not.
Objection is beyond scope of redirect, asked, answered.
Let's move along.
You entered this, your lawyer entered this as an exhibit to show when Judge Kelly ruled on your emergency motion, correct?
But you mischaracterized what I said. I said that it was a confusing situation because we had no court order on that morning. And
Ms. Matney, you had no order excusing you from attending that or for mandating you to attend that deposition on March 27th at 7 Plantation Park Drive in Bluffton, South Carolina, did you?
I did not know what it meant when we had a pending motion, emergency motion.
Well, you covered the court system and you tout yourself as somewhat of a legal expert. And you're aware that if a judge has not ruled on a motion, you don't have the authority or the right to ignore the existing orders.
I wasn't,
You know that.
I
Ms.
was
Matney.
not ignoring the existing orders, and I did. I talked to a lot of lawyers about this situation, and nobody had heard of a situation where defendants such as yourselves were making it so incredibly difficult to agree on a location. And I felt unsafe the more that you guys doubled down on that certain location. And I feel like I have the right to say that I felt unsafe.
And you felt like you had the authority to ignore the authority of this court. And that's what you did, right?
Incorrect.
Nothing further.
Okay, that's it. Thank you, man. You may leave the witness stand. Let's see the lawyers at sidebar. 1:15 promptly, 1:15, everybody. If you want to be here, 1:15.
Your Honor, if I may, Ms. Matney is released and she is.
Ms. Matney is released. She's off the stand. You talk to whomever you want. Okay, 1:15.
Thank you, Your Honor.
Thank you.
Thank you. Tell us your name for the record, please.
Eric Bland.
Thank you. Counsel.
Thank you, Your Honor. Eric, what do you do?
I am an attorney, mostly a civil attorney, but I do criminal law. Probably about 10% of my practice is criminal.
How long have you been a civil attorney?
38 years.
Where did you go to undergrad?
University of Tampa,
And where did you go to law school?
University of South Carolina,
And what year did you graduate?
1988.
And what bars are you a member of?
South Carolina, Florida, and Pennsylvania.
And are you familiar with the Murdoch case?
Very familiar.
How so?
I'm going to object. The Murdoch case is not at issue today. We're in a contempt proceeding. So I would say that's not relevant.
Your Honor, all of this rises up and out of the same thing, and it goes to the willfulness and perception as well as his relevance to the podcast, the parties, and being harassed by Mr. Seidel as well.
Okay, well, let's get right to those points. How about that?
I represented 6 of Alex Murdaugh's financial crime victims. I also participated as a de facto spokesperson for the prosecution during the murder trial.
Do you represent Sandy Smith?
I do.
Counsel, hang on one second. Law clerk says that you're not being heard on the WebEx. You want to get to a microphone?
Do you represent Sandy Smith?
I do.
And what do you represent her in regards to?
Actually, Your Honor, elements.
Okay,
I'm getting there, Your Honor.
we'll give her a little bit of leeway. Go ahead.
I represent Sandy Smith, who has lost her son, Stephen Smith, as a result of him being killed on July 7th, 2015, and her quest to find out what was the cause of his death in the ensuing years.
And have you ever had any contact with James Seidel?
Yes, one phone call. He called me on the phone and said that he believes that he can solve the murder or death of Stephen Smith. I, talked to him for a little bit and I said, look, I'm not law enforcement. I'm not a criminal investigator. We have, at this time, a reward. SLED is being the one who's obviously the investigative agency in charge of this, and call him on the phone and see if you can qualify for the reward. We'd love to solve his death.
And is there a reason you were gatekeeping Sandy Smith?
Yeah, I mean, there's a lot of people that have tried to use her or get to her to manipulate her, exploit her, or use her for their own commercial purposes. And, she has had threats. She's had different things. And that's what a lawyer does. They protect their client, and people have to go through their lawyers.
Are you aware of anything happening with Stephen Smith's personal electronic devices?
Your Honor, objection. Relevance. Nothing to do with this contempt proceeding.
What's relevant to about the contempt?
People supposedly helping Sandy Smith and holding themselves out as investigators came to her house, said they would solve the murder of her son, and never and just took the electronics and never supplied them again.
Okay, and what relevance is that to the contempt?
Because again, it shows ongoing harassment as well as the need to be careful about surroundings and interactions with others.
Let's get to surroundings about Ms. Matney. How about that?
This is part and parcel with Ms. Matney.
Move along.
How'd you meet Mandy Matney?
I met Mandy Matney in September of 2021. Mark Tinsley called me on the phone and asked me would I want to get involved in consulting with the family of Gloria Satterfield, who was the former housekeeper of Alex Murdaugh. She had died at Mizell, or as a result of a fall in Mizell in February of 2018. And Mark called me on the phone and said he got contacted by the family as a result of Mandy writing an article for the Island Packet News. She had investigated the court records, and there was a petition to have the court approve a $500,000 settlement in connection with her death. Mark called me on the phone and said that the family had said that they hadn't gotten any money and would I consult with them? And of course I did. As a result of that, I was retained and I filed a public lawsuit in connection with that because I did not get an appropriate response from Alex Murdaugh's law firm or Corey Fleming's law firm in connection with the $500,000. At the time, Mandy was a reporter and also was a co-host of her Murders podcast. And so she called me on the phone and we struck up a professional relationship.
When was that?
It was in September of 2021. I was very concerned as to why law enforcement was not more interested in the.
This has nothing to do with the contempt proceeding. Here to talk about the Murdaugh saga.
Again, back to Mandy, please.
And so you've known Mandy for 5 years?
5 years.
At some point, did your relationship turn professional?
Yes. We developed a professional relationship that evolved between a reporter and a lawyer over a 4-month period of time, which it evolved after Alex was criminally charged and she was reporting on it. And then she gave me a platform because it was very important for me, I believe, to get the story out about Alex Murdaugh's financial crimes. And so I had significant relationships with the press, with John Monk, who's in the back of the courtroom with a lot of national.
This is commentary about something that has nothing to do with this proceeding.
Counsel.
I cannot control Mr. Bland, and I am sure many a woman has tried in their life to do as
Okay,
well.
here's what we're going to do.
I am asking questions.
I want to get to the contempt itself. I don't care anything else about Murdaugh. I don't care anything else. Get right to.
After our relationship of lawyer to reporter, she asked me with David Moses, her husband, whether we would be interested in doing a podcast called Cup of Justice. I came up with the phrase a cup of justice when I argued a motion in the Murdaugh case, and that's how I came to work for Lunashark Productions.
All right, and so you have a podcast with Ms. Matney and Ms. Farrell.
I do.
As a result of your work as a podcaster, have you ever experienced online harassment?
Oh, yes.
I'm sure it's very interesting as far as what online harassment Mr. Bland has received, but it has no relevance to this proceeding.
We'll give a little bit here because go back to Harrisburg. Go ahead.
I have. I've had single shot people say things and harass me. I've had people come up to me and, say some untoward things. But particularly as of late, there's a gentleman named Jim Seidel who seems to have taken it on himself to harass me almost on a daily basis. And I'm pretty much okay with that. But he's also harassing my client, Sandy Smith, which I'm not okay with.
And when you say he's harassing you, what form does that take?
Well, he took my name and likeness and my photograph and put his book in my hands and used it for commercial purposes as if I was promoting his book. He then started mocking me on things that I say on my podcast. And instead of using my voice, he'll put his voice on my photograph or the video. He has tried to humiliate me, and he's filed to date, I think, 18 bar complaints against me.
And has he ever been a client of yours?
He has never been a client of mine.
And have you observed any harassment towards Mandy Matney?
I have. He has mocked Mandy. He has mocked Liz. He has accused them of not being journalists, of not being investigative reporters. And I have witnessed their reaction to him because I've been in the room when they have seen the online harassment that he's done, and they have genuine concerns for their safety. He's unhinged. He's a convicted felon who has a very, very dubious background.
And in regards to your harassment, would you classify as harassment?
Oh, there's no question about it.
Has he ever showed up at your house?
He has not.
But you would classify his behavior online as harassment?
Yes.
Going back to your work as a civil attorney, have you ever had a deposition not go on the day it was supposed to?
Sometimes, I mean, it depends if somebody gets sick or there's scheduling or weather difficulties, and you work out with the opposing counsel on rescheduling or where it's going to take place or how long it's going to be, what time of the day it's going to start, those kind of things. Lawyers, work it out together. Judges, with all due respect to you, Judge, they don't like to manage litigation, and they want lawyers to cooperate, and we have a duty to cooperate with each other.
And how many depositions would you say you've taken in your career?
Thousands.
And have you ever seen the first date of a missed deposition go immediately to a rule to show cause?
No, I have not. I have not seen anything like this.
I'm objecting. If he's going to be testifying as an expert witness of such, first of all, we were given no notice of this, we've been given no expert disclosures, no expert report, nothing about his conclusions beforehand. And there's been no proffer of him as an expert, and we would object to that.
Your Honor, this goes into the reasonableness and the fact that Ms. Matney is being treated very differently than actual parties to this case and differently than very often similarly situated deponents. Further, it goes into her reasonable fear and repercussions and willfulness.
Well, we already talked about the reasonable fear. I've already heard that, and I heard him say it too. I'm focusing on Ms. Matney, okay? Like him, I got 38 years at the bar.
Did you ever have a discussion with defense attorneys, Parker, about Ms. Matney's deposition?
Not with all of them, but I did with Mark Moore. We had a case, I think it was in October, Mark, or it was a mediation. I was at his law office, and it was at one of the breaks, and we start hearsay.
By party opponent, Your Honor.
It's his lawyer.
But let's hear what Mr. Gwynn has to say.
Go ahead.
And I said, Mark, I hear you're kind of going at it with Mandy Matney. You want to depose her. I said, can you just turn it down a notch, lay off? And he said, no.
Did you say why?
No.
Questions, Your Honor?
Sure.
Mark does not believe that means exhibit 50.
Your Honor, we object to this exhibit. This is a letter from Ms. Lindell, Ms. Matney's attorney. To Ms. Lindell from Mr. Moore. It has no relevance at all to Mr. Blanchard. He's not a counsel of record in this case that I'm aware of. And I don't know how he could testify about a letter that he's not a party to.
What's the purpose of the letter?
The purpose of the letter, Your Honor, is that it's dated March 21st, 2026. And it is from defense counsel talking about arranging this deposition. It's not been admitted to the record as it is a letter. However, in it goes on to say, regarding Ms. Matney's fee for compiling documents responsive to the subpoenas, please inform us as to your source for your assertion and reasons for your belief that the Parker's defendants have agreed to compensate fact witnesses by the hour for their efforts to comply with subpoenas issued by the Parker's defendants. As you will recall, we discussed on May 15th about the Callie Lyons deposition, which occurred March 4th, 2026, in which she was paid $8,700 for the text messages of which she was not a party to. And the letter goes on to state there's no justification or authority for why the Parker's defendants are obligated to pay a third party a fee to comply with a subpoena. And it certainly does not set forth any justification or authority for your assertion that Ms. Matney should be compensated at a rate of 5 times an approximate of what she earns per hour for her alleged journalism work. Further, it goes on to state that Ms. Matney's witness fee for her deposition attendance will be paid in accordance with the fees pursuant to Rule 45, which was not tendered with the subpoena or at any point during this case. Further, it goes on and says, with respect to your request that we conduct this deposition at a place of Ms. Matney's choosing, we are not aware of any authority that supports your request. Given Ms. Matney's various internet postings about her frequent travel, we do not believe her stated security concerns are legitimate or meritorious. In sum, finally, as
She's just reading it into the record. I don't understand what it has to do with Mr. Bland.
I don't know.
all right, then we would just move to admit this into evidence without Mr. Bland.
We object because there's no authentication of it, there's no foundation for it, and there's no relevance of it.
It's not relevant. I'm trying to get to what her thought process was.
It is completely relevant, Your Honor. This letter occurred 6 days before the deposition. It goes to show that Parker's defendants state that they did not pay any witnesses. The same witness that they changed the state of the location of the deposition, as well as allowed for it to be remote. And they're saying this did not occur. As Your Honor has heard and this court has received testimony, we know that is not true.
Okay, make it a court's exhibit, not an evidence.
This witness has no firsthand knowledge of any of these events.
Right.
And it's completely irrelevant.
Make it a court's exhibit.
Your Honor, I would then.
Hang on, please. Hang on, please. Let me get. Thank you.
Your Honor, I would ask that Defendant Parker stipulate to the authenticity and admission of this letter. It's their statements. It goes to Ms. Matney in our understanding at the time of debating where the deposition was happening, when it would happen, what was going on, and material misrepresentations by defendant.
They don't have to stipulate to it. It's a court's exhibit.
Mr. Bland,
Yes, ma'am.
have you seen Ms. Matney be afraid of her safety?
I have. I've watched personally when people come up to her. I saw it at the trial, how nervous she gets. I have personally read so many heinous postings that people have said about her, and I'm sorry, I apologize, Mandy, about her vocal fry, her voice. They have body shamed her. They have mocked her. They have insinuated that she's just a blogger and not a serious journalist and reporter. Said personal things about, her like of Taylor Swift, and somehow that makes her less serious. Mocked her love of dogs. I mean, it has been nonstop against her, and to a lesser extent, Liz. And it's abusive. If it was done to my wife, I would, I would feel for her in a way that I see David do it. It's disgraceful.
In the week prior to March 27th, did you see any intensification of Mr. Seidel's actions geared toward Miss Matney?
I did. It was not only to me, it was to her. It was daily postings, mocking her positions that her lawyers were taking in connection with her being deposed. She was under a lot of personal strain, a lot of financial strain that I was aware of because of this. And she never wanted not to have her deposition taken. She just wanted to have it taken at a place where she could feel safe. That's her right.
If she was your daughter, would you have advised your daughter to go to this deposition at this location?
No. And if she was my client, I would have done exactly what her lawyers did too. We owe a duty of 100% fidelity to our clients. Our duty is to make sure that our clients are safe and secure. And she was not. She voiced it. And I think her lawyers were entirely reasonable in trying to work with the.
He does not have the basis or the foundation to issue an opinion on this. He's not an expert witness in this case, and it's not relevant.
Counsel.
Your Honor, this all goes to reasonableness, and Defendant Parkers have done nothing but scoff and minimize Ms. Matney's fear and real concerns about her safety. Mr. Bland is in a unique position as both an attorney and a podcaster with experienced similar harassment to give us his perspective.
He's given his perspective. He's not giving an opinion. Go ahead.
I think it was entirely reasonable to try to reach out to the other side to just find a location where the deposition could take place, especially because she's a non-party. As a non-party, your goal as a lawyer is just to get the information you want. And it seemed to me that this is spun out of control, that it was no longer a pursuit of the information, but people dug their heels in.
No further questions.
Thank you. Counsel.
Okay, please report.
Yes, ma'am.
Mr. Bland, you said you've been licensed to practice law for 38 years. Is that correct?
I have.
Okay. And so you are very familiar with what a subpoena is, correct?
I am.
And we've had 3 subpoenas entered into evidence during this hearing. And I'll show you those. Matney Exhibit 50, Matney Exhibit 51, and 52.
Thank you.
You see those exhibits, Mr. Bland?
I do.
You see, first of all, your understanding as a lawyer and an officer of the court is that a subpoena is a court order, correct?
Objection, Your Honor. What's good for the goose is good for the gander. She's asking for a legal opinion as an expert.
He can answer because he knows what it is. Go ahead.
Lawyers are licensed to issue subpoenas as court officers, and they are legally binding documents.
They're court orders, aren't they?
It's one way to say it, but yeah, we have the right to issue subpoenas as if we are a court officer.
Okay. And as an attorney, you're aware of the significance of a subpoena, correct?
Yeah, it's a serious document.
And as a lawyer, you have an obligation to tell clients to comply with court orders, don't you?
Absolutely. If there isn't a reason to question it or ask that it be modified or work with opposing counsel, but yeah, on its face, it's a legally binding document. But lawyers all the time, Ms. Barbier, talk. And just because a subpoena is issued or a deposition notice is issued, it's always with the understanding that lawyers will call each other on the phone and say, that date is not convenient. The time is not convenient. The location is not convenient. We all work together.
And Mr. Bland, you understand from reviewing these 3 subpoenas and being in this courtroom during the testimony that these subpoenas were issued to accommodate the scheduling of Ms. Matney's attorneys, correct?
I didn't know that. I didn't know that. I'm not that involved in it.
Know that. Okay. Well, you understand that when a subpoena has been litigated and a court has ruled, a court has denied a motion to quash, that's an order that requires that person to appear at the deposition, correct?
Unless you have filed a motion to reconsider and the judge has ruled upon that order.
That's correct. And when a motion to reconsider is then denied and a subsequent court order is issued, that requires that person to attend that deposition, doesn't it?
It would unless there was another motion to reconsider filed.
Well, you only get to file 1 motion to reconsider under our rules, don't you?
No, I filed many
Okay.
for clarification on an existing order. If it's not clear or if there needs to be additional commentary by the judge or additional rulings, I've asked for clarification many a time.
Okay. And are you aware in this case that the motion to quash was denied and an order was issued requiring her attendance at the deposition? Are you aware of that?
I know there were a couple motions to quash. Again, I'm not into the details. I know there were at least 2 motions to quash filed.
And those motions were denied, weren't they?
One was denied earlier on, I think in 2025 or early 26, but I know that the one at issue was denied after Friday that she was supposed to appear at her deposition.
Well, you're correct, Mr. Bland. You're not familiar with the facts because in this case, a motion to quash was denied and order was issued.
Objection. This isn't a question. It is testifying.
No, it's going to end with a question. You let me finish.
It's beyond the scope of the witness's knowledge. He said that.
She'll be praised the question.
Mr. Bland, is it within your knowledge to know as an attorney that when there's an existing court order requiring somebody's attendance, that they are required to appear?
Unless they're sick or there's a legitimate reason that they can't. But yeah, under ordinary circumstances, people don't have a right to violate His Honor's orders.
That's correct. And Mr. Bland, you attended the May 15th hearing in this proceeding for contempt, did you not?
I did in support of my friend and co-host Mandy Matney.
Okay. And you understood that Ms. Matney took the stand that day and had her direct testimony, didn't she?
I think I only saw an hour of it. I left at lunch.
Okay. Well, when the hearing was over, did you understand that her testimony was not complete?
I knew that it was open,
You knew that what was over?
that her testimony remained open, that there was either cross-examination or further direct examination that needed to be done.
Okay. So you understood what we call in the legal world that she was a live witness, correct?
Correct.
She was still under oath, correct?
Correct.
And you understand from your knowledge of having attended multiple proceedings over your 38-year career in the law, that when a witness when court has to adjourn, that the court always instructs the witness not to discuss their testimony, correct?
With their lawyer.
Okay. Have you reviewed the transcript of the May 15th proceeding?
I did not. I heard you quoted today.
And so you're aware that Judge Kelly told Ms. Matney during the break not to discuss her testimony with a single soul. Did you see that?
I heard that.
Okay. And you don't question whether the transcript really reads like that, do you?
Judge can make any order he wants.
Okay. And you testified earlier that you're the co-host with Ms. Matney on Cup of Justice, correct?
I am.
And you're paid to do that, right?
I am.
How much are you paid?
Objection, relevance, Your Honor.
Oh, it goes to his bias and his motive, Your Honor.
Sure. I make my living as a lawyer, Ms. Barbier. I'm very fortunate and successful financially. I don't do this for the money. I get paid $1,750 an episode. I do it because I want to educate the public and assist in the listeners of True Sunlight and Cup of Justice. I feel that as a lawyer, I have a lot to give back. So I don't do it for the money. It's $1,750 for my time, which equates to my about $500 an hour, which I charge for my legal rates of how long it takes for us to prepare and do the episode. So yes, I get compensated.
And how many episodes do you participate in per month?
Usually 3.
So that's 3 times 750, 1750.
1250, excuse me. It's 1250 a month. I was mistaken. It's 1250
per episode?
per episode.
Okay. And you don't consider that a lot of money?
Yeah, it's a lot of, but it's sure a lot of money, but it's just paying my hourly rate.
So
What's your hourly rate?
on this podcast, well, if you've been practicing law for Mr. Bland for 38 years, you would know that this isn't your opportunity to ask me questions. You talk about cases on this podcast, is that correct?
Yeah, cases and current events and politics and criminal investigations, lots of things.
And you participated on May 18th or May 19th in Cup of Justice episode number 180, which was just a few days after this hearing convened in this case, correct?
You mean the last hearing?
The last hearing on May 15th.
Yeah.
And the purpose of the podcast episode was to discuss the hearing and what happened at the hearing and Ms. Matney's testimony, correct?
I don't think it was the sole purpose, but I assume that was a large portion of it.
And you took place in that, you participated in that discussion, correct?
As a co-host.
That's right. And you're a lawyer. And so when you speak about these issues, you would naturally assume that people know that you have a legal degree and you have legal experience and you're offering legal advice, aren't you?
I'm not offering legal advice at all to anybody. I am just merely stating what the law is, what the rules of procedure are, and what the rules of professional conduct say. I don't offer advice to non-clients.
But you discussed all of that with Ms. Matney while she was a live witness, didn't you?
Not with her, with our audience, but she was a participant, sure.
She was a part of that
I had,
conversation, right?
Ms. Barbier, I have no knowledge of what the admonitions of Judge Kelly were. I was not present. I told you I left at lunch.
So if you had known that Judge Kelly said not to talk to a single soul about your testimony.
Objection, mischaracterization of the court's statements and orders.
Your Honor, I'm asking him whether or not he would have participated in this podcast had he known that you had given her explicit instructions during the break not to speak to a single soul about her testimony.
Your Honor, that was during the lunch break. And then we clarified when we adjourned to continue this hearing to today that your admonition not to talk about Ms. Matney's testimony was in regards to her attorneys.
Let's move along here.
Okay. Mr. Bland, have you in your 38 years ever had a podcast with somebody who's a live witness in a proceeding that had just taken a break on? Have you ever done that before?
No.
It's a little unusual, wouldn't you say?
Well, it's just the way the circumstances work out. I've only been on one podcast.
And so you would agree with me that her talking to you as a lawyer and soliciting advice from other lawyers is a circumvention of the court's order not to discuss this case with your lawyers.
Absolutely not.
You don't think it's unethical and inappropriate and in violation of this court's order to discuss, for Ms. Matney to discuss her testimony with lawyers after she's been told not to?
Her lawyers.
So all other lawyers was okay, in your opinion?
She is in a podcast where she is educating the public to get them better informed about the legal system and about their own rights and their own legal needs.
Well, we'll leave that to the court to decide whether or not she's actually informing them of correct procedures. You have indicated that you talked about your impressions of Mr. James Seidel. Is that right?
Yes.
And you've had a total of one phone call with him. Is that right?
One phone call and the recipient of about 17 different highly offensive postings that he's done about me.
And you're offended because he mocks you and he mocks Ms. Matney. Is that right?
He mocks my client as well.
And you don't like being mocked, and you don't like your client being mocked, do you?
It's not, there's no basis for him to do that. He's injecting himself into something that he has nothing to do with, just in order for him to sell a book.
Mr. Seidel ever told you that he was going to physically harm Miss Matney?
No,
And, and you're not aware of any physical threats that he's made towards Miss Matney, are you?
I am not.
And you indicated that lawyers work together on deposition dates and deposition locations and things of that nature. And are you aware that by the time the Parker defendants deposed Miss Matney, 8 months had gone by when these things were trying to be negotiated and accommodations were made to Miss Matney? Are you aware of that? That it was 8
Objection.
months?
Objection, Your Honor. This mischaracterizes the timing because we had the hearing in November and then the court took it under advisement and did not actually rule on those motions until February. So to characterize this as it was this constant back and forth and Ms. Matney was exercising her rights to appeal and seek a review of your order is a mischaracterization.
I'll ask it in a different way, Your Honor.
Ask it in a different way.
Mr. Bland, do you have personal knowledge of the back and forth that went back and forth between the lawyers for the Parkers and Miss Matney on the accommodations that were being made for her deposition? Do you have any personal knowledge of that?
Some, but not in the granular detail.
Okay. And you understand, having reviewed these subpoenas that I handed you, that the place of her deposition was the law firm of Jones, Simpson and Newton, PA, located at 7 Plantation Park Drive, Bluffton, South Carolina, correct?
That's what you wanted it to be. Yeah, you declared it on this.
That's what the subpoena says, right?
Right. Did you ever pick up the phone call and try to
Mr.
accommodate that?
Bland, did you ever, are you aware of any specific threat at that location?
No, but I am aware that Mr. Seidel had intimated that he was going to show up at the deposition, not at that location or any other location, but he was going to show up at the deposition.
Well, what I asked you was, are you aware of a specific threat at 7 Plantation Park Drive?
Yeah, if that's where the deposition is going to be, a guy that's completely unhinged, a convicted felon who has harassed her, me, and my client, had threatened to show up to a deposition.
And you have no personal knowledge of Mr. Seidel ever being at that location, do you?
I do not.
And you have no personal knowledge of Mr. Seidel ever threatening to harm Miss Matney, do you?
I do not.
Your Honor, may we approach for a moment? I have a matter of law I'd like to ask.
Certainly.
Thank you, Your Honor. I don't have any other questions.
Anything?
Is this Matney motivated by money?
No,
Objection, Your
not
Honor.
my personal observation.
About what she's motivated by.
He was just saying,
Not in my personal dealings with her have I ever heard her mention that she was doing anything for monetary reasons.
has she ever made any indication that she disrespects the court?
No,
Did you have any conversations with her about disregarding court orders?
I told her, listen to your lawyers.
And overall, do you feel like she is disrespectful of our justice system?
No, I think she's done a lot of good in exposing things that need to be corrected.
Thank you.
Just briefly, Your Honor. Mr. Bland, you just said that Ms. Matney told you told Ms. Matney to listen to her lawyers. Did she tell you that her lawyers told her not to appear at the deposition?
No, that we were all concerned about her safety.
Did she convey to you what her lawyer's legal advice was?
She never waived the privilege.
Thank you.
Thank you. Please stand, sir.
Good to see you, Your Honor.
See you back. Do you need to step out?
No, Your Honor, I got it taken care of. Thank you.
Okay. Counsel.
Your Honor, going back to those prior filings by Parker defendants, I understand the court has ruled that they are not coming in, but I would ask to proffer them and mark them as a court's exhibit.
Your Honor, I object relevant to the contempt proceeding. They have nothing to do with why we're here.
Well, let me take a look at them. Of course, the objection is sustained. They're not coming in. Yes.
Nothing further, Your Honor.
Okay. Anything from the defense?
Your Honor, briefly a reply, we called David Moses to the stand.
Sir, if you put your hand on the Bible, raise your right hand, put your left hand. There you go. Swear to tell the truth, the whole truth, and nothing but the truth. Please. Thank you. Have a seat and adjust the microphone to suit yourself. And tell us who you are, please.
My name is David Moses.
Thank you. Counsel.
Thank you, Judge. Mr. Moses, you have been mentioned a couple of times by Ms. Matney as being the one who understands the dollars and the finances of Lunashark Media. Is that correct?
I do my best. Yes, sir.
Objection relevance, Your Honor.
Your Honor, it goes to financial ability to pay.
We aren't there, Your Honor.
We're trying to get through today, so I'm going to be relatively short. Thank you, Judge. All right, so Ms. Matney has described Lunashark Industries or Media as a multi-million-dollar company. Have you heard that?
I did hear that.
Okay. And what is multi-million implies is something more than two. How many is it?
You know, I'd have to check. But what's great about Lunashark Media is that we are able to hire so many people as contractors. So while gross revenues may have reached very significant levels, we do our best to compensate those that work for us in defending the First Amendment and calling out bad actors in the justice system. We expose crime and corruption, and thankfully people find that content, yes, very much interesting. And some people pay us on a monthly basis or a yearly basis. Some people fly across the country to support us with their finances so that we're better able and equipped to accomplish our mission of exposing the truth wherever it leads, giving voice to victims, and getting the story straight. And while gross revenues have been impressive at times, our nets allow us to have, I would say, a comfortable lifestyle, but we're not flying private jets. We don't eat at Sophie's Steakhouse all the time. What we try to do is to honor victims through our reporting and our content. People across the world find that interesting, and they do their best to help us hold others accountable, public agencies, individuals alike. So multi-million dollars, sure, over the course of the last 5 years, but we've also had to pay immense expenses along the way, including this hearing today, on May 15th, on April 7th, on April 8th, private security when deemed necessary.
Okay, so if we wanted to get at what was the net, what would be the documents and where could we find those?
Objection, Your Honor. Relevance.
Your Honor, he's testifying to what their financial situation is. And he's telling me that there are other things that are out there that he needs to be able to answer that question. So I'm asking, where are they? What are they? Because we can subpoena those and get them and make them available to the court.
To parrot their own line, what does this have to do with Ms. Matney's contempt?
Because it goes to ability to pay, Judge, which is one of the three things that are part of a rule to show cause. What's the other reasons that she didn't show up? And do they have financial ability to pay? Because ultimately you're going to have to decide if there was a contempt, and then how much are you going to fine or hold them in contempt for? Overruled.
Your Honor, I'm also objecting to what sounds like a fishing expedition for documents. Again, non-party. What would be the purpose for this?
Well, I don't need a fishing expedition if he'll just answer the question.
And remind me your question, sir.
I just asked you, I said, you've been described as a multi-million-dollar media company, and I wanted to know how many millions we're talking about. That implies more than two. Is there a number you can put on that?
Objection, that's actually a different question than what he had asked.
No, it's not.
I know that our personal income is not in the millions of dollars.
Permission to approach, Your Honor.
Yes. Counsel.
Your Honor, thank you. Based on court's indication from the sidebar that ability to pay will be something that we will reserve until after there is a formal finding of contempt, then we will simply reserve our position on that, and I don't have any further questions for Mr. Moses.
Thank you. Anything from opposing counsel? Thank you. Sir, you may leave the stand. Anything else?
I have some closing remarks.
Okay, I'm happy to hear from, let's start over here.
Thank you, Your Honor, but I think this has been very unique and unusual. And a lot of it is some overarching background that the defendants Parker desperately want to keep out. However, I think we need to recognize that Ms. Matney is world renowned as being a fierce investigative reporter who not only uncovered corruption and misdeeds within South Carolina, but the system as whole. She has experienced over the last 6 years nothing but harassment and anger for her asking questions and exerting her rights. Sometimes people don't do what we want to say, don't do what we want them to do. Sometimes people don't react how we want them to. However, that does not mean we can then punish them for exerting their rights. Here in this case, there was a subpoena which, under Ms. Matney's rights, she rightfully sought to quash. We exercised those rights here in this very same courthouse in November. Your Honor took it under advisement and ruled in February, and then, as required, per the rules of civil procedure and Ms. Matney's rights, she asked for a motion to reconsider to allow for an appeal of Your Honor's decision. So the actual time between when the court ordered the deposition to happen and when the deposition was to occur by was a matter of about 3 weeks maximum. I have been Ms. Matney's attorney for years, multiple times. As defense counsel has pointed out, I have served as the registered agent for various entities related to the Matneys. On their social media, I am also featured. And yet at no point was I allowed or did Parker's defendants reach out to me as co-counsel. The first time Mr. Moore spoke to me was during the failed attempt on March 27th, at which point I was just like, guys, why aren't you just coming and getting this testimony? What's wrong with my office? And it was responded with, I'm not talking to you. There has been a repeated pattern of harassment and annoyance because Ms. Matney isn't doing what they want. Throughout the evidence of Ms. Lyons' deposition, which occurred 23 days prior to Ms. Matney's set deposition, it is clear that defendant Parker's is willing to change the time, the location, and the manner of the deposition as set forth in the court document. As Your Honor is aware, civil subpoenas are different than criminal in that civil subpoenas allow the court officer and the attorney to issue them on behalf of the court. Whereas a criminal, you must seek the clerk of court's approval. In this instance, there was no effort by defendant Parker to actually touch base, collaborate, or even copy one half of Ms. Matney's attorney's team on any of the emails or discussions involving setting the case. Ms. Matney is not a party to any of these litigations and frankly just wants to be done in a way from all of the madness that has pursued her for the last 6 years. She offered as a non-party witness her own attorney's office in which she stated, "We are also friends, and so it is a comfortable location to do it." As your honor can see through the various subpoenas, that the time was unilaterally changed by defendant Parkers. From the first 2 subpoenas, they then unilaterally changed the time from 10 o'clock to 9 o'clock, which indicates there was some effort and ability by defendant Parkers to change and negotiate things with the subpoenas as they go. Your honor's order also stating that we were to take the deposition within 14 days was dated March 17th, I believe. That is the bulk of the order, which said in 14 days. When communications broke down with one of the attorneys, the other attorney was not communicated with, reached out, or anything, and failing to be able to reach a resolution, we did seek the court's guidance because we were very concerned about Ms. Matney's safety. And I understand we had not put that in court documents because, as your honor is aware, a lot of times you negotiate the big things and then you get down to the smaller things in negotiation. With everyone's busy calendars, there's so many plaintiffs and defendants and co-defendants and various attorneys. Coordinating the dates was the most important thing. And once we got that is when we turned to discuss the location. As discussed, my office is self-contained. We had security and we had all of the parties present. It is odd to me that such professional and esteemed attorneys would refuse to walk half a mile, drive half a mile. I even joked we could meet at the Dairy Queen that's in between our 2 offices to get the information that they wanted so desperately from Ms. Matney. Ms. Matney has experienced ongoing online harassment. We saw on April 7th the profound impact it has had on her, but also throughout this entire process, it's been a turning of the screws. And through Callie Lyons' deposition, we see that Mr. Seidel, the main proponent of this harassment, is working in conjunction with Ms. Lyons and assisted in brokering the sale of the text messages to Parker's defendants. This is all background knowledge and knowledge of all the players and how everything is playing out. It should also be noted that although everyone's saying Murdaugh doesn't matter, it does. Ms. Barbier was Corey Fleming, Alec Murdaugh's co-conspirators, defense counsel, and Mr. Moore was Russell Lafitte, the banker's defense counsel as well. Ms. Matney played a very vital and key role in uncovering all the malfeasance. Having that basis and knowledge and working with everyone only goes to color it. So having these events set into motion that may or may not be fueled or pushed by the defendant who is issuing this court order does nothing but psychologically harass and make it an impossibility for Ms. Matney to actually have attended and come. Further, the standard for the rule to show cause and contempt, we would renew that the lack of the affidavit should make the motion fail completely. Further, the standard at which contempt must be proven is not merely that she did not show up, but rather it's done voluntarily and intentionally with the specific intent to do something the law forbids, or with the specific intent to fail to do something the law requires to be done. That is to say, with bad purpose, either to disobey or disregard the law. That's from Spartanburg County Department of Social Services versus Paget, as cited by defendant Parker's in their prior motions. Here, we have not shown any actual intent to do something that the law forbid or to fail to do something that the law required to be done with a bad purpose to disobey or disregard. Ms. Matney was available. She made herself available for a longer period of time than the Parker's defendants asked to be available. The timing of the social media post from Mr. Seidel and the days leading up to the deposition, as well as the day of the deposition, indicate that it's a reasonable fear that was designed to psychologically torture Ms. Matney to the point she was unable to attend. The fact that the 14 days on the order did not expire on the 27th, but rather ran through the following week, and we'd made efforts suggesting any office all over the Carolinas, as well as a courthouse, we were immediately swatted down. And the secure location defendant Parker's is talking about is their law firm in Columbia, which again goes to the unlawful burden of why should Ms. Matney have had to drive to Columbia, going to the law firm of two people who defended some of the most notorious criminals in South Carolina. Further, no payment for the subpoena, as defendant Parker's indicated they would do, ever came. Ms. Matney, once the court told us on April 8th, we're doing it here at the courthouse, no problem. We never once had to come get your honor to consult as to any objections or anything concerning noncompliance. The whole issue about social media and the postings is a red herring, Your Honor, because as Your Honor is aware, everyone has an opinion. We can't control it. And we all have a duty to rise above it as officers of the court. And as you have frequently cited under your judicial ethics. And it is a lot of noise that doesn't actually go to the reason of why Ms. Matney was not present at the subpoenaed location on that day. It is a reasonable fear, and Ms. Matney's whole brand and driving motto is to bring truth out into the sunlight. Her opinions and memes and all the social media are just that. It's her living her life and stating what she feels and believes as an opinion. And one of the beautiful things about our country and our Constitution is under the First Amendment, we are free to express our opinions. And her subsequent social media posts have no impact on what is actually occurring. The fact that there have been no physical threats in the sense of a man lurking out in the bushes of her house should shock the court that that is the standard by which we are judging harassment and fear and reasonableness. Ms. Matney stated she was unable to drive for 4 years. I remember the day she drove to the grocery store because it was such a big deal. This is fear. This is law enforcement telling her there's certain counties she can't go in the state. However, she is a free person who is allowed to live her life. And if that doesn't comport with how Parker defendants feel that someone who is legitimately scared should present, I think that's more of a Parker defendant issue than a Mandy Matney issue. because throughout the entire time with all the negotiations and back and forth discussions, anything we have raised or said to opposing counsel has been waved away and no, that's not normal. This isn't a normal case. But Ms. Matney has nothing to do with this case. She is just a young girl trying to expose crime and corruption, live her life, and shine sunlight on the truth. She respects this court, she honors this court, and we ask that you do not hold her in contempt. Thank you.
Thank you.
Your Honor, is Ms. Lindell, making the marks because they said that they both wanted to, so.
No, that was.
So I know Ms. Matney would like me to talk about it briefly, just briefly. Your Honor, I will promise to be brief. And we have previously briefed this issue on undue burden. And we've cited Rule 45 in our prior briefing. And Your Honor, just to remind the court, which I know you're very well familiar with, but Rule 45, Your Honor, imposes an obligation on the party issuing a subpoena to a non-party witness. It says that they shall minimize the undue burden to the non-party recipient of a Rule 45 subpoena. And here, rather than reducing the burden and expense of complying with the subpoena to Ms. Matney, it appears from any objective observer that they have taken every step possible to increase the burden and expense on Ms. Matney. And Your Honor, I would just point, in addition to the cases that we've already cited, which I don't plan on reiterating here because I know that Your Honor has read the briefs that we've submitted, but I think it's critical to remember, Your Honor, that in addition to the monetary burden and the time burden, which I will discuss, undue burden doesn't take one particular form. It can include, for example, the burden of having to reveal confidential information, the burden of intrusion on someone's privacy. And the Fourth Circuit, which employs a similar standard to South Carolina, has, and there are more cases in the federal court system, but it includes the undue burden language as well. Those cases are clear that it's not a one-size-fits-all analysis of undue burden, and that there are various factors that are case-specific that the court is to look to and look at to determine whether a third-party witness was in fact exposed to undue burden. And I would point, Your Honor, to a Fourth Circuit case decided in 2019, Virginia Department of Corrections versus Jordan, 921 F3D 180 at Penn site 189 to 190. And that's the case that evaluates different types of undue burden, including the privacy or confidentiality interests of a third-party subpoena recipient. And here, in addition to the time and expense that Ms. Matney has been required to endure, there's also been an emotional burden on Ms. Matney. As has been highlighted through testimony and prior argument, Ms. Matney, as a direct result of the newsworthy information on the public index that she was being deposed in this case and had filed various motions, which she's entitled to do. And I don't think anyone disputes that filing a motion to quash and filing a motion for reconsideration is exercising her right under the rule that the rule gives to her. So there's nothing wrong. She shouldn't be punished for filing those motions. But as a result of that, the exposure and the newsworthiness of the fact that Ms. Matney was hauled into this court, numerous times. She's been exposed to significant emotional duress and harassment online. And I won't reiterate it line by line, but the testimony has been clear that Ms. Matney has suffered. She's been the recipient of social media posts, including, some posts that we attempted to offer into evidence and that the court has reviewed. So I believe they would be a part of the record on appeal. But posts, for example, from Mr. Seidel, whose name has been used throughout these proceedings, indicating that he would attend her deposition in person. He later backtracked on that after he clearly reviewed what had been filed on the public index in this case and said, oh, I was just joking, clearly. But Ms. Matney is entitled to take such threats seriously and believe that they're true. The day before her March 27th scheduled deposition, Mr. Seidel was posting signs of the Welcome to Bluffton sign. And we recognize that it's possible that he was not actually in Bluffton, but the clear intent of that post is to indicate through social media that he is watching and he is there and he is physically or emotionally imposing himself into the lives of Ms. Matney and her counsel for the purpose of intimidating or mocking or threatening or however you want to describe it, but imposing an undue emotional and stress and privacy burden on Ms. Matney. So we would ask that the court consider that testimony in the light that it was and the proposed exhibits that were proffered to the court in the light that they were intended to be used in these proceedings, which is to say, Ms. Matney has, she's been the recipient of, for example, TikToks where this man is lip syncing himself singing the Barry Manilow song Mandy. She has been, as it came up in the testimony of Mr. Bland, among others, she's been body shamed by members of this bar, and not anyone at this table, to be clear, but has been body shamed by members of this bar for her appearances in this very before your honor. I mean, people were taking photos of her and just saying truly cruel things. And that all could have been minimized had the Parker defendants met their obligations under Rule 45 to minimize the undue burden on Ms. Matney for complying with, which she did, she was deposed, for complying with the Rule 45 subpoena that they caused to be issued on her towards the close of discovery in this case. Your Honor, one additional case that I'll note that I think is relevant to what's come up today is a District of South Carolina case, and it is unpublished, so I'll read the Westlaw site into the record, but the case of Wellen versus Wellen, 2016 Westlaw 7613663. That's District of South Carolina, July 1, 2016. That also involved a third-party subpoena. And in that case, Your Honor, the court indicated that parties are encouraged to meet and confer about third-party deposition subpoenas here. And although it's not stated exactly this way in that opinion, and by the way, Your Honor, that was reversed on other grounds. The comments related to meeting and conferring remain good law. But the purpose of meeting and conferring in advance of deposition notices of a third-party subpoena is to minimize the undue burden in whatever form that burden takes, whether it be emotional, safety concerns, confidentiality issues, financial, interruption from work. It's abundantly clear from the record that Ms. Matney is with her husband self-employed. The entirety of their household finances comes from the successful and timely posting of broadcast of podcasts that Lunashark's listeners have come to expect to be posted on and broadcast on a particular schedule. And I recognize that, I'm here as an advocate for Ms. Matney, but looking at the timeline of when depositions were suggested or when hearings were suggested, one of the patterns that emerges is that it is frequently the case that Ms. Matney is compelled to come to court or sought to be deposed on days when it is known are writing and publishing days for her. So this has been a significant intrusion on her personal and household finances. And to go back to, and I'm almost done, but to go back to the sort of more traditional view of what an undue burden and expense looks like, it looks like the out-of-pocket cost that a third-party witness who did not invite themselves, I don't want to overuse the word party, but Ms. Matney didn't invite herself to this party. She was hauled into it. And that's, the typical sense where undue burden comes in is expense. And typically when cases look at it, they look at things like how much would it cost to print out your bank records or whatever. We know from deposition testimony that's previously in the record, including the deposition of Ms. Lyons, that other witnesses were compensated for their time to comply with the subpoena. Ms. Matney was, as Ms. Bannon noted, told flatly no, and also has not even been paid the required witness fee to appear. But in addition to that, Your Honor, Ms. Matney was deposed on April 8th. She indicated numerous times that she was available on other dates and other locations other than March 27th. And I think there was a reference made to counsel's schedule. I do want to be clear, Your Honor. One of those conflicts was me, because I got ordered to appear in federal court on a day that we had initially made available. Unfortunately, as much as I wish there was something I could do about the ability of federal judges to tell me where to be and when, as we all know, that is quite limited, if there is any ability at all to fuss at them. But in any event, since her deposition, since she indicated that she was willing to appear at a neutral location or at her own counsel's office in Bluffton, as long as she didn't have to expend her own funds to do so, Ms. Matney has had to drive all the way across this state on numerous occasions. She appeared on April 7th. She stayed overnight on April 7th. She stayed all day on April 8th to be deposed. She drove across the state for the May 15th hearing, which required an overnight stay, or at least one, maybe 2 nights. And then she also drove here today, which required an overnight stay last night. For each of those trips, we're talking about a travel burden on Ms. Mandy of approximately 800 miles, hotel stays for Ms. Matney and her counsel, and the additional incidentals that come along with having to travel away from your home many hours, 4 hours away from your home. She has been made to bear all of those expenses as a third-party witness. And we haven't, as we've mentioned in a sidebar, we haven't seen any sort of indication of what the specific attorney's fees are that the Parker defendants are seeking. But at every hearing, there have been 4 partners here on behalf of the Parker defendants. I don't think I'm speaking out of school when I say that Ms. Bannon and I both are representing Ms. Matney at a greatly reduced rate, if at all. But so her attorney's fees have been minimized to the extent that we can. But the real out-of-pocket financial cost of having to travel 800 miles each way every time we've had a hearing in this part of the state versus the low country where Ms. Matney lives, the overnight stays, the private security that we've hired, and we do have private security here today, the changes of clothes she's had to purchase for unexpected overnight stays when she was deposed, and also the lost work opportunities for the days where she's been made to appear in court when she really should be using that time to generate revenue through Lunashark for its intended purpose of covering other cases, in addition to, continuing its mission, its original mission of covering some of the corruption that is well known in South Carolina with respect to prior court cases. So, Your Honor, we do contend that this type of burden is not just undue. It's not unduly burdensome. It is extraordinarily burdensome. It's like unlike anything I've ever seen in the 20 years of practicing law. So we would ask that this court decline to award any fees to the Parker defendants, because Ms. Matney has had to bear expenses already, and that should be enough. Let me pause and see if anyone wants me to add. Thank you, Your Honor. I appreciate the time.
Thank you. Yes, ma'am.
May it please support, Your Honor. Your Honor, the matter before you today is about something very simple. It's very simple, but it's very fundamental in our system of justice. It's about respect for the rule of law and respect for the authority of this court. It's about whether a witness may knowingly refuse to comply with a lawful subpoena and a direct order from this court simply because she disagrees with it. It's about how this court is going to address the fact that while knowingly defying a court order, Ms. Matney has told half-truths and created false narratives for her podcast and her social media platforms. And in every false narrative that she contrives, she is the hero and she is the victim. She masquerades the false narrative as journalism for the purpose of attacking this court, for attacking the officers of this court and our justice system. As demonstrated by her own testimony and her own business model, she does all of this to make money. Controversy and content drive clicks, and clicks generate cash. And now let me be clear. Ms. Matney is free to criticize anyone she wants outside this courtroom within the bounds of the law. That's the First Amendment. She's free to do what she wants, wear what she wants, post what she wants within the bounds of the law. And although she's created a spectacle of herself, this case is not about her. The evidence before this court establishes overwhelmingly that Ms. Matney's refusal to attend her deposition was willful. The first subpoena that she received for her deposition was on October 14th of 2025. Ms. Bannon and Ms. Lindell speak about the fact that people weren't willing to accommodate. There were meet and confers galore. There were multiple attempts to accommodate her schedule, accommodate her counsel schedule, accommodate the location, accommodate all of that. And the only reason that her deposition has been taken in this case 8 months later is because this court ordered her to take it on April 8th at the Spartanburg County Courthouse. Her refusal to attend her deposition on March 27th was willful, it was deliberate, it was calculated, and it was contemptuous. She knew exactly what this court ordered, and the record is very clear on that. She admitted it on April 7th on the witness stand. She knew her motion to quash had been denied. She knew the motion to reconsider had been denied. She knew the court ordered her deposition to take place within 14 days. She knew that the March 27th subpoena required her appearance at the noticed location. And critically, she knew that her emergency motion had not been granted, but she refused to appear anyway. There's not confusion here. There's no ambiguity, and there is no misunderstanding. This was not an accident. It was a conscious decision to ignore the authority of this court. And the evidence shows it was not merely noncompliance, it was defiance. On February 5th, 7 weeks before the deposition was supposed to take place, and before any safety concern was ever discussed or raised by Ms. Matney, she posted on social media that she would rather go to jail than comply with the subpoena. And for months, Ms. Matney never objected to the deposition location. The same Bluffton location appeared repeatedly in subpoena after subpoena, beginning in October of 2025. Yet only days before the deposition, after every other effort to avoid the deposition had failed, she suddenly asserted safety concerns. And even then, even on April 7th, when she testified, she could not articulate one specific threat tied to that location. And at the evidentiary hearing, when she was asked repeatedly to identify a concrete safety concern about the law office where the deposition was to occur, she could not do so. Instead, she spoke in vague generalities about distrust and fear. And while claiming she was too fearful to comply with a court-ordered deposition at a law office, her own conduct reveals something very different. She traveled publicly without security. She socialized publicly without security. She dined publicly. She posted selfies publicly. She walked public streets in Savannah with her lawyers. She promoted her podcasts. She promoted travel programming. She advertises upcoming public appearances, and she encouraged supporters to crowd the courthouse for today's hearing, for the hearing before this on May 15th. She publicly promoted the very hearing at issue in this matter. And perhaps most tellingly, on the day that she refused to comply with the deposition subpoena, she publicly celebrated what she believed was her victory over the process. That's in evidence, Your Honor, can see the social media post of her and her lawyers out celebrating that she didn't comply with the subpoena. That's not the conduct of somebody who's incapacitated by fear. That's the conduct of someone who believed the rules did not apply to her. And unfortunately, the contempt did not stop with her refusal to appear. Following the hearing, Ms. Matney and her associates launched a coordinated public campaign attacking legitimacy of these proceedings, attacking counsel, mocking the court, and encouraging public outrage against the judicial process itself. The court has seen the exhibits, the repeated accusations of corruption, the repeated assertions that our legal system is evil, the repeated public claims that she was ambushed, harassed, and berated, the efforts to portray lawful discovery as persecution. The social media campaign built around harassing and defaming the lawyers in this court. The public references to Judge R. Kelly, which Ms. Farrell later admitted was intending as a joke, comparing this court to a convicted sex offender. And all of this occurred while Ms. Matney simultaneously monetized this controversy through podcasts, premium subscriptions, sponsorships, and merchandise promotions. Ms. Matney walked out of this courthouse on May 15th, and the first thing she did was start after the court had clearly instructed her not to discuss her testimony and not to discuss her testimony with her lawyers. She went out and participated in a podcast about this hearing and about her testimony and complaining to the public about these proceedings. So, Your Honor, this matter is far more, it's much larger than this dispute. Courts do not possess armies. They do not function through force. The judicial system functions because the public has confidence that the law applies equally to everyone and that court orders must be obeyed, whether we like them or not. The rule of law depends on the principle that no person, regardless of their profession, their platform, their popularity, their wealth, their followers, or their public influence, gets to decide which orders they will obey and which orders they will ignore. If litigants and witnesses are permitted to openly defy court orders and then publicly recast themselves as victims of oppression and corruption and persecution simply because the court ruled against them, the confidence in the judicial system erodes. That is precisely why contempt powers exist. Not to punish criticism, not to silence disagreement, but to protect the integrity of the judicial process and to ensure that every citizen understands the same rules apply equally to all. Ms. Matney did not merely disagree with the court's rulings. She constructed and amplified a false public narrative that she was somehow exempt from compliance because she believed the process was unfair. She portrayed routine civil discovery as abuse. She portrayed lawful court orders as harassment. And she encouraged thousands of followers to distrust these proceedings based on distortions of what actually occurred. That is dangerous to public confidence in the administration of justice. Because if public figures are allowed to ignore lawful orders while telling the public that compliance is optional when someone feels aggrieved, then respect for our courts and ultimately the rule of law is undermined. Ms. Matney had remedies available to her. She filed motions.
She sought reconsideration. She sought emergency relief. And this court ruled. And at that point, her obligation was clear. Comply first, argue later. Instead, she chose self-help. She chose defiance. She chose to substitute her own judgment for the authority of this court. And she did so willfully and knowingly. And as a result, the Parkers defendants and their counsel incurred substantial fees and costs because of that decision, because of the decision that she made back in October of 2025 that she was not going to cooperate or comply with this deposition. We repeatedly had to prepare for depositions that didn't occur. We had to respond to baseless motions and motions to reconsider and emergency motions. We had to respond to letters re-arguing the same points that Ms. Matney litigated and lost. We had to pay for hotels and court reporters and videographers. We appeared at the notice location, and we had to prepare and litigate this rule to show cause, which she has unnecessarily prolonged and profited from. And those expenses were not caused by a misunderstanding. They were caused by deliberate disobedience, motivated by profits, and a quest to increase her celebrity status. The expenses that Ms. Bannon complains of, that Ms. Matney has incurred, were all brought upon by herself. She made those decisions, and that's why she incurred those expenses. So, Your Honor, accordingly, the Parkers defendants respectfully request that the court hold Ms. Matney in contempt, impose an appropriate monetary sanction sufficient to vindicate the authority of this court, award attorney's fees and costs incurred as a result of her failure to comply with court orders, and make unmistakably clear that court orders are not optional suggestions to be obeyed only when convenient, profitable, or politically advantageous. Because the public must know, and litigants must know, that the rules apply to everyone equally. There are no exceptions, not for lawyers, not for corporations, not for podcasters, not for influencers, not for anyone. Thank you.
Thank you.
I make it a practice not to object during people's closings, particularly when there's not a jury present. But there are at least two objections I would have made if I can just make them for the purpose of the record. I'll be very brief.
Okay.
Thank you, Your Honor. And actually, 3 points, Your Honor, and I will be very brief. First of all, there was earlier when Ms. Matney was on cross, I don't have the exhibit number in front of me, but there was an exhibit that was passed up that included a number of links to podcasts that Ms. Matney has published related to this deposition. And one of the links was to True Sunlight episode 152, which was broadcast on and published on June 11th of 2026. Ms. Barbier just argued during her closing, and she also asked Ms. Matney some questions about that podcast, indicating that Ms. Matney was asking for legal advice with respect to her testimony. The transcript itself was not admitted, but the link to it was. And so my objection, Your Honor, would have been that when the transcript is reviewed, Ms. Matney, and I apologize, there's no pagination on the Apple transcripts, but I believe they're searchable. When the transcript is reviewed, Ms. Matney is saying that she refers to the argument with respect to the affidavit, and she says, if there are some rules we don't know about, if this is a different game we're supposed to be playing here, we have the right to know that. Instead, Your Honor, moved on. She's referring to the objection about the affidavit, the fatal flaw. And then she says, and please, if you are a South Carolina lawyer with knowledge about this issue specifically, please reach out. So she did not invite any advice about her testimony, nor did any of her counsel, nor Mr. Bland. There's been no testimony that either Mr. Bland, Ms. Bannon, or I talked with her about her testimony at all, which is related to the other objection I would have made, Your Honor. One of the exhibits, I believe it was a court exhibit, probably, I don't know what we numbered them, Court Exhibit 1 probably, which was the transcript of the May 15th hearing. During her closing and during questioning, Ms. Barbier asked Ms. Matney questions about Ms. Matney not telling and not talking to a soul about her testimony. And I believe that's on or about page 86 or 87 of the transcript. To be clear, Your Honor, that comment was made with respect to the lunch break. And at the end of the hearing, there was, I believe it's around page 103 of the transcript. Ms. Matney's counsel, Ms. Bannon, and I were very clear to get a ruling from Your Honor that Ms. Matney was not to discuss her testimony with her lawyers. That was the court's instruction. The prior quote that has been continuously relied on today relates to the lunch break, not to the multi-week break that we've been in since May 15th. And there's been no evidence whatsoever that admonition by the court was violated by anyone. And then, Your Honor, finally, the other objection that I would have made, Ms. Matney testified that she has actually lost money as a result of these proceedings because she has not been able to publish on schedule, including the fact that this week alone, there are 2 podcasts that she will not be able to publish on the typical schedule. So the argument that Ms. Matney has made money from this, in our view, needless exercise promulgated by the Parker defendants is contrary to the evidence, and I would have objected on that basis. But that's all I have, Your Honor. I will send that.
Yes, Your Honor.
Because I've read that. The transcript of that hearing was introduced at the York County Courthouse, Moss Judicial Center. This court took live testimony. No affidavit was needed. Live testimony as to whether or not this court should issue the rule to show cause. But I just want to address that because when we went to lunch, when AJ and I went to lunch, I said, didn't I understand that I did this? And he said, yes, sir, he did.
Thank you for that clarification, Your Honor. We did make that argument and reserve that appellate argument for the record.
Sure.
And not a criticism at all of the court, but from reviewing the transcript, it was not entirely clear, which is why it has been raised. But we appreciate the offer that Your Honor is providing clarity now. And I believe that we have properly preserved that issue for review if necessary.
And you should. All lawyers should protect yourselves.
Thank you, Your Honor.
Okay. Anything else from anyone else before we adjourn? It's going to be under advisement.
The lawyers, not Ms. Mandy, but the lawyers in the case approach an issue with, I think I applied.
Sure.
Okay.
Well, come on up because I wasn't here.
But I wanted to raise it. We need to address it before we go.
Okay, well, I'll tell you what, it's time for a break here. I promised Madam Court Reporter I would not go too awful long, and we've been about 15 minutes over. So I'll tell you what, let's take a good 20-minute break here and go back in the jury room. We'll talk about whatever it is. But again, I wasn't here last week. And I don't know if the audience knows, but the Spartanburg County internet system is down since June 10. Since June 10, we can't see files. We can't do a lot of things. Okay, we'll gather up in the jury room. Yeah, just for a few minutes. I don't know.